with very good all India ranking.
Huh.
He has been called for state level counseling scheduled to start on 13th of August. Now, at the time of state level counseling, he needs to produce the domicile certificate. Long back, he has applied for domicile certificate. The problem he is facing that his EPIC has been cancelled in this SIR. Now he has preferred appeal. He belongs to district Murshidabad. More than 6 lakhs appeal is pending for district Murshidabad, my lord. Now, since the appeal is pending, the SDO concerned is not handing over the domicile certificate, stating that he will not hand over. But there is no central.
His name is deleted.
Yes, he has preferred appeal also, my lord. On
When he
30th,
has prepared an appeal.
second week of July.
Second week of July he has prepared an appeal.
No. Appeal is pending since April, my lord. After deletion, he has preferred appeal. He applied for domicile certificate in the 2nd of July after the NEET result.
उसको ले लो कल रख दो. You are moving, new moving.
Yes, my lord.
My lord, I am paying my
leave, my lord.
My lord, I am
Leave is granted. Serve the notice. List tomorrow.
My lord,
In the
the new petitioner is the meet aspirant, your lordship.
I will not hear anybody. If all will mentioning together.
My lord, this is my. I am paying leave. My lord, SIR matter. My lord, his pharmacist. My lord, his pharmacy license is not being renewed. That is why his profession is being.
File it every day. I am taking. File it in the department. Every day I am taking 100 matter of SIR. I will take. No mentioning. I accepted because of the education. Pharmacy license, you file in the department, automatically file will come, it will be listed. No mentioning with regard to the SIR matter. If I receive any SIR application, I will not allow any of the SIR matter. Every day I am listing the SIR matter 100 to 150. I will not allow any of the SIR matter in mentioning. If any SIR mentioning list, I will dismiss the application.
Well, this is very urgent.
Whatever the urgency, give the urgency matter.
Mentioning for
Mentioning list.
SDO is not giving the domicile certificate. Very urgent, my lord. Diamond SDO is not giving the domicile certificate, my lord. He is a qualified student. Passport.
My lord, kindly, my lord, that yesterday, my lord, my lord, in morning, my lord has given. Yes, call the list. My lord, that has given.
Lordship, kindly allow me to mention, Lordship.
Clear, my lord. My lord, I have seen it clear, my lord. Kindly let me suffer. The petitioner is the NEET aspirant. My lord, the petitioner did not getting the his domicile certificate. And my lord, 13 is the counseling date. There is a very short time. My lord, kindly grant leave. My lord, otherwise student will suffer. My lord. Live streaming. My lord, kindly, my lord. Live streaming बंद करो. Kindly grant leave. My lord. Record now. My lord, that matter counsel appearing for the CWC has prayed for
item number 2, my lord. হয়ে গেছে ভাই।
Item number 2, I have accepted for the petition.
yes. Who is the item number 2?
ভাই মিউজ ওভার হয়ে গেছে, ডোন্ট
For correction, I have mentioned twice.
You have given the list.
I have given it.
That's all.
Thursday,
Have you given the list or not?
I have given.
That's all. Yes. Who is item number 2?
For the petition.
my lord.
Yes.
এটা তো ওই ঘরে ছিল,
হ্যাঁ, এখানে ভুল করে লিস্টিং হয়ে অর্ডার
1 তারিখে অর্ডার হয়েছে, আপনারা অ্যাপিয়ার করুন।
কেউই অ্যাপিয়ার
আমরা কি করব?
এটা এটা ইলেকশন কমিশন ম্যাটার আছে, ম্যাটার আছে নেই তো কি the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. The counsel for the petitioner draw the attention of this court that by an order dated 1st of August 2026, this court has passed an order by disposing of the present date application by directing the appellate tribunal to consider and dispose of the appeal filed by the petitioner as early as possible within a period of 3 months. Then counsel for the petitioner, the writ petition being WPA number 13352 of 2026 within bracket Manju Jha and another versus Union of India and others is not related to the election, not related to the SIR appeal, but inadvertently the order has been recorded in WPA number 13352 of 2026. This court has considered the WPA number 3552 of 2026 and after going through the record, this court find that the order has been wrongly recorded. Order dated 1st of August 2020 is wrongly recorded in WPA number 13352 of 2026 within bracket Manju Jha and another versus Union of India and others. In view of the above, the order dated 1st August 2026 passed in WPA number 13352 of 2026 is recalled. Is hereby recalled. ठीक है? The department is directed to place the record of this writ petition before the appropriate court having determination.
I'm deeply obliged, man.
Yes. As the order has been the order dated 1st August 2026 is recalled, accordingly department is directed to rectify in the website not to show the matter as disposed of.
My lord,
Yes, you the call the next matter.
my lord, I beg to appear for the petitioners, my lord. My lord, these are my affidavit of service, my lord.
The order is not corrected, sir. The order was given back in May. Lord, I have mentioned twice, Lord, I have given the corrected copy of the order. Lord, the order is now being flouted, Lord, the amount has not been mentioned, Lord, we need to correct it. Lord, kindly allow it.
My lord, I am for the petitioner.
Yes, who is for
My lord, yesterday, after yesterday's hearing, my lord, I cross-checked it. My lord, though it's a matter of forest, but your lordship has the determination, my lord.
how
My
it
lord,
is?
because I am not challenging the acquisition proceeding which will fall under group 1. My lord, my prayer is that there
Okay.
is a,
Appellate side, appellate side.
my lord.
No, schedule ka schedule.
পরে যেদিন হবে, হ্যাঁ।
or IL by the kindly, I mean, if you lordships may please to my lord that is on the release, my lord, otherwise.
I know that. रोज बोलता है, ठीक करो इसको हटाओ ना,
हटा देता है।
ये ऊपर से ये हटाओ, इतना हटाओ ना, ऐसे नहीं है, हाँ यार, you are having the appellate schedules.
The appellate side rules. Well, it is in the monthly. No, why can I? No, I'm not. Antya.
Come tomorrow, not today.
Then instead of tomorrow, my lord, can I come back on Monday, my lord?
Not today. Come tomorrow. আমি দেখছি, আমি রেকর্ড করতে হবে না। আইটা নাম্বার
এখানে একটু স্লিপ গুলো দিয়ে দাও না।
That basic
yes
point would be whether the direction of a constitutional authority can be ignored by a sub-constitutional authority. Let the problem was what the petitioners were deployed by the Election Commission for a considerable period of time. And ultimately their service career would have been affected because they would not be able to collect the insurance policies during the time. And my lords were kind enough to direct the Election Commission to vent his views. Kindly takes up the supplementary affidavit filed by the
তোমারই filed by you.
who is appearing for the insurance?
Your Lordship, I had informed the learned advocate who appears. কালকে বলেছিলেন, আমি ইনফর্ম করে দিই।
I am told pursuant to my lord's desire, the other side has been informed, but they are not responding to it. Kindly takes up the supplementary affidavit filed on 23rd of March 2026.
Supplementary affidavit.
The Election Commission.
Supplementary affidavit. When you filed? Yes, yes. Yes.
Kindly now turn to page 6 of the said affidavit.
Yes.
Paragraph 2. Entitled National Affairs so and in pursuance of the order dated mentioned above, the Commission desires that the concerned authority of LIC may be advised that no adverse action should be taken against those LIC officers who are deployed in SIR duties for their being absent in their substantive work due to the said deployment. But this should be honored. This is sovereign duty. Now they want to really avoid these directions and put us in such a situation which have ultimate effect on my service career.
Where they have given any further notice?
Their order is at page 7. They say that recently in many places, page 7, the development officers have been deputed for the special intensive revision electoral rolls and also in the legislative assembly so and so. I'm just skipping over the unnecessary details. In case this period of SIR duty spread over 2 appraisal years, then these provisions will be applicable not for appraisal years during which the period of duty is minimum 30 days at a stretch. The concerned developer will have an option either to choose the regular appraisal period of 12 months or an extension of the appraisal year in the following manner. This extension would ultimately put me always a cumulative effect for the entire career. But this is also some sort of penalty. The actual number of days spent on such election duty, which will be at least 30 days at a stretch, shall be added to the relevant appraisal ending date, and the last date of the month during which the extension ends will be the revised appraisal month.
Yes.
Then the development officer, item 4, may opt for lesser number of months extension instead of maximum extension period, which may be allowed depending on the number of days of election duty. If opted for extension, relevant appraisal years, developers will have to submit the request in writing. But I'm not troubling my lord with that. My basic point is, my lord, no action which will have ultimate impact on my service career be taken by the LIC. That is the specific direction by the Election Commission.
The actual number of spent on duty is such election duty, which be at least 30 days, that is, shall be added to the appraisal ending date and the last date of the month during the extension and will be revised appraisal month. Will be the revised appraisal month. Option either to choose the regular appraisal. Yes.
Now, will kindly come to paragraph 4 onwards. I have detailed out not how this LIC circular will ultimately affect my career. Paragraph 4, that the improved circular dated 12th March issued by LIC is expressly colorable in nature inasmuch as the relief which the LIC is directing the general manager to provide to the development officers falls under the ambit of minor penalties.
Where from you are reading?
Supplement affidavit paragraph 4.
That's why I want to hear the LIC. They are not
Lordship wanted below the presence of LIC counsel
I have informed him
and
again.
also at below.
No, I am issuing the warrant. Nothing.
Yes.
If they are doing like this and they are not appearing, then what can be done?
That the general manager may be directed to present it.
In spite of service of notice and in spite of several intimation given to the respondent number 5, none appears on behalf of the respondent number 5.
Right.
Accordingly, the general manager, Life Insurance Corporation, having its office at Yoga Keshma, Jeevan Bima Mark, Mumbai. No. General manager, na? Life Insurance Company having the office at Hindustan Building, 4 CR Avenue, Kolkata, is directed to appear before this court in person and to explain why the respondents, in spite of service of notice, is not appearing before this court. This is the matter on 12th of August 2026. Full stop. The petitioner, the department is directed to forward this order to the respondent number 5. 6 over 5 Mumbai. 6, and the petition is also directed to communicate also for compliance by the respondent. This is the matter on 12th at number 1 matter.
Right, and you know.
Address there. Address it Eastern Zone.
Next.
Lord, before my learned friend starts, Lord, your lordship is taking up 3 matters, out of which 2, in 2, my learned friend is appearing.
Right. Yes.
First and second. But the dates of completion of registration is not the same in both. So I intended to indicate that once, number 1. And number 2, I also intend to indicate in a similar matter, there has been an order of the division bench. I will be failing in my duties if I don't bring it to your lordship notice and leave it to your lordship. Give me the note first. If your lordship sees the second matter, that is Sundaram Enterprise.
Item 6.
That is item 6.
Yes.
I have prepared a chart. It is there in the video copy. The date of completion. The date of completion, the soft copy on the Dadake to forward. In Sundaram,
Yes.
the date of completion is 20 for 2 trucks. Kindly see in the chart, 23rd of February 2026. But kindly, if I may invite your lordship to look at the calendar once, 22nd February 2026 was a Sunday.
23rd of February.
22nd was a Sunday.
22nd.
23rd was a Monday. My date was over on 22nd of February. Because the LOA in that case, kindly see, was on 23rd of October. So 4 months is 22nd of February. The Sunday also, they are penalizing me because it was on the very next Monday.
Okay.
So that is that date I intended to point out.
Yes.
Only 1 day. 1 day means that also a weekend. And the division bench I wanted to point out. Lordship, it was in a HPCL matter.
Sundaram, there are 3 vehicles.
3 vehicles. In Karambi, there is 1 vehicle.
Yes.
And in the third matter, my lord, though HPCL will appear, I'll address that later. I don't see, my lord, Mr. Chatterjee here. My lord, in three matters, interim order was refused. We moved the honorable division bench. My lord, in two matters, the honorable division bench relegated us to the arbitration forum because there's the arbitration clause. And in one matter, it was not done. I just intended to point that out, but the honorable division bench has said that in the facts of this case, that case, my lord, it was sent to, and my lord, the petitioners there, my lord, as per my understanding, have taken steps under section 9. My lord, this is the order where, my lord, the matter was sent to the arbitral forum, giving an interim protection for four weeks. এটাও তো কপি নেই নিশ্চয়ই, কোনোটারই কপি নেই যেটাতে পড়তে পারবো।
This is another vehicle.
This is of HPCL. This is working under HPCL. No system.
I think it is IOCL,
IOCL, no?
IOCL, not HPCL.
I'm sorry.
IOCL.
বিশ্বনাথ কার IOCL এর appeal?
হ্যাঁ?
বিশ্বনাথ এটা কি? HPCL, এটা HPCL।
ওটা দাওনি আমাকে।
ওটা এখনো দিতে আছে। Oh, IOCL. Sorry, that is IOCL, and the other one where it was not sent to the arbitration forum was IOCL.
সেটাই তো বলছি।
আপাতত 5-6.
Yes.
And my lord, in this matter, that is Lord Shiva, it was not sent to the arbitral forum, it was sent back to the writ court in the same set of facts. But the difference that the honorable division bench has drawn in the two cases is the continuity of the vehicle. Since in Karamvid, the vehicle, your lordship had directed in an earlier round that the vehicle will run for 1 week after the impugned order is passed. In the meantime, we approached this honorable court and the interim order was refused. Then we went to the division. In Lord Shiva, it was not sent to the arbitral forum. It was sent back to the honorable single judge to decide finally. The point of difference is that the vehicle was not continuously running.
Okay. And in this case, currently my vehicle was continuing.
In this case, my lord, your lordship directed it to continue, but my learned friend yesterday made a submission, though he has not completed. I'll make submissions in reply that the vehicle is not continuing. In fact, it is not continuing, but actually should continue because your lordship has set aside the term. That I'll make submission reply. But my lord, since one of the matters have been sent to the arbitral forum, my lord, I'll just, my lord, place two judgments, my lord.
In this case also the same agreement.
Similar. All the oil companies issue similar tender for all the states across West Bengal. All the states of India. Same. It's worded same, my lord. But I'll just, my lord, your lordship already knows this principle, my lord, that the my lord, presence of the arbitration clause will not denude your lordship of the writ jurisdiction, my lord. The powers under 226, my lord. This is 2021, volume 16, SCC, page 35. Paragraphs, my lord, 39.2, 39.3, 39.5, and 39.6. That same ABL principle has been reiterated. I'm not reading it, but here also there was an arbitration clause. And since arbitrariness was found, kindly comes to 39.2.
Yes.
The decision in ABL International cautions that the plenary power under Article 226 must be used with circumspection when the other remedies have been provided by the contract. But as a statement of principle, the jurisdiction under Article 226 is not excluded in contractual matters. Article 23.1 of the development agreement in the present case mandates the parties to resolve their disputes through an arbitration. However, the presence of an arbitration clause within a contract between a state instrumentality and a private party has not acted as an absolute bar to availing remedies under Article 226. Then in 39.4, ABL is quoted, kindly comes to 39.5. Therefore, while exercising its jurisdiction under Article 226, the court is entitled to inquire into whether the action of the state or its instrumentalities is arbitrary or unfair, and in consequence in violation of Article 14. The jurisdiction under Article 226 is a valuable constitutional safeguard against an arbitrary exercise of state power or a misuse of authority. In determining as to whether the jurisdiction should be exercised in a contractual dispute, the court must undoubtedly eschew disputed questions of fact which would depend upon an evidentiary determination requiring a trial. But equally, it is well settled that the jurisdiction under 226 cannot be ousted only on the basis that the dispute pertains to contractual arena. This is for the simple reason that the state and its instrumentalities are not exempt from the duty to act fairly, merely because in their business dealings they have entered into the realm of contract. Similarly, the presence of an arbitration clause does not oust the jurisdiction under Article 226 in all cases, though it still needs to be decided from a case to case as to whether recourse to a public law remedy can justifiably be invoked. Here in our case, in my understanding, the dates are not disputed. The facts also, the interpretation may be different. That I could have done it, I did not do it, but I am putting my case only mostly on the utilization of the vehicle for one person and this hanging the sword over the others. In case of one of the matters which I placed yesterday, they have not challenged that order. They have accepted the registration of peso after the designated date of 120 days. But yet, in my case, it is not being done so. So these facts are not disputed in my case, which brings me within the bracket of 39.6. And the other judgment, this is also settled principle, but just the most recent that we found to be relevant, 59 onwards. This is 2024, volume 15 SCC, 461. Nine 60 61.
Yes.
$59 60 61. It is 59. It is needless to state that in matters concerning specific modalities of the contract, such as required work, execution methods, material quality, time frame, supervision standards, and other aspects impacting the tender's purpose, the court usually refrains from interference. State authorities, like private individuals, have a consensual element in contract formation. The stipulations of terms in the underlying contract purpose are part of the consensual aspect, which needs to be entertained by the courts in writ jurisdiction, and the parties may be relegated to ordinary private law remedy. Judicial review does not extend to fixing contract stipulations, but ensure that the public authorities act within their authority to prevent arbitrariness. Thus, the demarcation between a private law element and a public law element in the context of contractual disputes, if any, may be assessed by ascertaining whether the dispute or the controversy pertains to consensual aspect of the contract or tender in question or not. Judicial review is permissible to prevent arbitrariness of public authorities and to ensure that they do not exceed or abuse their powers in contractual transactions and requires overseeing the administrative power of public authorities to award or cancel contracts or any of its stipulations. Therefore, what can be called out from the above is that although disputes arising purely out of contracts are not amenable to its jurisdiction, yet keeping in mind the obligation of the state to act fairly and not arbitrarily or capriciously, it is now well settled that when contractual power is being used for public purpose, it is certainly amenable to judicial review. So, my lord, if my case is not within those parameters, though my lord, it is not exhaustive in paragraph 59, that required work, execution method, material quality, time frame, supervision, and other aspects, my lord, as mentioned in paragraph 59. Then, my lord, your lordship's, my lord, jurisdiction is not ousted. Till my case is put on the pedestal of arbitrariness only.
Yes.
I am not here saying that I should be given more kilometer, more load, less load. I am not on those points.
Okay.
So these are the two judgments, my lord.
Thank you. Yes.
Lordship, my learned friend, I think, has argued the entire matter without affidavits. Now, I can certainly argue on the point of interim order. As on date, termination has taken effect. They are not in service. Their trucks are not in service since March. And there is one order of referring the matters to arbitration, my lord. Now, all these points regarding maintainability of 226 vis-a-vis arbitration, my lord, was perhaps argued or not argued before the division bench, but that order of the division bench is still staring and has not been challenged by them. In fact, they have accepted the order. Now, my lord, the same person, if your lordship sees the arbitration order, it's Karamveer Singh, who is the first petitioner in the first writ petition here. Now, my lord,
So what is you will not argue matter on merit. You will argue.
I'll certainly argue the matter on merits and also on the issue of arbitration and maintainability of 220.
You can argue
But-
because this court finds if we giving the direction for affidavit, then it will never be ended.
Right.
That's why whenever I am taking the matter, because either interim or yet it is on merit. So that's why at a stretch I am disposing of the matter so that it cannot be burden the court in future again
Right.
for re-argue the matter.
That benefits everyone, my lord.
Yeah,
That benefits everyone
that's
also.
why. That's why it is my
Lordship,
All the documents are mostly on record.
correct. Now, if you want any document you wanted to refer, you want to supplementary, you take 1 week time, no problem. Supply the copy, they will take exception, so the matter can be disposed of.
I do not believe there are any more documents that they can bring on the table.
On point of law, you can argue any point with regard to the arbitration.
Lordship will kindly keep this in that event on 25th or 26th.
Why?
Because next week I am in difficulty, my lord. Entire next week I am in little difficulty.
But there are no documents to be put on record.
I have also
Even
got to deal with the
or argument,
my lord, they have to
not the document.
deal with the
I am
arguments also.
out of business.
I-
My learned friend can give a
Taking into
Shorter
consideration,
brief.
that's why I am not giving any affidavit direction.
Next week I am in some difficulty. That was I was asking for
Disposing of the
25th,
matter. In
26th.
all matters
Yes.
regarding
Yes.
this contact, unless it is an affidavit is required, because
Yes.
these are all the matters of the
Yeah.
court.
If affidavit is not required, I will not burden the court.
I am saying affidavit, if you are telling that all the.
But I'll have to also deal with these matters because these judgments and all initially came when the tender was initially floated last year.
Okay.
And this was challenged by the and upheld up to division bench that the terms of the tender cannot be changed.
Let
No, we are not on that.
Yes. He is really asking
when,
for
when you will be available now?
my lord 25th.
After 25th?
Yes. 25th itself or 26th, whenever.
Land
Or
council-
may retain its position.
Yes, land council for the petitioner has concluded his argument
Yeah.
with respect to
Sorry,
WPA number 16644 of 2026 and 16207 of
Thank you, but no legal
2026. Land and council
Only
for the
facts.
respondent prays for time. According case adjourned, let the matter appear on 26 within 5 matters. Under the same heading.
My lord 5 and 6 both.
Yes, 5 and 6.
I have for item 7, you can take all of them together.
It is also.
Now, in that Mr. Bandyopadhyay has not argued. You will argue separately in item number 7.
But let it also
Come on, 7.
appear because
It's
Uh,
spilled over and can be otherwise.
as regard item number 7, as regard WPA 16213 of 2020. नहीं क्या वो भी छोड़ दो. Let the matter WPA number 13 be also appeared on.
Correction to correct.
ठीक नहीं इसमें hearing नहीं.
Malad, the
ठीक है.
note may be kept with the record, Malad.
Come on that day. अलग अलग कर दो. उसमें खाली बोलो let the matter appear on one by one. Yes, next.
Grateful, my lord.
Policy matters.
Also grateful, Malad. Item number 8, my lord, I'm for the respondent number 325.
Yes.
Lord, it is that matter pertaining to the election of a apartment owners association. Now, my lord, we had completed our, she's there. She's there for the petitioner. Mr. Basu for the respondents has completed his arguments. If my lord desires, we can file a written note on the next day.
No, what it's Mr. Trivedi. You are completed your argument.
Mr. Basu had concluded on the last occasion.
So why it is fixed today?
Lordship, I was supposed to ask.
You reply yes.
Yes.
Lord, perhaps, though it's not indicated, 26 may be a holiday, my lord.
Some Mohammedan festival.
Acha.
So, which is according to the moon, so it may be on 28th, my lord, subject to lordship business permitting.
28 कर दे.
Great.
One problem I'm facing in item number 4, my lord has given direction for personal appearance of the LIC Journal Manager. I was busy in Sabada court, my lord. This is my problem. I cannot appear, my lord. It's my fault, my lord. Not my client's fault. It's my fault. My lord, kindly withdraw that order. I'll appear any day according to my lord's convenience. It's my fault. I cannot appear before your lordship.
Then you, okay, you tell to Mr. Vikas Bhattacharya. Vikas Ranjan Bhattacharya.
Yes, yes.
Come with any junior, I will sit.
Okay.
Yes.
Your Lordship, may I? Your Lordship, I would some indulgence, Your Lordship. I would like to start from the very inception of the problem. Your Lordship, on 24th of
See, only the question now they have raised, there are two. Okay, the competent authority has heard the matter,
yes,
passed the order, holding that yes, there was some lacuna, whatever it may be,
yes, Your Lordship.
but election was held to be fair.
Yes.
Now the question is that if the election again it is not fair and to be declared election is to be held further or setting aside the election process, you are the defaulter of paying the rent.
Your Lordship,
That issue was not before the competent authority. That authority has not decided.
yes, Your Lordship.
Correct. And as per the act, and you have received the notice. If you have received the notice and that is not the matter before the competent authority, how this court can, on the basis of this court can set aside that?
Your Lordship, the problem here is
Because as per the order of the competent authority, your suspension gone.
yes, Your Lordship.
Correct. Because they have not challenged.
I accept it.
And they have accepted.
But-
With regard to the election process, you notice has been issued to you.
No, no, no.
With regard to the
Yes, WhatsApp notice I have said.
correct.
Here I need
But subject to correction, on the last day, I submitted before your lordship for the purpose of recapitulation, rule 8,
Yes.
rule 11. I said the rule 8, sub rule 3, that how the notice is to be circulated, a registered post or WhatsApp or electronic mode. I adopted the second, my learned esteemed friend, Milord, kindly,
With regard to the dues,
dues.
you have received the notice.
Your Lordship, the notice itself is wrong since its inception.
Why?
Your Lordship may come to the bylaws, Your Lordship.
Notice to challenge করেছে? Notice is not under challenge.
Lordship, the notice. Your Lordship,
Which notice?
Your Lordship, notice dated 5/5/2025, Your Lordship. The Lordship, they,
Page number?
yes, Your Lordship, Your Lordship, in their opposition, page number 23, Your Lordship. the notice that they have declared that they have declared the AGM to be held on 20th July 2025, Your Lordship. As per as election, Your Lordship, that they have declared that election and AGM will be held on 20th July 2025. That notice itself wrong. This 5/5/2000 notice, the declaration of election should be decided by the Board of Managers, not by the office bearers, Your Lordship.
It is the minutes of the notice, meeting.
See that,
The notice should be issued.
where is the complaint made earlier on the basis of which the competent authority has passed the order? Where is the complaint?
Possibly, my lord, she has misunderstood my contention. I said there are two parts. One is right to elect and right to participate in the election.
Correct.
The right to elect and right to participation, my lord, it emanates from Rule 11. Number one. Number two, I said that Justice Sinha coordinate bench order, my lord, page 61, it stares at us, my lord, for the simple reason. Because the point of dues, my lord, was raised. The court said, my lord,
Your Lordship, the point of dues was never in question in the earlier petition, nor it is a question
Kindly.
here. The election process in
61, my lord, kindly say.
eligibility comes second. If I'm eligible or
Paragraph-
not,
My lord, I appreciate her perception, my lord. Kindly sees, my lord, in order to eradicate any confusion, my lord, between the ears and the eyes, my lord,
Your-
kindly sees 4, page 61. My learned esteemed junior friend, my lord, possibly, my lord, has, my lord, consciously misunderstood this, my lord. 4,
Your Lordship,
learned
wait.
counsel for the association denies the allegation of the petitioner.
I will hear. Yes.
Your Lordship, just a small
Sorry,
indent.
I'm sorry.
Your Lordship, the matter itself started on 28th of November 2025, where I was alleged that I have misbehaved. I asked for CCTV footage. There was no CCTV footage given to me, either to the police official.
That has gone.
Your
that
Lordship,
That
there
has
was nothing
gone with
barring
regard
them.
to, that has gone with regard to your suspension. That is the allegation which you have been suspended. That suspension, the
Yeah.
competent authority kindly come to the 109. This removal of so and so from the office of the manager board was not done following the rooms, and they have accepted that.
Your Lordship,
So-
just a small indulgence, Your Lordship. If Your Lordship may turn to page 21, Your Lordship, of their opposition, that is, they have told that the police officials have barred them to hold a meeting, physical meeting, but not virtual meetings. Your Lordship, the date of election should be decided by the Board of Managers, Your Lordship. If Your Lordship may look at this, Your Lordship,
So see, I am having the book. Which provision you are?
Your Lordship, bylaws, election, clause 8, Your Lordship, under chapter 3, Constitution of a Board of Managers and its functions.
Yes.
Your Lordship, it says that within 15 days of formation of an association, the apartment owner presiding over the general meeting referred to in the said clause shall serve notice upon each and every member of such association, fixing therein the date on which and the time and the place at which a special general meeting shall be held for deciding the detailed manner in which and the date on which the election of managers of the board to be held. Your Lordship, this particular election date needs to be decided by the whole board of managers, not only by the office bearers. Your Lordship, which they have done, stating that the board of managers meeting could not be called. They were barred. But Your Lordship, the police itself, they have itself stated by the order dated by the notice dated 24/1/2025, where further meetings shall be conducted online. Your Lordship, from that day, January till 5th of May 2025, no board meetings were ever held, Your Lordship. And by the order dated, if Your Lordship goes to Justice Sinha's order, that is 18th of 7/2025, Your Lordship. The election was supposed to be held on 28th, Your Lordship. But they have declared the list of successful candidates, Your Lordship, on itself 14th. They have kept mum on the day when this notice was supposed to be, when the order was being issued by Justice Sinha.
Yes.
The that itself states that there are pre-election flaws stating.
Then you come to the Justice Sinha order. Kindly come to the page 61.
Yes, Your Lordship.
Correct. Kindly come to the page 60. Read the page paragraph 3 onwards. Paragraph 3 onwards. Read paragraph 3.
In the meantime, the sunrise owner to be conducted, Your Lordship, they are.
Read.
In the meantime, the Sunrise Tower Apartment Owners Association has declared an election to be conducted on July 20, 2025. The petitioner intended the contest election process, but because of his suspension, he was unable to do so.
Correct. Correct. So your case is that that's why since beginning you started your argument. Your case is that you have been you was illegal suspended and they have declared the election. You have not been allowed to participate in the election. That's why the election is bad in law. Correct. And subsequently, you filed the writ petition here. This court has relegated the matter to the authority. Now come to the paragraph 4. Now come to the paragraph 4. It is submitted that there are maintenance dues to be paid by the petitioner. They have on the petition itself, they have taken this plea because you have to pay the dues. Correct. Now come to the paragraph 8. In view of the above, the competent authority, West Bengal so is directed to consider disposal of complaint lodged by the petition, counter complaint lodged by the private respondent in accordance with after giving a reasonable opportunity. Now, a reasonable opportunity, the allegation of the election process has not been legally followed and the issue of suspension. So with regard to these are the two issues to be decided by the authority, whether the election was in accordance with law and with regard to the suspension. Suspension, they have declared that yes, your suspension is not in accordance with law. Now they have accepted, they have not challenged that order. With regard to the other portion, the election process also kindly come to the 101. 109. Clause 2. There are some flaws in the pre-election process, although the actual election was conducted in a free and fair manner. Correct. So free and manner, you are telling that the notice itself is a bad, but that is not the case in the earlier round of litigation. Your case is with regard to your suspension due to the suspension. Now, if you say the notice is bad and illegal, then you have to challenge the total election process. Correct. First thing. Second thing, with regard to if we go by the election process also, you have not still date, you have not deposited the even before the when the hearing was taken by the competent authority, before the competent authority also, you have not shown no, I have paid the total dues, there is no dues. Even in the writ petition filing, before filing of the writ petition also not here disclose that I have paid the total dues and I am entitled to participate in the election. That is the only question, madam.
Your Lordship, the point that I have not been allowed to participate in the election is my eligibility criteria. But Your Lordship, I am not the only board of managers there. There are 48 other people. The whole election itself is wrong.
Then where is the complaint? Initial complaint? Where is the initial complaint on the basis of this competent authority decided the matter? Where is the initial complaint?
Your Lordship, the competent authority itself states that in the order.
Page 43, subject to correction to be made by my learned esteemed friend.
The election committee was constituted without any resolution or decision being taken.
That's correct. So then your case is totally based on the complaint which you raised.
Yes.
And which has been relegated by this court to the competent authority. Now kindly come to the page number 46. Yes, 46.
Not a single whisper which your lordship is asking. 43.
43.
43. Annexure P4.
43. Show me the notice is wrong. You are the manager. Manager not can you show Show me.
Your Lordship, the whole contention which I stand on is, Your Lordship, that
Okay, when your senior will come?
Your Lordship, Mr. Trivedi.
Trivedi said he will not appear.
Yes, Your Lordship.
He will not appear.
He said no.
He
Because
will,
Milord,
you will
by dint of his post, Milord, he cannot
He
appear.
cannot appear in the private matters, Your Lordship. Your Lordship, the main contention which I'm trying here is the issue itself on the order dated 25th of August 2025. It is stated that there are some flaws in the pre-election process. They not deciding that they deciding all amongst themselves, that is the 8 office bearers, that 20th July is the date of election. That should be decided by the board of managers, Your Lordship.
I totally agree with you, madam. I totally agree with you, but the authority has to decide with regard to what the complaint you have made.
Your Lordship, I have
Correct.
asked in
See,
my prayer.
leave aside the authority. You are filing the writ petition.
Yes, Your
The
Lordship.
court has to decide the writ petition as per the averments made by you and the authorities, or the counter, what is the counter by the authorities. If in your writ petition the allegation is not there, how the authority will decide? And this is not an independent writ petition, it is a writ petition challenging the order of the competent authority.
Yes,
If it is an independent writ petition, okay, so far the court can gone into that. But it is the writ petition challenging the order passed by the authority in terms of the order passed by this court. And in the competent authority decided the issues to the claim made by you and the counterclaim made by the other party. Correct. That's why I'm again and again telling, if you show that you have taken this point and that has not been decided, then the matter would have been different. Because they are specific. If suppose, see the situation, your suspension, they are admitting now that you are not under suspension. If suppose today the court say the election was wrong and you conduct a new election, but you have not paid the dues, you have not shown your bona fide in a writ petition also, see, I have paid the dues. So,
And execution, Milord, number 2, Milord, the Justice Sinha's order, Milord, the last part which I said, Milord, there are 3 components. And it clears, Milord, there is no
that's what I'm telling.
there is no climate of uncertainty, Milord. So, Milord, today, Milord, all but Milord,
When is the next election?
Not yet
May.
decided.
May?
You are not supposed
3 years later,
3 years later.
28.
28.
Your Lordship, the malafide intention here is, Your Lordship, the moment I have been suspended illegally, they have declared an election. So now, even if I get an order of reinstatement, they will say, Your Lordship, the prior election, I cannot be reinstated in the board of managers. Your Lordship, that is the whole point.
She can never be because of Rule 11.
You do
Deeply
one thing.
obliged. Deeply obliged.
You want to file return notes? No problem. We'll give
Written
the
note.
chance.
File karna chahti ho?
You
Yes,
file return notes?
yes.
By Monday?
When?
Your Lordship, a week's time.
Counsel for the respective parties have concluded their argument, full stop. The parties are the counsel. You will also file, Mr. Basu?
Yes.
The parties pressed for a week time to file return notes of argument. Let the return notes of argument be filed by by 13th of August 2026. List the matter on 13th August as to be mentioned for filing return notes of argument. Yes.
Item number 4, my lord, my other side.
I don't know, you have taken the dictation. Yes.
My lord, if he is appearing, my lord, personal appearance, my lord.
That's why I'm telling to call you, because otherwise tomorrow you will,
Yes, my lord.
Mr. Bhattacharya will say, so what can be done?
My lord, on 12th or
Any day, any day.
Oh, personal, non-person, yeah. Since appearing for the petition, counsel for the petition argue the matter at length. Counsel for the respondent prays for time. Let the matter appear on 12 within 5 matters.
Same date. I'm glad.
ended only within the top.
Within 5 matters.
I'm glad.
Come on that day.
Yes, yes, yes.
Because you are.
I was always present, my lord.
No, you take the instruction.
Yes, yes.
Take the
I'll come. On the meantime, I have already filed my affidavit also.
next.
Much obliged.
Time for the petition.
उन्होंने आई है फिर हो तो स्टे Right?
Yes,
What-
who is for the petitioner?
Yes, my, I am for the petitioner.
What is the
Right,
matter?
your petitioner has a business transaction with one Orient James Ornament Private Limited.
Orient
James Ornament.
Gems.
Yes, madam.
Hmm.
But they are goldsmith. But what has happened? The Orient James sold one gold ornament of rupees 13 lakhs to one Sujoy, right? Sujoy Mujumdar. After that, Orient James sent me 4 lakhs rupees. But I came to know my 4 lakhs something was marked lien. Thereafter, Orient's bank account 8 lakh odd, right, marked lien. But total 13 lakhs the amount. Thereafter, I had an amount of rupees 30 lakhs in my bank account, but that too marked lien. But Orient James made a complaint before the officer in charge, inter alia, alleging the entire incident that they have sold gold ornament. The amount
They
that
have
is
sold the gold ornament to you.
no
13
to
lakhs, 80,000.
to Sujoy,
To
13
Sujay.
lakhs.
Who is Sujay?
But the Sujoy is a customer of Orient.
Okay.
Now, after that, my lord, money receipt is at page number 23.
23.
23.
Yes.
Yes, my lord. Thereafter, as I have,
Where is that amount?
those are sold to this Sujoy.
Hmm.
After that, he paid 13 lakhs odd to Orient after purchasing the same. Now, Orient and I have business transaction. Orient send me 4 lakhs. My amount frozen. Orient's 8 lakh frozen. Again, 30 lakhs, which is lying in my account.
Whatever the amount transferred by the Orient in your account,
That too frozen.
that has been frozen according to all the total account has been.
Total account 30 lakhs, that too
The
frozen.
disputed is with regard to the Sujay and the Orient.
Yes, ma'am.
I appeal for the bank, like HDFC Bank will be my lord.
Yes, you are appealing for whom?
I'm appealing for the state, my lord. I do not.
Who is for the HDFC? Have you served the notice?
Yes, Lord. So,
That is the problem. You persons are mentioning when the matter is taken up for hearing, either petition not appear or respondent not appear. Then in the morning hours, you all persons will make halla gulla. Out. What can be done? I record an order. The petitioner has filed the affidavit of service, wherein it reveals that the notice has been served to all the respondents. Then counsel for the state is present. None appears on behalf of the HDFC Bank. Accordingly, petition is directed to inform the next date of hearing to the respondent number 3, as well as the respondent number 4. The respondent number 3 is directed to submit report with regard to the account of the petitioner and the circumstances how the account of the petitioner has been freezed by the respondent number 4. This is the matter. Full stop. It is made clear that if in spite of the receipt of the notice, if the respondent number 3 failed to 3 failed to appear before this court and to file report, the matter will be taken up for hearing in the absence of the respondent number 3.
I'm grateful.
This is the matter on 13th August. Next.
Great.
But I like to give the Reserve Bank of India.
My lord, I am appearing on behalf of the State Bank, my lord, in this matter.
May it please your lordship, I,
Yes.
my lord, appear, my lord, for the petitioner, my lord. It's a pure question of law.
What is the
Yes, my lord, at the very outset, I would say that it's not an adversarial litigation against us. It's the account holder who is having an account.
একটু
He
বলে নি,
said-
বলে নি fees দেবে না।
Now, if you're giving this relief, then there is no problem. Then I will hear you first.
In accordance with law. That,
In accordance with law.
and the bank's interest may.
What is the prayer, Mr.
The short point is, my lord, as to whether a will probated by the British court, whether that requires a letter of administration or not. But this field, this issue is no more res integra. The Honorable High Court at Delhi, my lord, it has held already that no, court means
All court.
also foreign courts. So in tune with that, my lord, now this pertains to the estate of the deceased who was a British citizen who breathed his last at United Kingdom. Now his will was probated. My lord will find the probate at page 25 of the petition. Yes. So upon the probate being granted, the executors, my lord, the petitioners herein, so on their behalf, a representation was sent to the State Bank of India vis-a-vis the estate of the deceased in India pertaining to two of his accounts. My lord will find that at page 28. It's a very short representation. I'll just, my lord, read the representation that will, my lord, give a clarity as regards the facts. Page 28, my clients Pitman, Burke and Sinker solicitors having their office at such and such was appointed the trustee by the above named Subhash Mitra since deceased in his last will and testament dated 30th day of November 2009. The said Subhash Mitra died on 17 December 2019. After his demise, the said will dated 30th day of November 2009 was probated by the Honorable High Court of Justice England and Wales, Principal Registry of the Family Division. The testator held various accounts with you at the time of his demise, which were not closed, as it has been held by the Delhi High Court, citing Section 41 of the Evidence Act, stipulating that final judgment of a competent court in the exercise of probate conferring upon any person a legal character is conclusive proof of that legal character, and that the Honorable Court in the case of Dr. Sanjay Khanduja versus Punjab National Bank and another also reaffirmed that the word court should not be restricted to a domestic court. Hence, probate of a will by a foreign court of competent jurisdiction stands as conclusive proof of legal character throughout the world. It is requested you take action as follows. Above circumstances and by virtue of the given precedent of laws, you are hereby requested to take the appropriate steps to remit the funds held in the testator's account in favor of the aforementioned trustee, so that the trustee can distribute the funds among the beneficiaries of the said will, thereby complying with the last wishes of the said of the deceased. Now the bank turns down this request at page 30. My lord will find. We refer to the trail mail of such and such, whereby video letter dated such and such, a request has been made for releasing the funds in the name of Subhash Mitra, since deceased, to the trustee executor on the basis of probate of will granted by foreign court, considering the precedent of Delhi High Court. In this connection, we have received confirmation from our law department, wherein the scenario of will which probated by foreign court is explained. It is mentioned that as regards will executed and probated outside India, a properly authenticated copy of the will issued by foreign court is to be produced in the courts of India, who can then grant letters of administration. This dispenses with the necessity of proof of original will. Therefore, in such case, claimant should be advised to approach an Indian court for issuing letter of administration. The court will grant letter of administration with a copy of will annexed, where the branches can act. So, but this is how it has been turned down in by misconstruing, my lord, the judgment of the Delhi High Court, written out 2021 SCC online page 3209. আরেক কপি কোথায়? Stitch করবে তো না? Not the way. Very embarrassing for me. But let me kindly kindly take the entire judgment is of relevance, but para 14 and 15, my lord, will be of significance. It states that it is thus clear that under section 41, a competent court includes the foreign court, so long as the probate or letter of administration is granted by a competent foreign court and the same does not violate the laws of succession in India, it can be recognized in India. Further, the Hague Convention abolishing the requirement of legislation for foreign public documents that is the Apostille Convention, is clear to the effect that legislation in the Indian embassy would not be required if the document is duly apostille. India being a member of the Apostille Convention since 2005, there is no requirement of legislation of duly apostille documents. So, my lord, this is the ratio. And thereafter, para 17, if my lord kindly takes. The above being the legal position, the only requirement for claiming rights under a probate granted by a foreign court would be to file an apostille copy of the judgment of the said foreign court in view of the judgment of the Honorable Supreme Court and settle legal position, as also the notification. The following directions are issued. Thereafter, my lord, the directions, my lord, similar to what we have prayed for, my lord. So, my
You
lord,
got the this apostille.
yes, it's apostille. In fact, in my lord's petition also, my lord, everything is apostille. So, my lord, may kindly, my lord, clarify the position, my lord, set aside, my lord, the communication of the bank and direct them, my lord, to, my lord, act in terms of, my lord, the law as interpreted by your lordship, my lord.
My lord, there are some legal confusions in this matter. My lord may lay down a law in this regard also. I will humbly beseech my lord. My lord also may kindly consider this judgment of Honorable Madras High Court. My lord, probably this judgment of Dr. Sanjay Khajuja has not taken note of section 228 of the Succession Act, Indian Succession Act. My lord, I just like to point out paragraph 15 of this judgment that I have handed over right now, my lord.
Yes.
In the second stage, an application for grant of an ancillary probate, also known as resealing of probate under English law, is required to be filed before the concerned court in India, along with the authenticated copy of the will and the final order obtained from the foreign court. The necessity to obtain an ancillary probate is clear from a conjoint reading of section 213, 228, and 270 of the Indian Succession Act. My lord. My lord, 213 has been repealed. My lord, 228 and 270 may be considered.
No, new one. Indian success, Hindu successor. Hindu successor. 228.
220. When a will has been proved and deposited in a court of competent jurisdiction situated beyond the limits of the state, whether within or beyond the limits of India, and a properly authenticated will, copy of the will is produced, letter of administration may be granted with a copy of such will annexed. So this provision has been taken into consideration by this judgment.
Yes.
Whereas Dr. Sanjay Khajuja's judgment is absolutely silent on 228. It has been passed in sub-silent. It has not said anything about 228 of this Indian Constitution. It is only relying on section 41 of the Evidence Act.
Have you gone through this Samir Kapoor SCC? Relied by the Delhi High Court?
Para 13, there 228 and 276 were also considered.
Yes, my lord, Samir Kapoor was considered by that, Dr. Sanjay Khajuja, but my lord, ultimately in the no reasons with regard to this 221.
Additional right. That's what Sabir Kapoor says.
My lord, at the very outset, I said that it's not an adversarial litigation. My lord may lays down. Because there are some confusions under for which we have not been able.
But Mr. Bhattacharya, have you read the paragraph 14.1 and
14.
17? Just the case of Samir Kapoor.
Correct.
Because there the observation is that okay, the case is that they filed the application for grant of letters of administration. The opposite party filed an application 711. 711 rejected. Now they can go. So that's why the court is telling that 228 is maintainable.
So 228 has been interpreted to be an enabling
Enabling course, but the foreign court decree, you have got the probate.
additional right to apply for letters on the
Yes,
basis of.
letters of
It's an additional right. It's discretionary whether to avail or not to avail.
The application can be submitted to probate of letters of administration if the objection is raised by anybody. So there is no objection. Is there any objection you received?
No, we have not received.
Then, if there is an objection, then they have to go.
There is another subsequent decision also, my lord.
Question is whether they are required to question before us, my lord. Question is whether they are required to obtain an ancillary probate under section 228 or not. If my lord says no, we.
Another judgment ordered which
What?
not stitched, my lord may kindly excuse me, my lord, for the same not being stitched, my lord.
No problem.
दाओ एक कॉपी दो कॉपी नहीं है भाई पूछ तो भाई तो बीएमओ का There also, my lord, Samir Kapoor and Khanduja were considered. And finally, citation to the The ratio is, my lord, that once a will is probated in a foreign court, there is no requirement of obtaining any letter of administration with respect to the same will. It was by the SBI only, my lord, the same respondent who had raised the same objections. Para 24 of will be of my lord, substantial significance. Regard must also be
23
had.
and 24.
Yes. As was eloquently explained and held in Kumarjit Singh Khandpur, a probate issued by a competent court is conclusive to the legal character throughout the world. Explaining the provisions of the 1925 Act, it was held that it could not be said that rights of applicants do not come to be effectively settled and secured once probate is granted. The court cannot lose sight of the fact that under provisions of the 1925 Act, a probate is not mandatorily required to be obtained in respect of a will which may be presented before a competent court in the National Capital Territory. In any case, the issues raised here stand conclusively settled in favor of the petitioner in light of the judgment of the court in Dr. Sanjay Khanduja. The decision has duly considered and negatived an objection addressed on identical lines. The only obligation which was accorded recognition was of an apostille copy of the will and the judgment of probate being produced. Regard must also thereafter, my lord, finally the directions are that SBI shall act in accordance with para 27 in accordance with the conclusions recorded herein above, process the prayer for remittance as made by the petitioner in light of the judgment of the Supreme Court granting probate, Superior Court granting probate. Aforesaid would be subject to the petitioner placing a duly apostille copy of the will and judgment of the probate before the bank. I want to do this only, my lord. And it says that it's a judgment in rem. The subsequent judgment, my lord, it's
Yes.
I'll just give the citation to my learned friend. 2022 SCC Online Delhi 5078.
2022.
SCC Online Delhi 5078.
Yes. Record.
Great put.
The
But may I take your lordship's kindly?
Yes.
Great.
The petitioner has filed the present application praying for amendments upon the respondents to release the funds and the funds of the amounts lying in the bank account of the deceased testator in account number 111 26 85 76 32, 37 45 76 26 489 and 37 45 78 88 694 of the respondent number 2 bank in favor of the petitioner based on the basis of the probate of the deceased Subhas Mitra without insisting on letters of administration. Mr. Bilawal Bhattacharya, learned senior advocate appearing for the petition, submits that the deceased Subhas Mitra alias Subhas Chandra Mitra was domicile of the United Kingdom. He has executed during his lifetime. He has made and published a will dated 30th November 2009, signed and executed in London on the same day. Same, full stop. The deceased died on 17th of December 2019. After his death, the last will and testament of deceased was probated on 5th of May 2023. And the administration of his estate was granted by the High Court of England and Wales to the executors of the deceased who are the petitioner herein, comma. The petitioners in the said will, the testator has described the money investments and the property wherever situated, which includes 3 bank accounts as mentioned above. That is at State Bank of India, from a DA block, Salt Lake branch. Salt Lake, full stop. All the formalities pertaining to the probate of the last will and testament of the deceased were completed. Full stop. On 29th of February 2024, the petitioners, through their learned advocates, has sent the copy of the will, death certificate of the deceased, and the probate granted by the High Court of Justice, England and Wales. To be submitted before the bank for release of the funds lying in the name of the deceased. The petitioners in the representation submitted by the petitioner through the learned advocate requested the bank for release of the fund lying in the name of the petitioner and deceased in terms of the probate granted by the Court of England. On receipt of the letter, advocate letter, the respondent number 2 has sent a reply. On 29th of February 2024, informing the petitioners that the will was executed and probated outside India. Therefore, the petitioner should approach the Indian court for issuance of the letters of administration. And after getting the letters of administration, the respondent number 2 will take appropriate step for release of the fund. Now the petitioner has challenged the communication of the bank dated 30th April 2024. Then counsel for the petitioner submit that once the High Court of England and Wales has granted probate, thus there is no necessity for obtain any further letters of administration to the said probated will. He has relied upon the judgment in the case of Dr. Sanjay Khanduja versus Punjab National Bank and another, reported in 2021 SEC Online, Delhi 3209, and submits that the similar issue was raised before the Delhi High Court, and the Delhi High Court has held that the only requirement for claiming rights under the probate granted by the foreign court, would be to file an apostille copy of the judgment of the said foreign court, the full stop. The Delhi High Court has passed the judgment by relying upon the judgment in the case of Samir Kapoor, reported in Samir Kapoor versus the state through the subdivisional magistrate South Delhi, reported in 2020, volume 12, SCC 480. Full stop. By relying upon the said judgment, Common Learned Counsel for the petition submit that the respondent bank has wrongly interpreted the law and directed the petitioner to obtain letters of admission from the Indian court instead of relying upon the probate granted by the High Court of England and Wales. He further submitted that the petitioner has submitted the said probate to the bank with the apostille, but the bank has not accepted the same. Per contra, an advocate appearing for the bank has relied upon section 228 of the Indian Succession Act 1925 and submit that as per the said provision, the petitioner has to obtain a letters of administration of the probate granted by the High Court of England and Wales, but the petitioner failed to obtain the letters of administration. The counsel for the bank has relied upon the judgment in the case of Roshan Anthony Gunawardhana versus Ministry of Finance, Government of India, reported in 2022, SCC Online Madras 9379, and submit that the Madras High Court has considered Madras High Court has held that it is the necessity to obtain an ancillary probate to clear from the conjoint reading of 213, 228 and 271 of the Indian Succession Act if the probate has been granted by the court outside India. Had the learned counsel for the respective parties peruse the materials on record and the judgment denied by the parties. There is no dispute the will was executed by the deceased at United Kingdom, and the probate was also granted by the High Court of England and Wales. The only question and the bank has rejected the request of the petitioner for release of the funds lying in the name of the deceased in favor of the petitioners on the basis of the probate granted by the High Court of England and Wales, that the petitioner has not obtained the letters of administration from the Indian court by producing the probate granted by the High Court of England and Wales. In the case of Dr. Sanjay Khanduja, Supra, the Delhi High Court has considered the judgment passed by the Honorable Supreme Court in the case of Samir Kapoor, Supra, wherein the Honorable Supreme Court has held that eta करो ना क्या बोला wherein Delhi Supra the Honorable Delhi High Court while the Delhi High Court while dealing the issue with similar issue has held that eta करो वे यहाँ से लेकर के Yes. Full stop. The petitioner has also referred the judgment in the case of BMO Trust Company versus State Bank of India, reported in 2022 SEC Online Daily 5078. In the said case also, the Delhi High Court has considered the judgment in the case of Sanjay Khanduja and passed an order directing the the bank and directing the bank that the superior to release the fund in terms of the judgment passed by the Delhi High Court in the case of Khanduja. Full stop. The judgment relied by the petitioner in the case of Roshan Anthony Gunawardhana, the Madras High Court has not considered the judgment passed by the Honorable Supreme Court in the case of Samir Kapoor within bracket Supra and the judgment passed by the Delhi High Court in the case of Dr. Sanjay Khanduja. Full stop. Consider the judgment delivered by the Delhi High Court in the case of Khanduja, the Delhi High Court has held that the only requirement for claiming rights under the probate granted by the foreign court would be to file an apostille copy of the judgment of this foreign court. Full stop. Subpara. In the present case, the learned counsel for the petitioner submitted that the petitioner has submitted the probate granted by the High Court of England and Wales, apostille copy of the, but in spite of the same, the bank has not released the same. Considering the above, full stop. In view of the judgment, full stop. The Honorable Supreme Court in the case of Samir Kapoor, has categorically held that in a case where a will has been proved or deposited in the court of a competent jurisdiction situated beyond the limit of the state, whether within or beyond the limits of India, in that case, as provided under section 228 of the Act, when the properly authenticated copy of the will is produced, the letters of administration may be granted in favor of such persons, meaning thereby, in such situation, the will is not required to be proved again, and it shall be conclusive. Therefore, section 228 of the Act shall be an enabling provision, and it confers an additional right to apply for letters of administration on the basis of such authenticated copy of the will. Therefore, as rightly, full stop. In the case also, full stop. In the case, the petitioner has obtained the probate of the will of the deceased from the High Court of England and Wales, and the petitioner has submitted the same by way of submitted the same to the bank for release of the funds in favor of the petitioner in terms of the probate granted by the competent court. Thus, this court finds that the communication dated 30th April 2026 is not sustainable. According, the same is set aside and quashed. The respondent number. Well, the petition is direct. He has submitted the apostille copy. It's there.
No, he has not submitted there.
The petition is directed to submit the apostille copy of the probate. Apostille copy of the probate granted by the High Court of England and Wales to the respondent number 2, and if any application is filed by the petitioner to the respondent number 2, the respondent number 2 shall release the fund in favor of the petitioner in terms of the probate granted by the High Court of England and Wales upon completion of all formalities in accordance with law. Yes, next.
My lord is taking up the 12 noon fixed matter, my lord, that insolvency professional matter which I mentioned yesterday, my lord. Then should I come back at 2:30, my lord?
Let us see whether it will continue or not. If it is not, I will. Which matter? What is the serial number?
That's, my lord, item number 12, because today is the last day.
12.
6th, yes.
I reached 10. Let us see whether it will not take. I will call the matter.
Only thing is that I have, my lord, a matter fixed at 12:30. That is it.
2:30 I cannot because 2 PM matter is fixed. Then it will again go, then I don't know. That's what I'm telling. So your juniors are not here.
They're there.
Let
Very well.
Yes.
May it kindly be please not.
An
Lord-
order of the Lordship on 24th of June 2026, a report was supposed to be given by them, my lord. They have not given any report.
Lord,
Who is for the respondent?
Lord, I am appearing through VC, Lord.
I speak for. Ah,
And
not
affidavit
supply
was, a supplementary affidavit was to be filed, my lord.
go through. That's why I'm telling. We don't know whether the matter will be taken or. See, very small report is there.
My lord, actually, I have
Within a minute, you can go through and. use it.
Let them place the report. We shall be giving the answer here. To your
Here
lordship.
you know.
Yes.
You will not go through.
No, we shall know, my lord, what they may say. We have gone through the entire subject.
Hmm. Yes.
The answer of question of your lordship was,
my lord,
the
may I respectfully
petitioner have raised the issue, the test report which respondent have relied upon, the name of manufacturer, NS, and these are not been given. Learned advocate respondent paid time for supplementary disclosing the document to show that the batch number and manufacturer names of material sent for test. Let them show that page only.
Yes.
That will satisfy your lordship query.
Yes.
My lord, may I respectfully submit? My lord, on the last date, my lord, on this issue itself, my lord have asked me to submit the report. My lord, I have filed the document. My lord, may directly come to page number 36.
36.
36.
Yes.
My lord, the first entry is, my lord, find that page 36, first entry.
Yes.
My lord, it was sent on 17th March 2025.
Yes.
Laboratory name is Shri Balaji.
Yes.
Tender number is this.
Yes.
Thereafter, date, drug name. Then, my lords, may kindly see the batch number.
Batch number 791.
791. Thereafter, my lords, may see the secret code number.
Yes.
That is the secret code. And thereafter, my lord, report number and the other details are there.
Yes.
My lords, may I respectfully submit why this is being done? My lords, in our quality policy, in order to maintain unbiasedness and secrecy, we have already provided the manner in which we will conduct the quality testing. Lords, may kindly have page number 17, my lord.
17.
Yes, my lord, 17. And this is the practice, my lord, which is being followed all over India.
Yes.
All the drug corporations are following this practice only. My lord, may kindly have point number 6. That is sample preparation.
Yes.
My lord, while this, my lord, the relevant clause would be C.
In-house system.
The relevant clause would be, my lord, clause C. May I read, my lord?
Yes. Yes.
consignee selection of drug batches from all samples received to quality control division of UPMSCL Lucknow drug warehouse will be done by the headquarter pharmacist quality control through DVDMS portal. Lord, this is drug verification and drug management system. This is a automated system, Lord, for which we don't have any control.
Yes.
It is an automated computerized system.
Yes.
Quality control division shall wait for 7 days for the receipt of sample of any batch or up to sample of same batch is received from 3 warehouses, whichever is earliest, for the consignee selection and sending sample for testing as empaneled lab. Not when there are more than one consignee. There are 78 districts almost in state of Uttar Pradesh. When there are more than one consignee, then we collect the sample from various consignee drug warehouses and collect it at Lucknow. And when there is only one consignee, then we directly proceed with the testing. Then, my lords, may kindly have clause D. All marks of manufacturer's identity, including batch number, shall be raised masked for the sample to be sent to the empanel lab, and sample shall be sent with a system encrypted code, product name and strength.
Yes.
Then, my lord, the software clause E, the software system DVDMS shall recommend the laboratory to which sample shall be sent based on the randomized logic in consideration with various lab empaneled for respective drug and total sample load balance, cumulative number of samples sent to the lab and total sample pending for testing at the lab at that point of time. Therefore, my lord, complete automated system is there. We even do not select the lab from which we have to send. Therefore, my lord, saying this, that we have done something secretly, that would not be correct. Lord, again, I will come back on the issue after explaining this. Lord, there is an arbitration clause in the tender. There is no public law matter involved in this issue. Lord, there is a purely contractual dispute between the parties. They have supplied certain drug. We on quality testing as per the policy, which they are already aware of.
Yes.
It is not something we have applied something new, which they are already aware of. We have conducted the test. The test was found not of suitable quality, and particularly each drug is sent to 3 laboratories, not only one. Each drug is sent to 3 laboratories. When majority reports comes to that it is not of satisfactory quality, then only it is declared not of satisfactory quality, and then the order is passed of blacklisting. My lord, therefore, what I respectfully submit is, my lord, I have also annexed all the drugs of all the companies during that period in order to rule out any further possibility of any bias, my lord. My lord, that detail is also there.
Yes.
My lord, it starts from page number 48.
Yes.
From page number 48, my lord, it is the entire detail of all the drugs during that period. If my lord wants to match certain, my lord, on the random basis, may I tell my lord, may kindly have page 49, serial number 8.
Yes.
My lord, here it was, the drug came from Agra warehouse.
Yes.
And the batch number is there, my lord.
Okay.
Thereafter, the secret code is also there, my lord.
So you are telling that this is the format which you are following, not the special only for the petitioner.
Yes. Not only especially for the petitioner.
This is a formula framed by the dealer company, my lord, on their own, my lord, giving a go-by to the Drugs and Cosmetics Acts and the guideline thereof. First of all, my lord, I could come to the point, my lord, they have taken the drugs on their own, giving the labeling, I have no dispute. Given the batch number, I have no dispute. But this is whether they are entitled under law to collect it or not. According to the law, according to law, my lord, I will be drawing your lordship the rule 104, din Joshua the rule 104, read with, my lord, the schedule K. Rule 104, read with schedule K. Rule 104 speak of no person shall alter, obliterate, or deface any inscription or 104 by A. ওইটা দেন না, খুলে পাঠ করতে পারছেন না। Of the drugs rules 1945.
104A.
এই যে, my lord kindly take.
104A. Yes, yes, yes.
104A. Prohibition against alteration, inscription, or container level or wrapped or drugs.
Yes.
No person shall obliterate or deface any inscription or marks made or recorded by the manufacturer on the container, label, or wrapped on any drug, provided that nothing in these rules shall apply to alteration of any inscription made or container, label, drafts, or at the instance or direction or with the permission of the licensing authority. Kindly come, Mala, straightway to the schedule, how it is to be collected. Drugs are to be collected, schedule K. Mala, that is at 416. Page 416. If it tallies with my book, Mala, the 5A, the schedule.
Which schedule?
Schedule.
Schedule?
Is a marked one, Mala, board handy to you.
Schedule?
Schedule K.
Schedule K.
Item number.
Item number 5A.
Subclause 2.
Yes.
Well, this speak of drugs left hand side, drugs supplied by hospital or dispensary maintained or supported by the government or the local body.
Correct.
Now, Mala, kindly come to right hand side, Mala, the answer, the answer given, that is at the top, extent and conditions of exemption. Exemption is available, but the provisions of chapter 5.2 kindly come to. 5A2, the premises where the drugs are supplied or stocked shall be open to inspection by an inspector appointed under the Drugs and Cosmetics Act, who can, if necessary, take samples for tests.
Correct.
Has any inspector appointed? Answer is no. They have not given any.
So how this drugs has been taken?
Drugs have been taken by their own team.
Who?
They have said so, my lord.
Respondent.
They have just now the respondents themselves. Respondents themselves have taken it to the laboratory.
Correct. When from your premises the drugs have been taken, there might be a inventory.
We have supplied the drugs.
Correct.
We have supplied in their warehouses.
Correct.
That's that element that drugs have. If you want to have it tested, you should appoint a inspector. You should approach to the state authorities. State authority, central authority, and central authority will appoint a drug inspector.
You have supplied the material. That's not dispute at all. They have sent for the testing. Correct.
They have sent before sending it there to
Biological test was not
that
important.
was secondary.
Where the inspection? See, you have supplied to the company. Correct. And the company has taken to the and
drugs to the for test laboratory.
Laboratory.
Whether they can take it or not.
Correct.
So they should take it. So they should ask the inspector to come.
Because you have already supplied sent the. So where from the this drugs has been taken?
From the custody of the company, not from me.
From the company.
Yes.
Not
from me.
Correct. From the company. Who is the company?
The dealer is the company.
Dealer is the company. The company has not made any complaint that this drug has been taken without our consent and without our inspection.
No, they themselves have sent it to the laboratory.
Correct. That's I'm telling. So what the materials you have sent to the company, for the confirmation, the company has sent to the laboratory.
But there is a clause that should be done only by
This clause is with regard to the inspection. This clause is if the company so moto wanted that my drugs, my materials, my
sample is to be taken.
Sample is to be sent. If they have sent voluntarily, so where is the necessity of the 5A? 2. It is not that the authorities came to your premises, seized the materials, sent for the safe. It is not the case. If it is the case, then the 5A will be applicable.
It is not a case.
Not a
that-
case.
that-
You have supplied the materials to consent form. Consent.
In that case, normally it is to be collected.
Where?
5A,
Ah.
drug supplied by,
Ah.
once I supply it, then subsequently it is to be tested by
By
inspector. Supplied by hospital,
hospital,
dispensary maintained,
or
supported by government or local body. I have a local body, but I have
Correct.
supplied.
Correct.
That drugs is in the custody of the
Ah.
dealer.
Ah,
Dealer is wanting the drugs to be tested.
correct.
He is to approach to the Drugs and Cosmetics Authority for the purpose of appointment of an inspector
Ah.
or having it tested.
Okay. Okay, then.
That is admittedly not done.
Okay.
Secondly, my lord, this particular drug, benzyl, my lord, is not a drug, my lord, for which, my lord, the microbiological test is required.
That you are already taken note.
My lord, even RTI information I have given, and that provisions of law I have my lord, also drawn to your lordship's attention.
That you already.
Category C and C1 where microbiological required, I do not fall within the said category. My particular.
But our drug is not under the CC1.
My drug is not within C and C1 where you can have it tested
For microbiology.
for microbiological.
Okay.
My microbiological test is not required, and I have been blacklisted because they have found during microbiological test that this drug is not substandard one.
So what about the arbitration proceeding?
Arbitration is
That
not
was
applicable
that was
to that.
my lord, I have very outset, my lord, we had wanted to make our submission to your lordship. We wanted to make your lordship that this is particular something which there is a statutory violation. This is absolutely a statutory violation, my lord. When a particular drug is not at all, my lord, under the law protected by us, my lord, that is not to be microbiological test.
Ah.
My lord, what is the answer to that? They are supposed to, my lord, in the court of law, they are supposed to, my lord, give an answer to that.
Okay.
What the statutory obligation to cast on the authority, my lord, whether can be, my lord, waived by them on their own discretion by making or framing a particular rule. My lord, my third point that was I argued on the last occasion, my lord. My lord, they have, my lord, so far as the microbiological test is concerned, they have, my lord, wanted a report from the, my lord,
Pharmacopoeia Commission.
Pharmacopoeia Commission. That report was given in their favor, my lord, that yes, this particular drug should be microbiological test.
Yes.
That statute, my lord, prohibited when they have to make a gazette notification for that.
There is no gazette.
There is no gazette notification for that.
Okay.
The rule 124. সেখানে IP অনুযায়ী আমাদের রয়েছে IP তে কোনো microbiological test নেই।
The relevant provision regarding the microbiological test that has been highlighted to your lordship on the last occasion by us. That is not required. Lordship will kindly to permit us to the supply was that is 124 of the standard of drugs, my lord. That is under drugs rules, rule 124.
Yes.
Indian Pharmaceutical. Appreciate 1A.
124 1A for drugs included in the Indian Pharmacopoeia, the standards for identity, purity, and the shall be those as may be specified in the edition of the Indian Pharmaceuticals for the time being in force. In case of the timing in force, my lord, that will appear from table 6 of the said
Indian Pharmacopoeia addendum.
In the said Pharmacopoeia addendum to 2022 my lord, addendum, which
there is no specification.
where there the my lord, I had handed up to your lordship on the other day probably that compendium.
Indian Pharmacopoeia.
The India Pharmacopoeia 2022 addendum. Is it there to your lordship? Where, my lord,
Cutaneous use,
there is no provision for cutaneous use,
microbiological
any
test.
microbiological test.
That you given to that.
And the RTI information also we have given to your lordship. That lordship noted on the other day. We put the question to the central government that whether microbiological test is there required or not. Okay.
That's my submission to you.
And
That's
we
all.
have to
Thank you.
determine that there is no IP.
That's all.
Yes.
My lord, on the issue of the drug not being falling under Indian Marcophobia, my lord, may I rely on para 32 of my reply, my lord? Not today, already filed, my lord, on the last day.
Opposition দিয়েছে
Para 32, my lord.
Para?
Para 32. 32. Of my objection filed on the last date, my lord.
Yes. Whether
Lord, my lord, in this paragraph, my lord, I have quoted the question asked in the RTI and the answer given in the RTI.
Yes.
My lords, may kindly have the answer given in the RTI only. My lords, in that table itself, I have mentioned that at para 32.
Yes.
My lord, the test parameters of benzyl benzoate application IP as per Indian Pharmacopoeia 2022.
Correct.
They are saying that the test criteria would be as per Indian Pharmacopoeia 2022.
Correct.
Thereafter, my lords, they are saying monograph and general chapter of IP 2022, namely microbial contamination for non-sterile products, does not include any microbial test.
Yes.
Lords, in this paragraph itself, lords, I have quoted that particular portion, lords, from the, lords, may I read? From the bare perusal of the aforesaid reply given by the State Public Information Officer, it appears that it is only his opinion and is also contrary to the Indian Pharmacopoeia 2022, Chapter 2.2.9, Microbial Contamination in Non-Sterile Products read as under. They are saying for non-sterile product, there is no microbial testing required.
That you already pointed out on the last
Yes,
occasion.
my lord. One thing more, my lords. My lords were on the last date have asked a query to me that why in that table it is not written.
That page 43.
Uh,
Annexus C to the page 43, 41, 41. No, 43. Kindly come to page of affidavit.
Yes, yes, my lord. I have
Accepted.
annexed the pharmacopoeia. I saw not page 43, my lord.
Correct.
My lords may kindly see that 10.2 and 10.1 is there written, and thereafter two further entries are made in the subsequent column, my lord, adjacent column, in the same, my lords. And it does not change. And it does not change still auricular use.
Where from you are reading?
Lord, I am reading that table itself. Table
Page-
6.
Page
Table
43.
6.
Yes.
Table 6, my lord.
Acceptance criteria, microbiological quality of the non-sterile dosage forms.
Forms. Yes, my lord. Then, my lord, may kindly see for rectal use, it is there 10.3, 10.2.
Yes.
Then subsequently it is dash.
Hmm.
Then oromucosal use, my lord, 10.2, 10.10. Then
Yes.
Staphylococcus aureus absent 1 gram or 1 ml. Then, my lord, Genevial use, also there is no mention.
Spontaneous
Lord,
is
then
Our product is
spontaneous is there is no mentioning.
cutaneous.
They are harping upon that only.
Lord, I am just trying to explain why it is not written. It is not written because they all are similar to the aforesaid at 10.2 and 10.1. The moment it changes, they mention it.
Okay.
That is what they have clarified in the RTI.
Okay.
The criteria would be same.
Thank you. Okay, anything further?
My lord, I rest my submission with a submission that not since all these disputed facts are to be considered in the arbitration, the writ court perhaps may not enter into all that.
Okay.
Most obliged, Lord. Most obliged.
Thank
I bow down.
Concluded, CAB. उसमें ना एक ऊपर लिखो लैंड काउंसिल फॉर द रेस्पोंडेंट सबमिटेड सप्लीमेंट्री एफिडेविट after serving copy to learner counsel for the petitioner. Counsel for the petitioner submitted, he will not use any reply to the affidavit. Hearing concluded. See.
Most obliged.
Yes, next.
Item 11, my lord, I beg to appear for the petitioner. On the last occasion, my lord had detected the Mumbai police to my lord appear with the case diaries. Subsequently, my lord, we have received information that the my lord.
You are appearing for whom?
They are appearing for the bank. Subsequently, my lord, the lien that was marked to the account has been removed by them.
Removed.
So, my lord, all the prayers have been my lord, made.
Removed.
It has
become infectious.
It has become infectious. The service be kept on record in compliance of my lord's order.
Affidavit service filed by the petition be kept with the record. Counsel for the petition submitted. Subsequent to the order dated 22nd of July 2026, the bank has defreezed the account of the petition and now the bank petitioner is operating the bank account. Accordingly, he submitted that no further order is required to be passed.
Only, my lord, only the subsequent lien that was marked has also been removed, my lord. The subsequent lien that was marked that has also been removed, my lord, kindly records.
Also removed?
That has also been removed.
Lien also removed?
Because there was a my lord, freezer on the account. We approached my lord.
Lien is also removed?
Lien has also been
totally free?
Totally free.
क्या बोला? Net counsel for the petition submit that the bank has defreezed the account, including the lien account, and as such, no further order is required to be passed. In view of the submission made by the counsel for the petitioner, WP number 132623 of 2026, disposed of. Next.
Well, this is my application, my lord. Sir, affidavit of service, my lord. Well, in this matter, my lord, just my lord, 5 minutes of my lord, the story behind it is that my lord, an insolvency professional was appointed in one of the my lord matters before the my lord National Company Law Tribunal, Kolkata. And my lord, he had proceeded, my lord, with the my lord insolvency proceedings. In the meantime, there were certain issues which were raised. My lord, few of the issues were, my lord, taken care of by an order passed by the Delhi High Court, and subsequently, my lord, there was an appeal made from an order of the, my lord, order passed by the National Company Law Tribunal, Kolkata, which went up to the NCLAT. NCLAT passed an order, my lord, which was challenged before the Supreme Court. Supreme Court said, my lord, that being unbiased or, my lord, without looking into the order of the NCLAT, my lord, a proceeding may be, my lord, initiated as against, my lord, the insolvency professional. Now, my lord, the proceeding which was initiated in a manner, in a biased manner, following, my lord, the NCLAT order, which the Supreme Court had said not to look into. My lord, we challenged it by way of a writ petition. After, my lord, hearing both the sides, my lord, on 16th of July, 2026, Justice Shampa Sarkar passed a detailed judgment, my lord, whereby my cancellation, my lord, of my license as, my lord, an IP, my lord, to act as an insolvency professional was set aside, and, my lord, the judgment has not been appealed against. This is the background story, my lord. Now, my lord, in the meantime, what they do, my lord, immediately upon this judgment being passed and not being challenged, my lord, they issue me a notice. My lord, will kindly come to, my lord, page 36 of the writ petition, my lord, whereby they say, my lord, please see the trailing mail. My lord, sees the date 21st of July 2026, and the judgment is passed on 16th of, my lord, July 2026. Please see the trailing mail with which notice of investigation has been issued in captioned manner. However, it seems email does not appear to have been delivered to you. Accordingly, the email is again forwarded herewith for your information and further action in terms of the notice of investigation in the trailing mail. And if your lordship, my lord, sees the trailing mail. There is an attachment, Lordship will find, which, my lord, is at page 37.
Notice of investigation is issued.
Yes.
Who has issued? DGM.
Yes. Now, my lord, kindly sees page 37, my lord, is the, my lord, grounds on which this investigation is to take place. These are identical grounds, my lord, which were there earlier. Identical grounds. Now, my lord, kindly sees, my lord, I reply to them, my lord, by saying that, my lord, I require some time, and in the meantime, challenging this notice, I have filed the writ petition before this, my lord, which is before my lord today. Now, what they do, my lord, is that they issue me a further notice, which is not part of the, my lord, proceedings before my lord, which, my lord, is, I'm sure, my lord, my learned friend will have a copy, otherwise I'll give him a copy.
No, I have a copy.
This is the latest notice.
This is the latest notice whereby they say that although the application or the writ petition you have filed, but you must kindly see, my lord, paragraph 4. My lord, kindly see, may I read from the top? Please refer to the notice of investigation dated 27/2026 issued to you under the relevant provisions of the Insolvency and Bankruptcy Code and rules and regulations made thereunder. In response thereto, you have informed the board that you have already filed a writ petition being such and such before the Honorable High Court at Calcutta, inter alia seeking recall and setting aside of the notice of investigation dated 20th of July 2026 and other consequential release. In this regard, it is observed that you have not furnished any order of the Honorable High Court staying the operation of the aforesaid notice of investigation or restraining the board from proceeding further in the matter. Mere filing of writ petition does not, in absence of any interim order, absolve you of your obligation to comply with the directions contained in the notice of investigation. Accordingly, you are once again called upon to comply with the notice of investigation dated 20th of July 2026 by furnishing the information, records, documents and explanations sought therein immediately, not later than 6/8/2026, that is today, as the time prescribed in the notice of investigation has already elapsed. Please note that in the absence of any subsisting order of stay or restraint order passed by the competent court, the investigation initiated by the board shall continue in accordance with law. Any failure to cooperate with the investigation or to furnish the information and records called for may attract action as provided under the provisions of the code and be applicable to regulations. Now, my lord, kindly sees the judgment, my lord, which was passed by the Honorable Court, my lord, that's in volume 2, if your lordship kindly takes page double B. No, 3. Sorry, volume 3, my lord. So it starts from 343, but lordship will kindly seize the relevant portion which is at, my lord, page 383. My lord, I may suggest something which would solve the matter is that, my lord, after this judgment, my petitioner also does not wish to continue ever as an insolvency profession. I mean, enough he has had. He has already given, my lord, a notice, my lord, for cancellation of his, my lord, license as an insolvency professional. I can say this, my lord, that, my lord, if that is accepted and Mr. Chaudhary can take instructions, that, my lord, they would once and for all, my lord, this notice goes, I withdraw because I don't want to continue ever. My lord, then this writ petition and I don't need to proceed.
Surrender your number.
No, but then this
will go on. This will ultimately
then,
lead
my
to
lord,
criminal
then, my lord,
liability.
Well, very well. Then let us not go into it. Let us continue.
And I have, my lord,
Let us now continue. Let
I
us not
just
make any more
indicate,
submissions.
my lord, we had, my lord, we know what the IBBI says. It's not my response. IBBI, because of an NCLAT order, they will
This
continue.
is on merit. Let me
No, no,
continue.
no, it's
then.
not on merit. We will continue.
Very well.
Subject to what your lordships hold. Once it was, my lord, the initial steps
What
was
is the allegation?
The allegations, my lord, that is
Extraordinary.
exactly what I'm going to read out, which has been taken care of by the judgment. And there's no appeal, my lord. Well, let us come to page 383, my lord, where the Honorable Court, my lord, has considered the grounds. One of the, my lord, I'm reading paragraph 30. One of the grounds for such inspection was to ascertain whether the provisions of IBC and the rules of the regulations and guidelines framed thereunder and the directions issued by the board were being complied with. One such inspection being held, the report was filed and no infraction of law or violation of IBC rules, guidelines and directions of the board was noticed in respect of the petitioner's conduct as an insolvency professional. Thus, when the said report was in favor of the petitioner and was prepared by a team constituted by the board just a few months prior to the issuance of the show cause notice, such report could not have been ignored. It was all the more necessary for the board to direct an inspection or an investigation into the affairs of the said company before a show cause notice was directly issued on the basis of the order of the NCLAT. Formation of opinion by the board necessitated that a deeper probe in the matter and scanning of the records. Now, this portion is very important. The Honorable Apex Court directed that the IBBI would not be bound by the observations made in the order of the NCLAT and would act independently. And this is exactly what they did, and they have done now also. In view of the procedural irregularities in the manner of the conduct of the proceedings, and the lack of jurisdiction on the part of the chairperson to act as the disciplinary committee, the order impugned is set aside. Reference is made to the direction of Tata Cellular. Then, my lord, kindly comes to paragraph 33 at page 384, because this, my lord, records the Tata Cellular judgment. The IBBI committed an error of law. The order also suffers from gross illegality and procedural irregularity. The lack of jurisdiction and failure to comply with the provisions of section 218 and 219. This is very important. I'll show again they have done it. Are adequate reasons for interference by the writ court. The order impugned is set aside as a whole, because, my lord, they had, my lord, stopped me from acting. That suspended my license also. Although statutory infractions have been pointed out by the respondent number 4, the said respondent did not point out what were the options available to the RP to continue with their CIRP process in the facts and circumstances of the case. It has also been stated whether the decision of the COC would be avoided or disregarded by the RP. The IBBI failed to take into consideration the background of the case and the recommendation of the BIFR. The fact that the audited books of the accounts and other relevant documents were not available is also a significant fact. Secondly, the BIFR had itself declared the company as a sick company. The decision of the NCLT dated 18th April 2024 in a proceeding with regard to renewal of lease in favor of the said company was not looked into. In the said decision, the NCLT observed that the company was not a going concern. Thus, before the petitioner was found to be guilty of not trying to revive the company, such observations of the NCLT ought to have been taken note of. An inspection or investigation into the affairs were thus all the more necessary. It is also pertinent to mention that the application in which the NCLT observed on 18th April 2024 that the company was not a going concern had been filed by a subsequent RP who was appointed after the petitioner has been removed and his registration has been cancelled. So, for the ground for which I was removed, my lord, the same thing the next RP has done, but I am penalized for that. Another order dated 7th March 2025 of the NCLT is also relevant in as much as the same would indicate that the said company did not have any audited records or any records, and for that matter the RP had appointed experts in order to obtain relevant information and help in revisiting the claims. Thus, whether the inability of the petitioner to collate the claims was genuine or was a dubious act of gross illegality and dishonesty which necessitated the cancellation of registration ought to have been probed deeper by the IBBI. By adopting the mechanism provided under, my lord will kindly mark this very important, section 218 of the IBC. In this case, an inspection or investigation was necessary before the board deemed to fit to issue the show cause notice. The show cause notice is also set aside. There cannot be any estoppel against a statute, even if the SLP was withdrawn by the writ petitioner and liberty was granted by the Honorable Apex Court to contest the show cause notice. Non-compliance of the mandatory provisions of section 218 could be raised at any stage. Enforcement of statutory provision cannot be prevented. The conduct or representation or behavior of the writ petitioner cannot override the law. However, liberty is granted to IBBI to act and proceed according to law on the self-same issue. Now, my lord, this paragraph 36 can be, my lord, a cause of action for the, my lord, issuance of this notice. Now, my lord, therefore, in terms of this judgment, which is not set aside, which has not been appealed against, not to our knowledge, my lord, therefore the law has to be followed, as has been, my lord, stated herein also, that a section 218 proceeding has to be drawn.
Correct.
Now, my lord, kindly comes to the notice. They do
But you come to this, the page 44, first paragraph, second line.
My lord,
First
page,
paragraph, last line, page 44, 386. 386, first paragraph, last but one line. In this case, an inspection or investigation was necessary before the board.
Correct. Correct.
It should know. Now the investigate the so-called
no,
was set
that
aside.
is exactly where I'm coming. Absolutely right, my lordship is saying. An investigation and my lord, inspection is necessary in compliance of section 218. Now, my lord, let us see the notice. Let us come back to the notice. I am grateful to my lord. They make the same mistake again. Or purposefully, my lord, in order to continue against me. My lord, kindly takes page 37. Upper court. 81 টা দেখাবো তারপর 218 kindly takes page 37. The undersigned has been tasked to conduct an investigation in the matter of in-cab industries under the Insolvency and Bankruptcy Code 2016, read with Insolvency and Bankruptcy Board of India Regulations 2017. My lord, kindly sees, accordingly, a notice of investigation under Regulation 8.1, not 218. 8.1 of the inspection regulations is hereby served upon you. So first anomaly. Now, my lord, kindly takes 8.1.
Is under 218.
Let me complete. I am saying what is the law. Mr. Chaudhary, you have done it there, you have lost it, better appeal. Kindly seize, my lord, regulation 8.1. Eight one is the procedure. It's not the, my lord, substantive law, which is 218. Kindly seize, my lord, 8.1. বার করে দিয়েছো লর্ডশিপকে? Lordship, the page, may I just indicate, my lord? I'll just take it out for my lord. আরে বার করে দেবে, just one moment. বার করেছো? ওটা দাও, দিয়ে দাও তো। বার করে দিয়েছো পেজটা। Followed, kindly sees the heading, conduct of investigation. The investigating authority shall serve a notice of investigation to the service provider at least 10 days before the commencement of investigation, provided that where the investigating authority is satisfied that the notice will cause undue delay in investigation, or there is an apprehension that the records of the service provider may be destroyed, mutilated, altered, falsified or secreted after the notice is served, it may, for reasons to be recorded in writing, dispense with such notice. Then, my lord, the investigating authority may require the service provider or an associated person to submit records as may be required before the commencement of investigation. Investigating authority may visit the offices of the service provider for conducting on-site investigation. Now, my lord, if 8.1 is taken, it is only, my lord, for the purpose of serving a notice of investigation to the service provider with a time of 10 days. It does not say under what provision, my lord, the investigating notice is served. And that is why the Honorable Court was skeptical, my lord, in quoting 218, which was, my lord, quoted at page, my lord, as I showed of the judgment. Now, my lord, sees what is 218. This notice is not under 218. Lordship has got 218, otherwise. Now sees, my lord, what is 218. And this was the violation which they had made lastly also, where it has been set aside. This is where, my lord, comes the law.
218, my lord, is investigation of service providers. So what should the notice contain? Where the board, on receipt of a complaint under section 217, or has, so my lord, I stop there. There is no complaint under 217. Or has grounds to believe that any service provided has contravened any provisions of the code or the rules or regulations made or directions issued by the board thereunder, it may at any time by an order in writing direct any person or persons to act as an investigating authority to conduct or an inspection or investigation of the service provider. Now, my lord, the second part, my lord, has not happened because there is no opinion formed. That's also dealt with in the judgment. Now, my lord, therefore, the two limbs of 218, one, my lord, a complaint, second, my lord, an belief of a reasonable ground or an opinion, that is also not there. That is not quoted in the notice itself.
Yes. Issue to them.
Now, my lord, kindly sees the second anomaly, my lord, in the notice. Lordship has seen the judgment says, as my lord done by the Honorable Supreme Court, my lord has directed not to be influenced by the NCLT NCLAT order.
Yes.
Now, Lordship takes paragraph page 37 once more, the second paragraph. Huh?
Yes.
Now, my lord, paragraph page 36, Lordship takes once the mail, very important. I want to show what is attached and what they are relying upon. My lord, just below, my lord, the mails that are sent, there is one attachment. Lordship has found at the top, my lord.
Yes.
Kindly sees, my lord, the same NCLAT order dated 4th of June 2021, which is relying upon. Now, my lord, kindly comes to page 37, paragraph 2. You are hereby required to submit your reply to the observations regarding violations and contraventions of the provisions of the code and relevant regulations thereunder with regard to COC constitution and inclusion of related party creditors to the CO in the COC and assignment of voting rights to such creditors as contained in the order of 4th of June 2021. This is the same, my lord, NCLAT order, which Lordship will find from page 119 to 200 of volume 1. Same NCLAT order. Now, my lord, kindly takes the Supreme Court order, my lord, which is at 334 of the of volume 2, my lord. No, volume 2, bolo. Volume 3. Volume 3 of it? Sure. No. No, volume 2.
Yes.
334 if your lordship takes, my lord.
Yes.
My lord, kindly sees this order. This is exactly the order which the Honorable Court also has dealt with. Learned senior advocate appearing for the appellant states that he has obtained instructions and the appellant is ready and willing to withdraw the present appeal and raise all issues and contentions before the IBBI in terms of the directions given in clause G. Well, clause G is at the top. If your lordship sees the top portion of the order, on the last date of hearing, we had asked learned counsel appearing for appellant to obtain instructions in view of directions given in clause G to paragraph 88 of the impugned order dated 4th June 2021 passed by the National Company Law Appellate Tribunal. Clause G of the impugned order is read as follows. Copy of the present order may be sent to IBBI for further actions which may be deemed to be fit, if any, against the earlier resolution. So, my lord, this is quoted from the NCLAT order. Now, my lord, kindly sees what the Supreme Court says. It is, however, submitted that there are certain observations in the impugned order, that's the NCLAT order, which may adversely affect the appellant. We have also heard learned counsel appearing for the workmen who state that they have no objection and in fact would like to file certain papers and documents before the IBBI. In view of the statements made before us, we permit the appellant to withdraw the present appeals without foreclosing his rights to challenge the impugned order if required and necessary at a subsequent stage. It will be open to the appellant to raise all pleas and contentions before the IBBI in terms of the directions given in clause G of paragraph 88 of the impugned order dated 4th June 2021 passed by the National Company Law Appellate Tribunal. IBBI, this is very important. This is exactly what is quoted. IBBI will not be bound by the observations made in the impugned order and would independently apply its mind. If that is so, then my lord, why is he asking in paragraph 2 again? When this, my lord, the writ court of this honorable court has set aside the entire, my lord, proceedings on this ground itself that they were influenced by this order, to my lord, a notice issued to give me a reply on the facts and circumstances as raised in that order of my lord NCLAT.
Yes.
And now, my lord, kindly sees, my lord, as Justice Shorka's order, my lord, has showed that, my lord, it categorically records at 343, my lord, kindly. Kindly takes, my lord, that portion of the order. My lord, 383, my lord.
Yes.
Towards the middle, I am sure lordship has marked it. The Honorable Apex Court directed that the IBBI would not be bound by the observations made in the order of the NCLAT and would act independently. So therefore, my lord, first of all, his lordship's observation after setting aside was that you have to proceed against 218, which has not been done. This is a notice, my lord, under 81, which is a procedural part, to issue a notice. And then, my lord, the second one is that they are not to be bound as directed by the Supreme Court by the NCLAT order. That also, my lord, paragraph 2 says, my lord, that I am, my lord, to reply on all the contraventions, my lord, and violations as recorded in the order of 4/6/2021, which is the NCLAT order.
Okay.
Now, my lord, apropos this, my lord, I say, my lord, that, my lord, this notice is, my lord, in view of the order not being challenged of the Honorable, my lord, single bench, my lord, of the writ court, where, my lord, the detailed judgment has been passed, and it is not challenged by them, my lord, could not have been passed at this stage, even though it says, my lord, that they can proceed in accordance with law, but they have not. I would have understood that they have. My lord, needs to be stayed, my lord, till, my lord, affidavits are called for, and we can, my lord, thrash out the proceedings before, my lord.
Yes.
Lord, before the, I'm not reading the judgment in detail. Lord, before the learned single.
No, once the NCLT order has been passed, was not to take on, then again, why you are giving the NCLT on the basis of the NCLT order?
NCLAT.
36, NCLAT order.
I'm sorry, my lord.
Page 36.
So my lord, there is no direction by the Supreme Court that I can't, my lord, take any action.
No, take any action, no. If
So everybody says you take action.
correct, you take action under 218.
Yes.
Under 218, investigation inquiry can be conducted.
Yes.
Conducted, but kindly come to the page 36.
Yes. 36.
36, what is the notice?
Yes.
Again, you are relying upon the NCLAT order.
Yes. Yes, NCLAT order.
NCLAT order, you are relying upon.
One attachment is the NCLAT order.
Correct. So you are relying upon that.
My lord, that's
Attachment means what?
information.
Attachment with what? So you are giving the notice that this is the order of the NCLAT. So that's why we have issued the notice for investigation. Please submit the record. So if that be so, then what is the meaning of this Apex Court order and the order passed by this court, page 383?
Yes. My lord, no one says that you don't do it.
I am not. That's why initially I'm to inform that this is an investigation notice.
Yes.
But the notice should be independently in terms of section 218. Correct. But you, in the face of the record, you attach the NCLAT order.
Lord, may I explain what has happened? I don't think my learned friend, my lord, he has been, my lord, very candid about what has actually been argued, what has been held, which is why, my lord, the IBBI has accepted the judgment of the learned single judge, except on one issue for which we are filing an appeal. But that's not related to this. That's related to whether the chairman can act as the disciplinary authority. Apart from that, we will not challenge. We'll accept it. Now let's, my lord, put it into sequence. What has happened?
Number one, my lord, my learned friend's client is appointed, my lord, as the resolution professional. What he does is,
It will take time.
yes, it will take me not, maybe 5 minutes I'll just take today, and then, my lord, your lordship will ask me to come back whenever your lordship.
But today is the date 6th August.
6th.
No, my lord, I'll finish by 1:15, I'll finish. I'll take 10 minutes, I'll finish. So RP appointed, what does RP do? He does 4 things. The promoters related parties are allowed to control the CIRP. Number 2, he inflates their claims to such an extent that the banks, my lord, are all minorities. And using them on the COC, he drives the company into liquidation. My lord, matter goes up before the end. So liquidation order passed, matter goes up before NCLAT. NCLAT, my lord, says this is extraordinary fraud. My lord, just one paragraph of the NCLAT order. Page 197. Paragraph 86.
197.
Yes, my lord, para 86.
Yes.
We have noticed role of RP liquidated, etc. We think it proper to change the RP. The above discussions show that the resolution professional failed to discharge duties and responsibilities cast. Kamala and Fasqua are related parties that were made part of COC and were in a commanding position to rush to the decision to liquidate the corporate debtors. Facts show that the CIRP was initiated in view of Section 9 of IBC. Petition was admitted on 7th and 5th COC was held on 8th, which is within 120 days to 2 days. Decided to liquidate the company. COC had 2 entities holding majority voting rights. However, their claims were not even admitted and they were also related parties, and thus the process before COC got vitiated in view of the extraordinary facts of the present matter and the disputes raised by the many workers through the appellants. Interests of justice require certain directions. So, my lord, they were rebooting of the CIRP because he did nothing for 2 years.
Correct.
And see, my lord, what the NCLAT says. Paragraph 88. At page 200. 200. That.
Yes.
My lord, D, my lord, 199. He is, my lord, handed complete charge. He is, my lord, removed. He hands over charge to others. And G, order be sent to IBBI for further action, which may be deemed fit, if any, against the earlier resolution professional. This is the NCLAT order. He challenges this NCLAT order, goes to Supreme Court. My lord, see the Supreme Court order. Page 334. My learned friend's interpretation is not correct. 218
Upheld by the
It is wrong.
by the
My lord, what he says. My lord, please see this. On the last day of hearing, we asked learned counsel for the appellant. It's his SLP to obtain instructions. In view of the directions given in clause G of 88 of impugned order, clause G reads as under. My lord, what I read out. Learned senior advocate appearing for the appellant states that he has obtained instructions and the appellant is ready and willing to withdraw the appeal and raise all issues before IBBI. By this time, my lord, the show cause had been issued in terms of clause G. So he says, I won't proceed in Supreme Court. I'll raise all issues before IBBI. It is, however, submitted that there are certain observations in the impugned order which may adversely affect the appellant. We have heard counsel for the workman. Next page, my lord. In view of the statements made before us, we permit the appellant to withdraw the present appeal without foreclosing the rights to challenge the order if and when required. It will be open for the appellant to raise all pleas and contentions before the IBBI in terms of the directions given in clause G. So he says, I will participate, and he's been given liberty to take every point. Now, last sentence. IBBI will not be bound by observations made in the order and would independently apply its mind. So I am not bound by the observations. My lord, if I were to be bound, then I would immediately, without doing anything, have to, my lord, suspend him.
That's why this.
It doesn't say you can't act on it. Now, my lord, see 218. He is, my lord, not putting facts correctly. Please see 218.
Two?
21, section 218 of the IB, my lord, the Insolvency and Bankruptcy Code. Where the board, 2181, where the board, I'm sorry, my lord, it's a very complicated book.
That's
My lord, if,
And every day it changes.
yes.
Every,
My lord, now, my lord, when
three
NCLT
months.
was here, I had several copies. Now, my lord, I have given up.
And one has to be very careful. Some of the copies also have some rules which are not
I
there.
have to finish at 115, otherwise you'll ask for interim order.
As it is, I will. As it is, I have.
218.
Yes.
Where the board on receipt of a complaint under 217. So, my lord, there has to be a complaint under 217.
Yes.
Or has reasonable grounds to believe that any service provider has contravened any of the provisions of the code or rules, may by an order in writing direct any person to act as investigating authority.
Correct.
So, my lord, two things can happen: complaint under 217 or grounds to believe that there is contravention.
Yes.
Now, my lord, once 218, and so the board will direct
Yes.
investigation.
Yes.
Next, my lord, is 219. Upon completion of investigation, show cause. My lord, this is, please.
Yes, yes.
This is the my lord, scheme. Now, argument, last time, my lord, what we had done was, we did not do any investigation. There is a routine inquiry which is made every 6 months for all companies. So we referred to that inspection report and we said that because of this phrase, my lord, I'm sorry, my lord, please see 219, where the board upon completion of inspection or investigation under 218 or on the basis of material available on record, then I proceed. Show cause. So, my lord, I had argued that you don't need any investigation. You can proceed on material on record, which is the enclad order.
Correct.
Court said no, you must investigate. I lost. I've accepted the judgment. Now, my lord, see 218. What does it say? 218 says that I have reasonable grounds to believe that there is
no dispute with regard to issuance of notice, investigation. Both all courts stated that the investigation can carry out.
Yes.
He is not telling the investigation cannot be carried out.
Yes.
But with regard to this notice under which.
Lord, see, my lord, please see, my lord, this is absolutely, my lord, not proper. Kindly, my lord, see the notice now. 387.
380?
387. My learned friend, my lord.
Oh, acha, acha. I have no notice.
Please see at the top, my lord.
Yes. That is the same, 36.
Oh, I'm sorry. I've given the wrong page number, different page number.
Yes, 36.
Undersigned, my lord, please see paragraph 1.
Correct.
Undersigned has been tasked to conduct an investigation. So who's asking him? IBI. Now, my lord, please see section 218.
Yes.
Second part of subsection 1.
Yes.
It may, at any time by an order in writing, direct any person or persons to act as investigating authority to conduct an inspection or investigation. So, opinion of the board, if board is of the opinion, board will not direct somebody to conduct investigation. Now that somebody is, my lord, Mr. Keshav Girdhari. Now he has received this direction. See the first sentence of the notice. the undersigned has been tasked to conduct an investigation. So, my lord, he has received communication from the board. Now, what does he do? He has to proceed under Rule 8. My lord, please see Rule 8. এটাতে জজ সাহেবকে দাও এটা আমি দিচ্ছি এটা Let's see Rule 8.
Yes.
This is regarding conduct of investigation.
Yeah.
So appointment, my lord, is under to appointment of the investigator is by the board upon the board forming an opinion. Once board, my lord, forms opinion, it directs an investigator to do investigation. Now that investigator will issue notice under Rule 8 and proceed with investigation. He is showing your lordship the second notice and pretending, my lord, it's the notice of the board.
Second notice.
My lord, there are two steps. Board to investigator, investigator to him.
Correct.
So, my lord, he is showing investigator to him.
Correct.
And he's saying that he's showing the section and saying this is like board to investigator. That is the fallacy, my lord, with respect to my learned friend.
So, under which section the investigation is?
218.
218. Okay.
218, my lord, please see the notice now.
That's why you kindly come to the notice.
Yes, this is the second step. My lord, please see paragraph 1. The undersigned has been tasked to conduct an investigation.
Which
has been tasked.
From your reading.
My lord,
Where from your reading?
page 388 plus page
Page 37 at the top.
37 at the top. The undersigned has been tasked to conduct an investigation. That is 218. In the matter of INCAB. Accordingly, read with IBC, read with IBBI regulations, second sentence. Accordingly, a notice of investigation under 8.1 of the inspection regulations is served upon you. Now, my lord, see Rule 8. 8.1. The investigating authority shall serve a notice of investigation to the service provider. So, my lord, under section 2, my lord, summarize this argument. Under section 218, board will appoint investigator or investigating authority. Investigating authority under Rule 8.1 will serve notice of investigation upon him. That is what has been done.
Yes.
What my learned friend shows your lordship at page 37 is the notice under 8.1.
Yes.
And he has received a notice appointing him as investigator under section 218. So that's board, IBBI to investigator. And this is investigator to him under 8.1.
Yes.
My learned friend says,
okay,
he is, my lord, confusing the second with the first. Second point, your lordship's, my lord, prima facie observation.
Yes.
Why are you relying upon the High Court, the NCLAT order, when the Supreme Court says, my lord, don't rely on it? Answer, my lord, is Supreme Court says you're not bound by it.
Correct.
So I am not, my lord, if I were bound, I wouldn't carry out investigation.
Correct.
Because his case is over in NCLAT. My lord, so I have to form an independent opinion. So, my lord, and now what is the material that I have? The NCLAT order. NCLAT directed the order to be given to me. Based on that, I am forming prima facie view. I am giving notice in terms of the earlier judgment of this honorable court, and I will proceed.
Okay.
My lord, it's, my lord, just once more, my lord, that sentence of the Supreme Court order, which is being misconstrued. Yes. Further, IBBI will not be bound by observations. Will not be bound means that the findings, my lord, are not binding on me. I will have to conduct investigation. I will have to, after conducting investigation, give him a show cause. He'll reply. DC will hear him and pass judgment. So nowhere are we saying we are bound. This is only some material. And why are we relying on this, my lord? Please see section 218. Please see section 218 once now. Oh, এটা তলায় না? 218, my lords, starts with complaint or other material available. My lord, NCLAT judgment has come to me. That is material available. On that basis, my lord, I have come to know. I'm appointing investigator, as my lord Justice Sarkar has said.
Yes.
And the fact that I'm not saying I'm bound by findings. And Justice Sarkar, my lord, has directed this to happen.
Yes.
So if he follows the judgment, then he has to do this, my lord. Kindly see, my lord, just to whether he is at all entitled to, my lord, maintain this writ petition at this stage. My lord, please see the judgment, my lord, paragraph 34, page 386.
With judgment.
Justice Sarkar's judgment, my lord. In fact, I'll go a little before that. Please see, my lord, 376. My lord, I was faulted because I didn't do investigation. Now, when I start doing investigation, he wants to stop me.
Naturally.
No, I don't
My lord,
want to.
no,
Unless
wait, wait.
unless and until you have not been restrained, so how he will survive?
I'm sorry, my lord. Unless, my lord, just 1 minute, my lord. Paragraph 27, chapter 6 deals with inspection investigation. Section 218, then the last 4 lines, page 376 at the bottom. According to Mr. Kaur, my lord, please note this.
Yes.
My lord, diametrically opposite stand today taken. According to Mr. Kaur, unless an investigation with regard to the move in which the writ petitioner has acted was ordered by the board.
Okay, okay.
Lordship has seen that. Exactly the opposite, ordered by the board. Now, my lord, show cause can't be given. Page 377 are my misconceived arguments. Then, my lord.
Okay, okay, complete. See,
My lord, my lord, para 228. No. Para 20, just 1 second, my lord. Para 28 under 218 does not contact issue if the board has, my lord, please see to 3 para 28 second line. If board has reasonable grounds, then direct investigation.
yes.
And then 219 and then, my lord, 380 clear, my lord, indication. And lastly, my lord, para 34, para 36 clear directions to do this. And his submissions, my lord, Mr. Kaur was, my lord, leading him, are totally, my lord, contrary to what he is arguing today.
Okay.
Or may I just take,
And why will you not face investigation? Give a reply.
may I just take 2 minutes by the clock? Or first of all, I don't know why he's saying this. I am not against investigation. I want investigation as directed by Justice Sarkar in accordance with law. Now, my lord, first thing, all these, my lord, allegations which, my lord, my learned friend wanted to re-agitate, page 345, all this has been argued and has been set aside and taken consideration of in the judgment. No appeal, so lordship is not sitting in appeal. Secondly, my lord, page 383, Justice Sarkar records Honorable Apex Court directed IBBI would not be bound by the observations made in the order of NCLAT and would act independently. My lord, 383.
That's what you are doing.
Please, I did not speak a word, Mr. Chaudhary. I expect this
You are
much from you.
Repeating what.
No, I'm not repeating. I'm answering you. My lord, towards the middle, page 383. The Honorable Apex Court directed the IBBI would not be bound. Lordship has got it, my lord.
Yes.
By the observations made in the order of NCLAT and would act independently. My lord, the Supreme Court order, my lord, at page 335 says, further, IBBI will not be bound by the observations made in the impugned order and would independently apply its mind.
Correct.
Now, my lord, kindly comes to page 37. 36, lordship has seen the, my lord, crust of his investigation is, my lord, the NCLAT order which he has attached. which both courts have said not to look into or not be bound.
He said that.
Be bound by the observations. Now, my lord, kindly comes at the top. He says, undersigned has been tasked to conduct an investigation. 218 says a complaint, no complaint. Second is, my lord, an opinion of the board. No opinion of the board is discussed here. 218 is not recorded. He says only regulation 81. Now, my lord, paragraph 2 says, answer all queries of, my lord, kindly sees the word. You are hereby required to submit your reply. Kindly mark to the observations regarding violations of the order of the NCLAT. So, my lord, it is observations which he is only relying upon. Kindly sees, my lord, the two orders of Justice Sharkar. The observation, Supreme Court saying not to be bound by the observation of NCLAT. And what is he saying? You are hereby required to submit your reply to the observations regarding the violations, contraventions of the court in terms of the order of 4/6/2021. And next paragraph, kindly sees is, but therefore, my lord, I say he can continue with the investigation, file afresh. There. So it's the observation.
Yes, call the other matter.
Grateful, my lord. But kindly considers, my lord.
Paragraph said NCLAT observations, NCLAT word is not there.
Increase the order is 4/6/2021. It is NCLAT order.
Doesn't say NCLAT.
Grateful, my lord. My lord, lordship can keep the book for the time being, my lord. Let it be, my lord.
Take back.
Great.
If your lordship permits, 4:30 would be the best time to take these matters.
I am having a fixed matter, we will continue till 4:30 at before my.
এই, আজকে না অন্য দিন। সব কথা তো বলবি জানা না
আমার যারা আমি বলবো না কে বলবো
হ্যাঁ ওই না লাঞ্চ খেতেও তো সময় পাবে না শুধু নাম স্লিপ বাকি
আপনি কি করে
হ্যাঁ আছে বুঝতে পারছি হ্যাঁ
প্রত্যেকটা ফাইল দিও না গন্ডগোল হয়ে যাচ্ছে যে এসআইআর মামলা নেব ফাইলগুলো এক একটা বার করে দিলে থাকবে এসআইআর মামলা এখানে মেনশন করবে আরেকজন কেউ মেনশন করবে আজকে আইটেম 2 ছিল স্যাটারডে হচ্ছে আরেকটা হচ্ছে আসবে নিজেই
Yes.
Item 86. For our qualification, this matter, my lord. If your service be taken on record. 80. Start from page 80.
Dispose of.
87. It's also mine, my lord.
18
Page 18.
তো লর্ডশিপ ফিজিক্যাল আছে
Disposed of. Next.
Item 88.
I am for Union India.
Start from page 17.
Disposed of.
ওই তো বলছি your lordship in these two matters there are no online appeals this epic number
Just be annexed. Just be annexed.
কোথায়
Give the file. 86, 87, 88.
হ্যাঁ তো
It is there. It is
হ্যাঁ
there.
হ্যাঁ ঠিক
In each and every matter, it is there, madam.
Yes, next.
Item 89 is also mine, my lord. The appeal starts from page number 18.
Disposed of.
Item 90.
যে নেই ওর করো না ওই পরে গিয়ে গন্ডগোল করছে
Dismissed. 90 dismissed, 91 dismissed.
Page 54, Your Lordship.
None appears on behalf of the petitioner.
Lordship, 54 page.
Which one?
91, Your Lordship.
The court is sitting here, calling you, why you are not telling?
Lordship.
Disposed of. Disposed of. Disposed of. Disposed of. That will, no, was list it is. The case file. Correct in the petition. It a note code. What is?
Filing section, while filing section, the entry which is made, it is incorrect.
Yes, next.
95.
95, Malda, I'm for the petitioner, page 29.
This was of.
Appeal of service.
I'm for the petitioner. 34 is the Your Lordship, the appeal number. Your Lordship.
7.
So 97 is Your Lordship, the page number 29.
This was of.
Your Lordship, may I?
98, my lord.
This was of.
99. My lord, I'm for the next one.
99.
My lord, I'm for the
Page number.
Yes, my lord. Oh, acha, ठीक है. 99, my lord. Page number. 1 minute. Page number 36.
আগে থেকেই বলেছিলাম
This was of.
100, my lord. I'm for the petitioner. Page number 26.
This was of.
101, my lord. I'm for the petitioner.
This was of.
Page number 22.
102, I am for the petitioner, page number 43.
This was of.
My lord, I've got the petitioner, page number 33.
This was of.
Lord, I've got the petitioner, my lord, page number 30.
This was of.
My lord, I'm the petitioner, my lord. Page number, my lord, 36. 36.
This was of.
My lord, I'm pretty sure, my lord. Page number 30, 40, 43, 43. 43, my lord. Page number 43.
This was of.
I have petitioner, page number 52.
This was of.
My lord, I am the petitioner, page 19. It is, my lord,
No.
extreme urgent matter, my lord. Kindly see, my lord. There is the export business is there, my lord.
Business is not a.
My lord, passport is withheld, my lord. Passport withheld, it is need to go there, Bangladesh, my lord. Some goods is withheld, my lord. Kindly.
Which one? Item number?
Apply for the online application.
But counsel for the petitioner submit that the petitioner is a businessman and having the passport, but due to the deletion of the name of the petitioner, the petitioner is not in person to visit the foreign country for the purpose of his business. He has filed an appeal and appeal is pending before the appellate tribunal. This for expeditious disposal of the appeal. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to dispose of the appeal prepared by the petitioner as early as possible, preferably within a period of 4 weeks from the date of receipt of this order. Yes.
Yes. Grateful, my lord.
Disposed of.
110 lots of for the petitioner. This is the affidavit of service.
Page number clear.
Lordship, this is. Lordship, there is more than one petitioner. Lordship, start from page.
No, they are the family members.
They are all the family members. Kindly see the address.
How it is the family members?
Lordship, the address on the same village and.
Whether they are the family members or not. Mother, father, son, daughter. They are the family members, nothing else.
No.
If it is not, then I will dismiss the immediate petition.
Kindly dismiss it, Your Lordship.
Only mother, father, son, daughter. That's all the family. I will consider and daughter-in-law and daughter-in-law. That's all. Otherwise, no.
Problem is the chair is.
This court find that the petitioner has filed the present date application consisting of.
That's the 30 petitioners before your lordship. Kindly see their address.
30 33 petitioners. Thus, this court find that the writ petition is not maintainable. According, writ petition is dismissed. However, the dismissal of writ petition will not debar the not prevent the petitioner for filing separate application for and direction.
233 lots of let no lots of Kylie 233 lots of petition number 1 let the petitionable 26 so far petition number 1 is concerned lots of Kylie appreciate.
Yes,
Let the petition
26.
lots of petition
This was
33 lots of not press and so petition number 1 is concerned lots of let this petition number 1 is allowed
112
আগেও similarly অনেকজন dismiss হয়েছে
dismissed, none appears, dismissed. Next, 113
My lord, I am for the petitioner, my lord, page 28.
disposed of. Disposed of.
I am not keeping my lord.
Huh? Three brothers. Court fees paid. Court fee paid.
Page 55. 65.
Disposed of.
Lordship, I am for the petitioner, page number 35.
Disposed of.
Page number 32 32
Disposed of.
Page number 22
Disposed of.
Page number 26 page number 23 page of 23
Disposed of.
page number 78
Disposed of.
supplementary evidence.
Yes, next.
Stand copy দেওয়া আছে।
Okay, okay.
হ্যাঁ।
Dismissed.
দিতে বলছি এই নম্বরে স্ক্যান কপি পাঠাইতে বলছি নির্বাচন করছেন
Stand copy.
Dismissed.
29 for the petitioner affidavit service 20 page number 20 পাঠাইতে বললো
And for the petitioner, my lordship, there is only offline appeal have done by the petitioner, no online app. Epic number টা দাও, paper epic number টা।
page number 42 এই লিখে দিন দাদা
Given
page হ্যাঁ অনেকজন সব বাড়ির লোক my lord
The petitioner has filed and the name of the petition has been deleted from the voter list. Accordingly, the petitioner has filed an appeal.
পাঁচজন
An appeal. A physical appeal before the appellate tribunal. Being appeal number, epic number WB/41/281/162508. They submit that 208. When you filed,
কবে ফাইল করেছিস?
request for direction upon the appellate tribunal to dispose of the appeal as early as possible in view of the submission made by the counsel for the petitioner. The petition director the appellate requests us to dispose of the appeal as early as possible, preferably within a period of 3 months or later. Next. Page next.
Lordship, I am for the petitioners, page number 33.
Dispose of. Page number. Disposed of.
My lord, I am for the petitioner, my lord. My lord, there is a, I am the son and father. My last application is on both sides, and I have mentioned that respondent number 4 also direction me because my form C not allowed. In my case,
What type of the submission you are making? This is a way.
पर ये जाएगा ये खूब मुश्किल है
petitioner number 1 is the son and petitioner number 2 is the brother. My kind then main issue is
What is your prayer?
caste certificate given. My prayer is form 6 kindly direct for the petitioner number 1 and petitioner number 2 appeal ID, my lord.
Appeal is pending.
Yes, my lord.
Page 37.
Yes, my lord.
Then,
And please 35
ah,
35 form
ah,
6
ah.
for the petitioner number 1.
So how is the two petition, two cause of action, one petition?
My petition is required.
Page 37 of which petition? Page 37 of Ajay Sarkar.
একজন তাই আলাদা করবি?
My, actually, my caste certificate is required.
The
My caste certificate.
so in the present writ application, there are two petitioners, but only the petition number 2, namely Ajay Sarkar, has filed an appeal, and the same is pending before the appellate tribunal, being appeal number APS 2509 G 070 42690 4228, dated 7th April 2026. Counsel for the appeal submitted. The appeal is still pending before the appellate tribunal and prayed for an order for expeditious disposal of the setup. But that has also been dismissed. That appeal is also dismissed. What is the page 39?
Page 30. Appeal pending.
What is the page 39?
Page 39 is the similar order.
What similar order?
Page 39 is the final,
No order. Order. Next. Next.
My caste certificate.
Page 38.
Draw করে নতুন করে ফাইল কর।
Page 28.
Disposed of.
129, my lord, after filing the writ petition, his name already include, my lord. Her name already include.
Dismissed, dismissed.
Counsel for the petition submitted. The appellate tribunal has already considered the matter and his name has already been included in the voter list. Accordingly, writ petition is become infectious and disposed of. Next.
Also same, my lord, already name in.
Same order. No order. Next.
DM.
Next. Next.
Page 31.
Disposed of.
133, मतलब there is extreme urgency, मतलब petitioner is a appointed candidate of WBCS Group C, मतलब petitioner police verification all are withheld, though lower rank candidate got appointment.
Post.
मतलब
Which post?
Group C, मतलब
WBCS Group C, my lord. Pardon me, my lord. WBCS Group T, page number 45, my lord. The petitioner rank is.
না
Your Lordship,
Yes,
there is few SI matters were left, my lord. Maybe please come back at 4:30 PM, my lord.
let the all members go to the bar, learn the decorum of the court, then come. One man advocate is mentioning, making a submission, the same advocate is through the video conferencing. So if you persons are not having the decorum, maintain the decorum of the court, I will not take the matter. It's morning hours also mentioning the same thing is happening. You persons are not hearing the court, all are mentioning. I am taking the SIR matter every day. One by one I am calling. One junior advocate is mentioning here, the senior is arguing from the website, online. So if the senior is not having the faith on the junior, why he is allowing to argue the matter?
My lord, very unfortunate. My lord.
I am taking the matter in the lunch hour. I know it is an urgency matter, but you persons are not understanding what the court will do. I am not telling I will not take the matter. Then,
Very unfortunate, sir. My lord.
and that to a senior advocate. If he has given the brief to the junior, junior is arguing the matter, I am putting the question to her, he is giving the answer over there. Come at 4:30 SIR matter.
Obliged, obliged, my lord.
My application, this matter, your lordship was pleased to hear on the.
Yes.
Lordship, it will come back to your lordship's mind. There was no problem in the tender itself. The tender stipulated that reverse auction will be done, and after reverse auction, the selection will be done on the basis of the procurement policy. Procurement policy has a clause 6, which says that if the bid of the MSME bidder is within the band of 15% of the L1 bidder, then MSME bidder has to be given a chance to match that bid. That was violated here. And during the argument of the initial stage, your lordship will recall the sale was taking one stand. GM portal, on behalf of GM, it was argued on the basis of their communication that buyer, in the case being sale, they had not opted for the MSME option. Therefore, the bidder, my client, was not at fault. Because sale treated me as an MSME bidder, I was exempted from furnishing the usual guarantee and everything, earnest money deposit. So on that basis, your lordship has passed an order on the basis of their own order that no final work order shall be issued particular date.
Yes.
Now, my lord, when the affidavits have come, the lordship will find that sale is taking the same stand. Sale accepts, my lord, that they have accepted my bid as an MSME bidder. Sale stand is there was a technical glitch in the GM portal, as a result of which, my lord, I could not select the MSME option, and after reverse auction, my lord, they could not give me the option to match. If your lordship will kindly take, I will just place sales affidavit, GM portal's affidavit, GM's affidavit. This now it appears that there is a blame game going on between sale and GM. Sale is saying that there is a technical glitch due to GM. GM is saying that the sale was at fault. Now, the crux of the matter which now appears is that ultimately they have, both of them, for whatever reason, have not been able to give effect to clause 6. That is the only thing. So their fault is admitted. There is no fault in the tender process as such. After reverse auction, the procedure which was to be followed, they did not follow it. Now, this I will show your lordship from the two affidavits. Okay. If your lordship kindly takes supplementary affidavit to the file, I have been served. Kindly take, my lord, a supplementary
Yes. Supplementary affidavit of
sale.
1, 2, 3.
1, 2, 3.
Yes.
Kindly take, my lord, paragraph 8 at page 6 of the supplementary.
Yes.
Petitioner claims to be an MSE and is entitled to the following benefits: to participate in the tender without submitting earnest money, to relaxed financial turnover requirement, to match the price at the end of the auction. My entitlement, they accept. Then what can we see para 9? The petitioner submitted its bid, but GEM portal operated by respondent number 5 treated the petitioner as a non-MSE regular bidder due to technical issues on respondent number 5's portal. However, based on uploaded documents, petitioner successfully received the MSE exemption for turnover, earnest money deposit in terms of the tender terms, and public procurement policy for micro and small enterprise order of 2012 dated March 23.
This is the same policy.
So this is the same policy which I am relying on. Petitioner does not and cannot have any complaints. I am not making any complaint. I am saying that you have not given effect to that clause 6 of this order thereafter. Next, can you see para 10? However, when it came to the petitioner being able to match the price of L1 bidder, as admitted by the respondent number 5 in its email dated March 5, 2026 to the answering respondent number 1, the GEM portal managed by respondent number 5 prevents such matching from happening. So the portal is at fault. Happening as the respondent number 5 has not yet made available the MSE bid purchase preference functionality. This is because the GEM portal is designed in such a manner that match of price is only possible if tender is not an input tax credit enabled tender. So I have nothing to do. I am an MSME. They have treated me as an MSME. I could not match the price of the L1 bidder because something was missing in the GEM portal. Now, kindly see the mail which they have relied on in this connection. Kindly see page 16.
No, this because the GEM portal is designed in such manner the match of price is only possible if the tender is not in input tax. Okay.
But this is an input tax rate, and therefore that functionality is not coming. Kindly see their mail at page 16. Yes, I will start from the mail at trailing mail at page 17.
Yes.
Kindly see on page 17, there is a mail from Pankaj Sharma. This is their internal message. Sharma to sale 3rd of March 1625. What should that?
Yes.
Now kindly see against the subject.
So Pankaj Sharma sale.
Yes, sale to sale. It's an internal.
Okay, internal.
16 is against the subject GM bid 8 offers. Well, I am number 4, metal traders and processing.
Yes.
Were received within the extended due date. As per GEM rules, H1 bidder, construction, was eliminated before RA. And wide RA number such as the reverse auction was conducted on GEM portal for subject tender from such and such. After H1 elimination, total of 7 bidders were eligible for participating in RA, out of which 5 bidders had participated. Names of the bidders along with their ranking are mentioned below. I am third. Number 3, metal traders. MSC bidder. Kindly see, against my name, it is mentioned MSC. Then, as per terms and conditions, purchase preference as per extend MSC policy and make it standard applicable. B, bid cannot be split. Sale is writing. Number of sources of procurement shall be one only. In case L1 is non-MSC and preference is to be given as per MSC guidelines, 100% order shall be placed on the eligible MSC vendor as per the extent guidelines. However, next member, there is no option available on the GEM portal to launch the price matching event for subject GEM bid after RA. GEM bid and GEM screenshots have been attached for ready reference. In view of the above, it is requested to kindly take up the matter with GEM to provide the following for further processing of the subject tender. Original bid price of all the above mentioned bidders, price matching option if applicable to be made available as per extent MSC policy guidelines. such and such.
Sir, page 16 এর
Now
একবারে
we are
GM
just
রেসপন্সটা
on to the previous mail at page 16, bottom. 16 bottom note from R. Mishra sale to Jem. Kindly see the date, 3rd March 1659. This is second in point of time.
Yes.
As per bid terms,
To whom it is and Gem?
yes,
Sell to Gem.
sell to Jem.
Yes.
As per bid terms of service bid number such and such, purchase preference is to be given to NAC as the L1 bidder is non-NAC. May kindly advise as soon as possible whether the buyer can proceed with offline price matching as the price matching tab is not available on the buyer's dashboard. So sale is saying that let us comply with the MAC order and do it offline. Now kindly come to the top mail. James is writing to sale.
পঙ্কজ শান্তন রায় টু আর মিশ্রা
5th March. We would like to inform you that for ITC enabled bids, purchase preference to NAC is not available as of now through the system. So they accept ITC enabled bids. We would request you to kindly do the price matching with the NACs offline. And share it with James with breakup ITC wise. So James accepts their technical fault and suggests the method.
Go for the offline.
Go for the offline.
Not done.
Sale did not do that.
And I mean, court.
Therefore, we had to come to court.
And
And now, Manoj, kindly see
R5
why
maintains the
we
same step.
came to court. Kindly see that document which I had relied upon in the time in the writ petition. When I had made this communication, so kindly note the date. This is 5th of March. My communication was 9th of March.
আমার কই সেল না করলে আমি আর কি বলবো
Page 298 first. I am writing to say
299.
আমি ওটা দেখাই।
There are two writ petition.
No,
Two volume. এটা volume 2 তে পাবে।
But this your lordship will get in volume 2.
Okay. Page
298.
Yes.
This was my representation because I was this price matching was not taking place. Kindly see the response at page 299. This is coming from Jem.
This is to by you.
First one is by me to sale. 7th of March. This is the date is 7th of March. At the top left.
Yes, 7th March.
5th March is
Last application I showed, my lord, was 5th of March from Jem to
That
sale.
is the
Yes.
that is between them.
Yes. After that, this is 7th of March.
7th of March made by you to the
Sale.
Yes.
Now, my lord, Jem is writing back at page 299 on 9th of March.
Yes. To you.
Yes.
Sale to you. Gem to you.
Jem to us. Reference concern, we regret, we comprehend it will surely help you. This paragraph, we would like to inform you that upon checking, buyer not opt MI purchase preference during bid creation. Buyer is sale. Now again, they are putting it back to sale. During bid creation, as a result, bidder did not avail MSC purchase preference during participation. Hence, buyer is not eligible to send the price match request. Kindly proceed accordingly. So now, my lord, the more clearer picture has emerged from the affidavit of sale and the correspondence with the exchange. Now, also kindly see, my lord, the James affidavit.
Respondent 5.
Respondent number 5 affidavit.
Para 7. Page 4.
হ্যাঁ ওটা আগের দিনই দিয়েছিল আমার রিপ্লাই টাইম দিয়েছিল
Paragraph 8 at page 5.
Affidavit of respondent number 5.
5.
1, 2, 3. Yes.
Kindly come to page 5, paragraph 8.
Yes.
Primary grievance raised by the petitioner appears to be that being an MSC bidder, a price match request was not issued to it. However, the bid in question is a non-MSC bid, and this selection of a non-MSC bid was made by the buyer department sale. Accordingly, a price match request is not triggered through the portal, therefore no liability can be attributed to GEM. So, this
Passing
is
the buck.
passing the buck. Earlier correspondence of sale,
It's a gem.
this is GEM. GEM is saying that I am not at fault. Buyer did not select the MSC option.
Sale did not.
This line, they are relying on this selection of a non-MSC bid was made by buyer department.
Offline suggestion to এখানে বললো।
But actual picture is revealed from those mails which have been exchanged between sale and GEM.
GEM had suppressed it. It did not
This
do the offline.
should have been disclosed by GEM also. Yes. Now kindly see para 9. In the present matter, buyer department, that is respondent number 1, published bid document on such and such on the GEM portal for handling, processing, management of raw material. Respectively submitted grievance raised by the petition is confined solely to tender floated by respondent number 1 for management. We are not raising a challenge as to the tender process. Challenge in the present writ is thus directed against terms and conditions of bid. Absolutely not correct. We are not saying that any bid terms is defective or anything. We are only saying
You've not been
the circular, MSC circular is
not been given effect.
It is submitted respondent being an intermediary has no control whatsoever by eligible prices. But kindly come
Then
to
ওই second part repeat করে 16.
16 once.
Page 10.
At page 10. At page 10, if your lordship turns, second line from the top, it is pertinent to mention that it is the buyer who has chosen the bid to be non-MSC.
Which is incorrect.
That is wrong, because the sale has already said that we have been allowed to participate as an MSC, against which the petitioner has raised the primary in the absence of any substantive claim until it cannot be regarded as. This is their case. It doesn't matter. Now, in view of this stand of sale, that there was some defect in the portal for an ITC bid, that option did not open, and even but sales problem which we can identify is that when GEM has asked you to do it offline,
You did not do it.
They are not done.
so they did not do it.
They are not done.
So they could have saved their skin by doing it as per GEM request lastly. Now, in this perspective, my humble submission is the affidavit of the so-called selected buyer becomes redundant, because they cannot go beyond
What the
what
sale is saying.
sale is saying.
ওদের একটাই stand policy mandatory
But
নয়।
their only stand is now contrary to the tender condition and as well as the MSC policy. They are saying it is a discretionary power, but sale has exercised the discretion
Unincorporated.
to incorporate clause 6 of that policy. One thing that I would also show your lordship from the GEM affidavit, the GEM conditions, which specifically say this. Kindly take page 42 of GEM's affidavit, R5.
Yes.
Kindly see page 41. This is the topic bid to reverse auction. We are concerned with bid to reverse auction.
Page 42.
41 Q.
Yes, bid to reverse action.
While creating bid on GEM, buyers shall have provision to select bid to reverse auction option. If this option is selected by at the time of bid creation, sellers would be required to survey before bid closure. Such and such reverse auction will be conducted as per bid to RA qualification rules selected by the buyer, which have been stated below. In my case, I will show that the buyer has selected the second option at page 42, which is bid to RA with H1 elimination rule.
ওটা তো ওই কমিউনিকেশন থেকেই বেরিয়ে আসছে মিল
This has been selected by the buyer.
মিলেই লেখা আছে দেখুন
Number 2, bid to RA with H1 elimination rule. Now, my lord, your lordship will kindly see. Reverse auction would be conducted amongst all technically qualified bidders except highest quoting bidder. This is corroborated in their affidavit.
page 45
Technically qualified highest quoting bidder will not be allowed to participate. However, H1 we are not concerned. Now, my lord, after this ABCD, kindly read this one. After the RA process, the award of contract, we are after RA process.
but I think
Award of contract shall be made by the buyer. View public procurement policy for micro and small enterprise order of 2012. It is mandatory. So this is mandatory.
this is yes you
And public procurement make in India as amended from time to time.
substantively
So therefore,
are not given by
the
act.
incorporation of public procurement policy is a direction under the GEM portal. There is no scope of any discretion left to SAIL to leave it out of the tender.
সেটা ক্লেমও করেন না
And SAIL has not said that. I'm saying
SAIL then direct then.
why I'm by this argument is only to meet the case of respondent number 7,
আমাদের টেন্ডার
who says that no, SAIL was not bound to do this.
Yes.
In the fact.
আচ্ছা টেন্ডার টার্মস এর মধ্যে
Yes, who is for the
Sir,
SAIL?
I am the creator of the
Sale.
confusion.
SAIL.
Let me, I just. But,
Now the confusion is clarified by that.
I just indicate. I am mandated by the ministry's rules, my lord, to do everything through GEM portal.
Correct.
Number one. Number two, this is a matter where I had said, you please permit them to match the price. That is because of the purchase preference policy. But that is not possible as per the GEM portal. They have clarified that it's not possible as per the GEM portal. So, my lord, I am helpless.
No, the GEM portal has given you option to go for the manual and inform the GEM and GEM will incorporate
I
that.
can't do that.
Why?
The problem is, it has to be on the portal, and to do that, for this to be done offline, it will have to be a non-GST tender. Will you please have a look at? I have ITC enabled bid below is page 219. The series supplementary affidavit. I'm sorry, page 19 of the supplementary affidavit
Supplementary affidavit ba?
of R1.
Page?
Page 19.
Yes.
Will you please see, my lord, page 21.
Yes.
Note at the bottom, ITC is normally required by buyers who are commercial entities and need to take credit of input tax. Other buyers may select no as an option for ITC. Only requiring input tax credit and having GST registration need to enter values above.
Correct.
So, my lord, below that box, your lordship will see, do you want to avail ITC based evaluation for bid? If you put yes, I want, because I'll get input tax benefit. So the second they press yes, reverse auction, my lord, this matching is not possible.
Correct. That's
That
why.
lordship will.
So as per the guidelines, MSME you cannot ask for this.
Yes.
Correct.
Now, my lord, page 28, just one more page. I just want to indicate my problem. The general functionality, my lord, at the top, my lord, in that pink box, or it's pink, I suppose. The general functionality of ITC RCM has been made live for procurement of services. However, For procurements where MSME purchase preference is also applicable, ITC RCM functionality is still under development. Therefore, any procurement of services with ITC RCM, MSC purchase preference will be enabled by GM through backend.
Correct.
This is the problem. Now,
This is
I
the
can't do
problem.
anything.
You can't do anything. Before you placing the tender, you have to follow the guidelines of the ministry.
Yes.
As per the guidelines of the ministry, you have to give some concession to the MSME. What the concession? You had the knowledge who is preparing the tender document.
Yes.
And you are going to the GEM. So all the things first you have to fix to with the set with the GEM. Then you have to go to the tender process. Now after that you cannot
But
say
there also I have a problem.
Why?
I can just clarify 1 minute. Page 13, my lord, rule 149.
Page 13.
Page 13 of the same supplementary affidavit.
Yes.
Rule, this is the rule 149 of the finance rules. Government e-marketplace, GEM. Government of India has established, Lordship has seen rule 149.
Yes.
Government of India has established government e-marketplace for common use goods and services.
Correct.
GMSPB will ensure adequate publicity, including periodic advertisement of the items to be procured through GEM for the prospective suppliers. The procurement of goods and services by ministries or departments will be mandatory for goods and services available on GEM.
Correct.
So, my lord, I have to go to GEM.
You have. I'm not telling that you have. That's why I'm
And
telling.
GEM isn't
If
developed.
you are going to the GEM, so you have to give all the things to the GEM. This is my condition. This is for the normal contractor. This is for the GEM persons, and these are the condition. In terms of this, you have to prepare the software.
But I have told them.
Where is
And
that?
they have clarified and said that it is not possible.
That is subsequent. That is after the tender process was over, when the problem created, then there was a.
The problem is not created by me, it is by GEM.
No, but they gave a solution. But kindly see 2 pages.
GEM has given the solution.
But I have taken instructions. We will, I only, one submission to your lordship. What is happening in this is that we have to continue with the old person. And we are not being able to, my lord, proceed. Now we will do whatever your lordship tells us. Your lordship tells us to go to A, we'll go to A. Your lordship said
Court will not say to go to A, get to B. Court will say you have to act in accordance with the law, what the law provides. So,
and then tell us what to do, we will
as
do.
per the GEM's contention is that it is not, it is in their software, it is not there. The MSM is matching. So he has advised you to go for the manual.
Offline. And they
If
have
you
asked
go for
for
the
it.
manual. What is if is competing with the H1, then
I'll
you have
do
to
it.
report
I
to
have
the
no
GEM.
problem. But, my lord, I couldn't do it till the time your lordship said I should do it, because if I went to do it, I would lose my ITC benefit. But now that your lordship will tell me, I'll do it immediately. Tomorrow I'll do it.
Yes.
I have nothing. I am ready to go to do anything. But GEM has created a problem. Now the problem is getting solved. I am happy.
And in fact, GEM has told
Because,
them you
because
do
see,
mix matching
even the
offline
even
and
the,
shared.
even the law as on today, he is appearing for the GEM because of the default on the side of the authorities in the GEM portal. The petitioner, the bidder cannot be punished.
Cannot suffer.
That is the thing.
But at the same time, I also cannot suffer. If I do manual reverse bidding, then I don't get input tax.
No, he will.
The successful bidder suffers.
Successful.
Yes.
Successor has taken the benefit of this lacuna.
No, but that's all right. But the successor was asked to mobilize men, mobilize machinery, mobilize equipment.
We will not leave it entirely in your lordship's hand.
They will have a right of
Please, my lord, do not be harsh on our office. Because we are bona fide. Only problem was ITC. That's why we didn't do it.
No, no, where's the bona fide, my lord?
Mr.
Today,
Shah,
today, my lord, if you knew that this.
I have no dislike for Mr. Shah. I have no special liking for Mr. Shah.
Yes, Mr. Khan. What is your?
Well, let me now put it from my perspective. Now, my lord, SAIL has very conveniently said that, my lord, today there was a mistake on our part. Essentially, that is what they have said. Now, my lord, let us look at this. My lord, so far as the SAIL is concerned, my lord, if your lordship sees the bid invitation, my lord, page 42. SAIL is not a child. Well, they can't say that, no, we couldn't understand things.
Every day, I am telling to them with regard to the jam, either jam is to be closed or unless and until the total first all the department to sit with the government and prepare without any guidelines every day. Every day. Today this one, yesterday there was one. That's why I am identifying him. He is appearing in every day in one matter. Either it has been deleted, either it has not log in or it has not log out. This is the problem. Now here, this software is not with the gem.
Well, apart from the software issue, well, there is another issue. My lord, SAIL seems to be, my lord, abandoning its own case, my lord, in its affidavit. My lord, let me show your lordship, my lord, that. My lord, GEM really has nothing more to do here. My lord, please see page 42, my lord, this was the bid invitation. My lord, as I told your lordship that there is an option available with SAIL and, my lord, other PSUs. They don't have to, my lord, invite MSCs, but they have an option to do so. Now, my lord, they have exercised this option, my lord, how? Page 42.
Yes.
My lord, this is the last paragraph. The bid cannot be split. Number of sources of procurement shall be one only. In case L1 is not is a non-MSME, and preference is to be given as per MSc MII guidelines, 100% order shall be placed on the eligible MSc MII vendor as per the extant guidelines. Now, let's pause here for a moment. So, my lord, it is the guidelines that we have to refer to. Now, my lord, please have a look at the guidelines. The guidelines you also will find at, my lord, page 17 of, my lord, I'm sorry, my lord, this will be page 284 of the writ petition.
Yes.
But here, clause 6, which Mr. Sen was referring to, please see price quotation in tenders. Now, my lord, please see price quotation. My lord, this is the original price quotation. Price quotation in tenders. One, tender, in tender, participating micro and small enterprise quoting price with price band of L1 plus 15% shall also be allowed to supply a portion. So, my lord, this does not talk about, my lord, a revised price quotation, but in the course of a reverse auction. My lord, because, my lord, when we are talking about price quotation, my lord, what are we saying? We are saying that the initial price quoted by you is, my lord, what has to be taken into account for the purpose of this, my lord, policy guideline. The policy guideline does not say, my lord, a revised price quotation or, my lord, quotation made in the course of a reverse auction or any other means. So it is, my lord, the original price quotation which has to fall within, my lord, the plus minus 15% band. My lord, may I just read it? Price quotation in tenders. One, participating micro and small enterprises quoting price with price band within price band of L1 plus 15%. So, my lord, today if he is, my lord, higher by 15% than the L1, my lord, contender, then, my lord, he will be considered. But, my lord, that is the original price quotation. There is no mention here of anything apart from that. Now, my lord, this was clearly also SAIL's understanding. Well, I am not, my lord, on, my lord, whether there was a technical glitch, whether, my lord, they could in fact participate. I am on, my lord, the initial price bid. Now, my lord, if your lordship please see SAIL's affidavit. Please see, my lord, the original affidavit filed by 1, 2, 3. I'll show you, lordship, my lord, just, my lord, 3 paragraphs.
So as per your submission, page 284, the tender participate in the micro small industry quoting price with the price band of L1 plus 15% shall also be allowed to supply the portion requirement, bringing down their price to L1 price.
So, my lord, what I am saying is, my lord, initially, my lord, let us say I have bid, my lord, 115.
Correct.
The L1 bidder has bid 100.
Correct.
My lord, that's within 15%.
Correct.
So, my lord, they will have to have the right to, my lord, match my price.
Correct.
But my lord, today, if they are, my lord, let's say 125, they go beyond the my lord 15% band, then they cannot participate in, my lord, anything else. They cannot match my price. Now, my lord, what they're saying essentially, please see, my lord, what is the case. They're saying that in the reverse auction, I was within the 15% band. Well, let me show you, lordship, why I see this. Please see, my lord, sales affidavit. Please come to paragraph 9. I do not have, my lord, the reply to this, but my lord, I would imagine that, my lord, this is an accepted position. My lord, please see paragraph 9 at, my lord, page 14.
Yes.
The petitioner submitted its opening bid for a sum of INR 344 crores. For context, the L1 bidder's SIBPL bid was 227 crores. Thus, the petitioner's opening bid was not within plus 15% of the L1 bidder's opening bid. Then, my lord, will please see again paragraph 14. Moreover, as noted above, the start bid price in the present case was INR 227 crores. Petitioner's opening bid price was 344 crores 4,85,837. My lord, was not in the L1 plus 15% band of the start bid price of 227 crores. And my lord, again, one more paragraph, 17. The respondent number 1's tendering authority, after evaluation of the tender, granted the award of the contract to the respondent number 7 in terms of the following. The petitioner had not submitted the bid as MSME. Then B is very important. In the understanding of the respondent number 1, the reverse auction process is a process of negotiation. And as the original bid price of the petitioner was not within the L1 plus 15 price of the start bid price, petitioner was not allowed to exercise the option of price preference. Now, my lord, these figures, my lord, are not in dispute. My lord, if today in the initial stage you are not within the 15% band, then the question is, my lord, whether you can, my lord, in the course of reverse auction, my lord, which is the process of negotiation, as my lord sale has itself said, my lord, try to match my price and claim this, my lord, benefit. Now, I am surprised that, my lord, Steel Authority has taken this point in its affidavit. These figures are, my lord, there in black and white. They cannot be disputed. But, my lord, today they suddenly give up that case. And, my lord, today who suffers? My lord, I have been placed an order on the 16th of March. I was asked to immediately mobilize men and machinery to start the work by 18th of March. Mobilize men, machinery, equipment, my lord, to start the work by the 1st of April. There are targets, my lord, set. I have to achieve and complete, my lord, the work within the specified date. I have amassed, my lord, crores of rupees worth of men and material that side, because, my lord, this is a continuous process that has to be undertaken. And, my lord, today, all of a sudden, my lord, your lordship finds that the sale is saying that yes, there was a mistake. Now, my lord, where is the mistake? If today we look at paragraphs, my lord, 9, 14 and 17, where is the mistake? Steel Authority says that they did not initially come within the, my lord, 15% bandwidth. In that case, they are not eligible. Now, I am not, my lord, questioning the policy itself, because, my lord, the policy is, my lord, discretionary. Apparently, Steel Authority had exercised its discretion in the bid document. But, my lord, how does SAIL answer this question? As SAIL walks away after filing an affidavit without defending this position, after having entered into a contract with me, my lord, a written contract undertaking specific obligations, requiring me to, my lord, mobilize men, equipment, after making me deploy, my lord, crores and crores of rupees, they suddenly, my lord, say that no, I'll do whatever the court tells me to.
Okay. Just to deal with the last argument.
Yeah, this one.
Yes, only this argument. This argument will go, if your lordship has seen, my lord, page 42, which I had shown your lordship from the affidavit of GEM, the guidelines of.
Well, I am not concerned with GEM guidelines.
GEM guidelines is incorporated in the tender document. Tender is not DHO's GEM guideline.
There is the reverse auction.
It's reverse auction.
Well, today I am looking at the policy.
42, my lord.
Starts from 41, which is part of
Kindly see that GEM affidavit. 45.
Well, I don't even have a copy of the GEM affidavit. But today my learned friend wants to rely on the GEM affidavit, my lord, to defend this position.
I will not.
Today,
that's the guideline.
No, my lord,
participant.
no, my lord, today, if the GEM guideline is something that is not to be noticed, my learned friend cannot blow hot and cold at the same time.
I'll just want to kindly show before your lordship sees this, the tender document itself, page 45 first, then this.
To the writ petition. To the writ petition.
Writ petition?
Yes, not 45 or 79.
45 was.
79, your lordship can see.
Page 45.
45, your lordship will see.
Yes.
Kindly see just above eligibility criteria, very small, my lord, it is written mode of RA,
Yes.
JAM RA with H1 elimination.
That is the mode of
That is the mode of RA.
we applied it
And that mode of RA, my lord, is described
at page 40.
at page 42 of James affidavit.
James.
James affidavit page.
Oh, this is GEM RA with the H1 elimination.
This
Okay.
is the mode of RA.
Correct.
Now, what is the H1 elimination is given in page 42 of the GEM guideline. Page 42 of James affidavit. Lordship has
Same bit to RA H1
been- This is the procedure. After this, my lord, your lordship will see after RA process.
The awardee contract shall be made
By the buyer keeping in view the public procurement policy guidelines. Now, when my learned friend is referring to clause 6 of these guidelines,
After application of policy.
after RA. So therefore, whatever is the final quotation
That the policy.
achieved at the RA, then the question of L1 plus 15% will apply in terms of the procurement policy.
So you mean to say the final it has not arrived.
Yes.
So L1 plus 15% will not come in.
Until and unless the RA quotation is
Correct.
concluded.
So RA is not completed.
Yes.
So if,
My learned friend is saying the
because
first offer.
you could not get that, so
Yes.
RA was not completed.
Not
So
completed.
you will get the chance, you will get an RA. Once the RA you completed, then L1 plus 15% is to be taken into consideration.
Well, with the greatest respect, but may I?
One addition, my lord. Because, my lord, the initial quotation price is just a number.
That's
Because
a number because it increased.
or because at that stage I am not even techno-commercially qualified. When I am giving my that initial quotation price, that is subject to my qualification in the techno-commercial stage.
That I'll be allowed
It
to
is not
participate
even
in our-
exclusive offer.
Yes.
The offer becomes complete and absolute
After I'm
when
qualified.
RA is done.
And I'm qualified.
Then the question of acceptance comes. At the first quotation stage, there is no complete offer as of now. It is a conditional offer. Only if my techno-commercial bid is accepted, my offer ripens for consideration at the RA stage.
And today 159 is the last stage.
And when the final RA stage is at page 159 of the writ. Final
And
quotes.
the sale admits, therefore I should be given this.
This is after RA detail. According to this policy, RA.
And my lord, lastly, scale has not changed its stand.
159.
159 of the writ petition. This is the final RA quote. Kindly see. Number 3 is mine.
And one is my sir.
Yes.
And 1 is my learned friend. I am within 15%.
This is the final.
This is the final RA quote.
RA details.
RA details, my lord.
So how
mentioned.
that rate has been come in the affidavit of the
Yes, that is come in the affidavit of sale also.
no sale has given the affidavit of the amount what? They have given the
No,
Affidavit my learned senior friend showed my lord.
that is not this amount. The affidavit amount which their sale has given, that is the initial
that's
quote.
what I'm telling.
Yes.
That's why sale has given that was the initial amount.
Initial amount, which is not even a concluded offer.
Okay.
Well, I don't understand, my lord. Today,
Only one thing, my lord, just one thing, my lord. And sale has not changed its stand. Contemporaneous stand of sale before filing of the writ petition is 5th of March, which I have shown your lordship. There they have accepted that I am entitled to match. There is no provision for matching. So therefore, my learned friend's case that now in the supplementary affidavit a change has been stand is not correct. Contemporaneous stand before litigation is same.
may I just reply to this? I'll just take 2 minutes of your lordship time. First, my lord, we are not looking at, my lord, the GEM portal to understand the policy. My lord, the bid document or the invitation to bid, my lord, refers to the policy. The policy does not, my lord, signify, my lord, any acceptance of, my lord, bid in a reverse auction. The policy I have shown you, clause 6 of the policy. Policy is very clear that, my lord, bid.
No, clause 6. So which stage that?
No, my lord, that is what I'm saying. Now, my lord, here, if your lordship sees, clause 6, my lord, does not mention any stage.
Correct.
Clause 6 says price offer.
Correct.
Now, my lord,
Price offer will come only after the final.
no, my lord, with the greatest respect, my lord, today, my lord, when I put in a tender, I have to put in, my lord, my price bid. Now, my lord, that is my price bid. Now, my lord, what happens in the reverse auction, my lord, today, there is a, my lord, reverse auction, my lord, the whole process, my lord, is the process of, my lord, trying to match up and down. My lord, that is not the original price bid. Now, my lord, here the price bid, my lord, I'll just answer my learned friend's question here. My lord, we are looking at the policy. Now, my lord, the question is about implementation of the policy, which, my lord, SAIL has opted to adopt. My lord, SAIL says that I will adopt the policy. The policy says price bid plus minus 15%. It does not say policy plus minus 50%, final offer at the stage of, my lord, reverse auction, at the time of negotiation, nothing of that sort. My lord, today, please, my lord, bear in mind that, my lord, today, just like, my lord, the MSME entity is asserting a right. Well, I am also, my lord, an entrepreneur. I am also asserting a right. Now, my lord, I am not, my lord, at this point of time dependent on SAIL's, my lord, charity. Well, I, my lord, assert my right as, my lord, a successful involved bidder. Now, my
You have
lord,
to
the
defend
question
your
is,
right. You have to defend
yes,
your
now,
right.
my lord, the question is whether I can be, my lord, today, ultimately, my lord, suddenly toppled. That is the question. Now, my lord, my lord, go by the bid. The bid says very specifically plus minus 15%, 15% band. My lord, the policy says price.
If suppose court pass an order, the suggestion given by the GEM to be adopted, taking into the manual and thereafter. So what harm you will?
No, my lord. Here, my lord, today, well, I am only saying this. My lord, they would have a right to, my lord, try and match my offer, provided they were in the initial, my lord, plus 15% bandwidth. If they are not, and my lord, that is what the sales affidavit says, they are not. And my learned friends do not deny this position. They say that we came within the 15% band only in the course of the reverse auction. That is their case. Well, there should be no confusion about this. Initial price, they were far higher.
So L1, when the L1 will decide it?
Yes,
No,
L1 cannot be a initial price. L1 will be only after the completion of the price bid.
No, my lord, please see, my lord,
After
here.
the completion of the price bid,
Well,
L1, L2, L3 will be
My
come.
lord, here, my lord, your lordship will see, my lord, that the L1 is, my lord, there are two, my lord, L1 stages here. My lord, first, my lord, when there is an initial bid. My lord, because, my lord, ultimately.
Initial bid, any initial bid, the L1 can be.
But 159 designates L1, L2.
My lord, now, my lord, please see, my lord, here, my lord, paragraph 9, my lord, what SAIL says. My lord, there is no difficulty in understanding, my lord, L1 bid here. Well, the right is confirmed. The petitioner submitted its opening bid for INR 344 crores 74 lakhs and all.
Yes.
For the context,
Yes.
L1 bidder, well, at that point of time was SIVPL. SIVPL's bid was 227 crores.
Yes.
Thus, petitioner's opening bid was not within plus 15% of L1 bidder. I was not the L1 bidder then.
So that's not, then
Now,
what, then what is the 159?
Well, so far as 159 is concerned, well, it is, well, after, well, negotiation, well, that is the, well, reverse auction, well, price. Well, that is not what is contemplated. The policy does not contemplate the ultimate, well, price reached in a reverse auction.
So you show me then the very initial stage, the L1 is to be fixed. How the L1 is to be fixed?
No, well, today L1 is, well, very simple. Well, L1, well, at this stage is, well, whoever is given, well, the lowest bid.
Correct. But the initial stage, how we can say the L1?
No, my lord. Initial stage, my lord, L1 can be determined. Now, my lord, what they do is they try to, my lord, get a lower rate. My lord, that is, my lord, the process. Reverse auction.
Okay.
Reverse auction is not, my lord, something, my lord, that is, my lord, has to be adopted in every case. But in this case, my lord, they have decided to go for the reverse auction because SAIL wants to, my lord, minimize its exposure, financial exposure.
Okay, let me apply my mind.
Only for
Now,
your
my lord, the
lordship's
difficulty is, my lord, here, that, my lord, today SAIL with the full understanding of the matter that, my lord, today the petitioner was not within the plus 15% band. Well, they have, my lord, ultimately given me the tender. Now, my lord, how can they retract from that position? SAIL cannot do that.
Tender issued. Work order issued.
Work order issued, mobilized.
Not given effect to you. Lordship, you see the circular.
Well,
What my connection is
work
saying.
order issued is one thing, not given effect to because of the lordship's order is another thing.
And take note of 26th of March, your lordship has recorded in your lordship.
My lord, work order is, my lord, a part of my affidavit. Please, my lord, see my affidavit. Work order is issued on the 18th of March.
This has not been challenged by them. Kindly see.
I have, my lord, annexed to my affidavit.
With any work.
No, my lord, but my lord, there are documents which are annexed to show that they are
Yeah,
calling
but
upon me to
26
mobilize men and
months.
machinery, and I've done the full mobilization, repeatedly requesting them to allow me access to the site.
Kindly say 26th of March I had handed over.
My lord, there are minutes of meetings with SAIL.
Just after 8 days, SAIL has issued this.
My lord, they have asked us to mobilize men, they have asked us to mobilize
The,
equipment.
the existing contract was extended up to 30th of September.
My lord, that is, my lord, because of the challenge.
No, not at all because of this.
My lord,
Kindly have a look at
my lord, my lord, please see my contract. My lord, please see my affidavit. Please see my contract. My contract is, my lord, there at page 33 of my affidavit.
SAIL reserves to short close the extended at any point of time before completion extended time. This is approval of company, so they have no right in their favor as of now.
My lord, this is, my lord, subsequent to the work order. This is 26 March. My work order is 18th March. My lord, please see my work order and my lord, how SAIL has corresponded with me. Page 33 of my affidavit. Affidavit of R7.
So your lordship has recorded this. They have no.
You have filed the affidavit?
Yes, my lord, I filed an affidavit. Affidavit is, my lord, page of R7. My lord, page 33 is the work order.
Illegality is found on the face of it. They do not acquire any right.
No, my lord, it's not an illegality at all.
So that
My lord, my learned friend,
decided.
my lord, did not have the right to, my lord, match my price at all.
Your affidavit is not on record.
My lord, R7, my lord.
R7 affidavit আছে কি?
My lord, a reply has been used to that affidavit.
33.
The petition has filed a reply, my lord.
Might be, but you not filed in court.
Well, I don't recollect what my learned friend says. I filed it. Well,
7. Yes.
well, please come to page 33.
Page
33.
R7.
Yes, my lord.
Page 33 then. No?
In that 20.
Your opposition.
Well, that may be the reply, my lord, to my affidavit.
Affidavit reply. Affidavit opposition is not there. Not there. You're not filed.
If my learned friend's case may be against SAIL for damages that he may pursue.
No, my lord, that is, my lord, a separate matter altogether.
This cannot help him.
That is a separate matter altogether, my lord. Whether I can pursue it or not, my lord, that will be a different matter. Page 33.
Yes.
My lord, please see page 33, my lord, work order dated 16th March. Now, my lord, today, please see, my lord, it is, my lord, please see thereafter, my lord, towards the middle of the page, completion period. 1826 days from the start of the job.
No, but they have given the September, they are continuing with the old contract.
No, that is right, my lord. They have, my lord, asked me to, my lord, pause, but my lord, that is after, my lord, calling upon me to commence. My lord, please see, my lord, the minutes of the meeting at page 122. Well, this is what they asked me to do.
Fantastic case for damages.
122.
Yes, my lord.
What is the
minutes
date?
of meeting? 18th March 2026. 18th March 2026. This is minutes of meeting. Annexure E.
Yes.
Now, my lord, here, please see. United Air Express has stood L1 on the GEM portal with their quoted price, such and such. L1 has submitted. Then, my lord, deliberations. Then, please see. My lord, start the job. Please see under the heading deliberation. Well, let's second how in response to Arvind Kumar, GM such and such committed to start the job by 1st April 2026. However, and well, they are calling me deployment of manpower, deployment of vehicle, actions required to be taken, operational issues. This is all a part of the discussion.
L1 party has submitted price. This is that after reverse auction price.
Well, that is a different matter. Well, reverse auction, well, there are two stages. I can become L1 in reverse auction.
But manual is permissible. This has been in a Delhi High Court judgment. GEM portal, but kindly have a look.
Hearing concluded.
Well, kindly don't allow my lord steal to my lord, SAIL to my lord, get away with this.
Supplementary affidavit filed by the SAIL.
Yes.
That's one clarification.
Yes.
Kindly not have a look at it.
It was response number 5 plus din. Response number 5.
আমাদের পার্টি করবে
Response number 5. SAIL. Yes. Yes. Page.
the sale in scientific manner has disclosed the screenshot of how to create bid.
Correct.
The time of creation, how to create bid. Now, what you will find that on the left corner that create bid. So it is when sale was creating bid. So what kindly see the great portion it has been clearly stated. The splitting cannot be applied. The general alright procurement where basic purchase procurement is also applicable. ITC CLN functionality is still therefore for any procurement of service, the ITC RCM MSC purchase preference will be enabled by change to bracket. No matter at the time of creation of the bid by the sale, they were not aware that this function was not available. What was not required? What was not required to be done? They were simply required to shoot a email saying that kindly enable this as well. And my lord, this my lord has been further my lord clarified by our subsequent mail, which has been my lord relied upon by my learned senior friends, say whereby we have said
That's why I'm telling the GEM knowing that, sales knowing that it is not enabled. So they have not requested you to enable this so that the MSME can also be go for the.
So it is not that GEM needs total has been.
So, your lordship, in terms of Delhi High Court,
the fault that is evident.
Now,
They say there is no fault.
That was
After in their own email.
I don't know what my learned friend is.
Not available. That was
What my learned friend is handing up, I don't know.
let us not go into all that. Manual, they should do
Hearing
it
concluded,
manually. That is
CAB,
the prayer.
interim order continue till the final.
My lord, one last submission, my lord. Even if I do retendering today, just
No question of retender.
You are appearing for
manual.
Mr. Chaudhary has already made submissions. Just wanted to say, hypothetically, even if I do retendering today, even today, this functionality is not made available by GEM. So court has to direct us, my lord, to do
it
manual. However, we will be able to do it. Otherwise, we will not be able to do it.
Okay.
That is the only
So now the court is also the advisory.
Yes,
advisory jurisdiction for the GEM portal.
We are in such an unhappy situation, my lord. What to do?
I have fortunately not asked the court to last sale to compensate me for that.
Maybe that is for a future.
I will request them to implead me a party there. I will lose out on that otherwise.
Okay, thank you.
Obliged.
Lord, in the appellate site, Lord, item number 14. Lord, your lordship recollects that this was Mr. Mukunda had some request. The deed matter, sir, even some request.
It will come tomorrow.
They are giving us notices.
Come tomorrow, it will come tomorrow because today I reached 13. 14 will be within 5, 6, 7 months. Correct नहीं है? Website correction कोई disposal website.
प्रॉब्लम नहीं है ना सब कुछ अंदर टन लो
I have a lordship. Please, no, please,
May I be permitted to mention item number 192 in today's list? This is my review. This is my review application. So it is far very down the line. I would like to mention it, take it earlier because the whole defendant is disposing of her properties. That is why I am inserting. No, I am not enjoying.
What is the review? Which order?
Order for dismissal on the basis that I am not a license holder under the money lender act, Bengal money lender act. That is the reason. I have judgments. I allowed that all even allowed such kind of applications. So it may be taken earlier.
We'll see to that. Yes.
And under my lord, one degree has been passed for the principal amount, which is under the process of execution. And my
process of
execution. That is in the process, but my interest claim has been relegated to the suit.
So I would like to mention, include in the list. So I give the number.
You do one thing,
Yes, my.
you take the diary of my court officer and you choose the date and give the serial number or date. My officer will fix the your matter on the specific date and time. Because I cannot go with the diary. You sit with my court officer and you go which date is free.
I will give the case.
Every
number.
time I'm
I
repeating.
will give the case number, whatever he does or.
Okay, you give, yes.
May I have Lordship's leave? My item number 145, it's a fresh writ petition. My license.
Become infectious.
No, not at all. My license to do business in foreign currency has been revoked by the authority. That is what I am challenging. My business has been entirely stopped. I'm beseeching your Lordship, if your Lordship could.
Business currency has been revoked, but the Indian currency is there.
Indian currency, I can't. There's no business there. So if your Lordship would be kind enough to give some precedence to this matter. I'm praying for upgradation.
See.
But it can't be fixed because it's a fresh writ petition. Where the respondent is supposed to appear. If your Lordship could keep the matter any day with some precedence, but so that it can be taken up.
Yes.
My Lord, item number 145.
My Lord, may I pray for your Lordship's kind leave to mention item number 138. My Lord, I am praying for upgradation. My Lord, what has happened here?
You sit with the Mr. What is
My Lord, first time.
And with the court officer.
My Lord, any day, my Lord, trust is not being able to operate the bank account because they are saying, my Lord, KYC cannot be done. Why? Because, my Lord, the original trust deed is lost. My Lord, we have done a general diary and, my Lord, the RBI directions, my Lord, which the KYC directions are there.
It is not a registered deed.
Not a registered deed, my Lord. It was in the form of a will. The trust was settled through that will, my Lord. My Lord, any day your Lordship permits. Because the circular, my Lord, does not say that original has to be produced. Lord, I have served notice, my Lord.
Your Lordship, may I be permitted to mention item number 101? Your Lordship, the urgency is that a 5-year-old child is stranded in Dubai because her Aadhaar card is not being updated. The status of guardian is not being updated despite our representation in the month of January. Your Lordship may kindly keep it on any day.
So how the 5 years old child went to the Dubai? How he went?
Your Lordship, the passport is now expiring, which is why we have to upgrade the Aadhaar card, after which the passport
So
will
what
be
is the
updated.
prayer?
My prayer is to issue direction upon the UIDAI for resolving the Aadhaar issue.
Dubai?
Aadhaar authorities.
Aadhaar authority. So kar do direction.
Obliged, Your Lordship.
Yes, call the list. Yes.
Yes. Yes. Lordship, I was placing page 229. 229. That is the part of the final report of JB Boda. It starts at page 220, Exhibit R.
Yes.
Yes, kindly comes to page 229.
Yes, that you yesterday you argued that.
Yes.
Police authority could not establish. Or
Since it could not establish a case of arson against the insured or anyone else, and the legal opinion
etc., we are of the opinion that the fire was probably accidental in nature. So even they are not very sure whether it was accidental, they could not emphasize, and their conjecture that it was accidental was entirely due to the fact that the police could not apprehend the persons who were behind that arson. Now, my lord, and JB Boda made two findings. Firstly, it was probably accidental in nature, and then they made an assessment of loss, which initially was pegged at rupees 1.74 crores at page 231. That is the last page, my lord. 231, and it was subsequently revised and re-revised, and ultimately it boiled down to 1.49 crores.
4983958.
Yes, 259,260 on 21st of October 2011.
Yes.
That was a final assessment, and this is a figure that is now being claimed by them. Now, my lord, after this report of JB Boda, National appointed Premier Vigilance and Security Private Limited to investigate the cause of fire, because who were behind the arson, that was still a gray area. That report will, your lordship will find at page 307, volume 3. Page 307, that's the very first page of volume 3.
Yes.
Exhibit W. This is marked as Exhibit W. This is the forwarding letter of the report.
Yes.
Kindly find enclosed. This is dated 5th of August 2007. Kindly find enclosed report on the investigation job given to us, which speaks for itself. In our efforts at unearthing the truth, we have gleaned evidences from different sources and indulged in analyzing the forensic reports, experts' report ascribing the cause of fire as an act of arson. While agreeing with the opinion of forensic experts that the origin of fire was an act of arson, we confidently repudiate any other possibility of fire, such as accidental, electrical, lightning, bush, or natural fire, and firmly stand in our finding that there was a foreign, highly combustible substances present in the storing place of computers in the store of Jupiter International at 6 Garden Ridge Road, where a devastating fire occurred on 5th/6th of January 2006. Then the report comes at page 309. They have narrated the events of the fire, and then lordship comes at page 310. In the last portion of 309, they have stated also, in another report to the police, the fire brigade had described the fire as accidental. A very fair recording. Then at page 310, second paragraph, the forensic experts also visited the fire site more than on one occasion, collected samples of traces for examination. Then third paragraph, the forensic expert in the report number 398, dated 20th February 2006, described the fire as an act of arson. The expert arrived at this finding after examining the scene of fire as well as analyzing and examining the samples of traces collected by the police from wreckages of the godown. The expert found presence of highly combustible foreign substance that alone was responsible for heightening the heat and temperature of fire to over 1000 degrees centigrade, as because burning of computer parts and peripherals stored in the godown cannot produce that much of temperature, which caused conversion of ferric oxide contained in the red bricks at the site of fire to ferrosulfuric oxide of black bricks, which were found at the site of fire and whose samples were collected by police and examined by the forensic report. So this premier also had access to the FSL report. JB Boda had access, premier had access. And another thing, after this report that was filed by JB Boda, where they have discussed the FSL report and have given their own finding that it was, since the police could not apprehend the persons behind the alleged act of arson, it was probably accidental in nature. Now, even after this report, going by the case of the plaintiff, none of them said that we do not have a copy of the FSL. Everybody has a copy of the FSL, all the investigators, all the surveyors, assessors are relying on that, except that they don't have. And they don't raise any question that you have discussed about this FSL. What is this FSL? We don't have a copy. Kindly provide us a copy. That would have been the natural reaction of any person who reads this. Any person on the first blush of reading will say that I have copies of all the other things, but I don't have this FSL, what you are referring to. Please send us a copy. Nothing, not a single letter has been disclosed or exhibited by the plaintiff where they've asked for a copy of the FSL. But all the surveyors, all the investigators, they have a copy of the FSL. Now, may I continue? The forensic expert in the report observed that 4 floors above Jupiter's godown collapsed as iron joists failed at 600-degree temperature. The Jupiter store was accessible from a part of the first floor structure, middle portion of the northern side, to examine the prevailing condition of the store. There they found burnt, semi-burnt computers and peripherals stacked at isolated places. The experts observed in the report that such sporadic effect of fire was not consistent with the accidental origin of fire. In the above lines, the forensic expert has eliminated accident as origin of fire. So detailed FSL report has been referred to here and discussed. In their report, while suggesting the fire as an act of arson, the expert proceeded with observation and examination step by step. The expert found more significant effect of fire in the eastern back end of the store, where they found burnt red bricks turned black. These bricks, upon examination, yielded startling results. The ferric oxide contained in the bricks turned into ferrosoferric oxide, and this change of chemical composition can be obtained at a temperature of above 1000 degrees centigrade. Burning of computer parts, peripherals cannot attain this temperature. As has been said earlier, it was the presence of foreign, highly combustible substance, burning of which gave rise to intense heat and heightened the temperature of 1000 degrees centigrade. And they, page 311, next page, conclusion. Accidental fire ruled out. I'm just reading the headings. Then spontaneous fire ruled out. Electrical fire, natural fire, bushfire, lightning ruled out. The headings of the 3 paragraphs. Fire due to bushfire or due to lightning is not applicable in this case, as there was no lightning or bushfire. The report of the forensic expert conclusively proves existence and presence of foreign, highly combustible substance in the storing place of computer parts and peripherals, suggesting unknown hand behind an act of arson. The forensic expert's opinion and reports are authoritative, binding, admissible as evidence in a court of law. The expert's opinion cannot be wished away or ignored. It's scientific truth and fact.
The report of the forensic conclusive proves that the existence of presence of foreign, highly combustible substance in the storing place of the computer parts and peripherals suggests unknown hand behind the act of the arson. So who will decide the unknown hand?
Yes. It is this unknown hand that was sought to be made known by insurance company by appointing investigators.
That is, the insurance company has to ascertain
Yes.
if any mischief has been done by anybody.
Yes. If it is an act of the third party, they get the claim.
Correct.
But if there is any connivance, then my lord becomes fraud and the claim is not probable. That is why my lord repeated efforts were made to find out who were there. Now, this report of Premier has been exhibited by them. This is Exhibit W, which is this entire report.
No, this report with regard to the page 311 is
Yes.
from, that is exhibited. No.
Yes.
That is exhibit. That is exhibit.
Exhibit W.
Okay.
It starts from page 307 and goes on till 311.
311. Exhibit W. Yes.
Yes.
Yes. Then
This is based entirely on the FSL. Now, Lordship sees they have stated this suggesting unknown hand. Now, in further pursuance of the unknown hand, we had appointed J. Bashir, a surveyor, to investigate the cause of fire. Now, at this juncture, my lord, they filed a writ petition challenging the appointment of J. Bashir, relying on a previous Supreme Court judgment, where the Supreme Court, Honorable Supreme Court, my lord, had made rather caustic remarks against this particular surveyor, J. Bashir, saying that he had given a tailor-made report, again in a case of arson, in favor of National. So, the writ court passed an order. They preferred an appeal from that order. That division bench order is at page 373. Same volume, volume 3, page 373. Division bench order dated 27th November 2017.
Yes.
Yes.
373.
Yes.
Yes.
This has also been marked as Exhibit OO.
Yes.
Now, this division bench order, my lord, is of momentous importance, because what happens thereafter? May I place this order? Page 373.
Yes.
The appellant company carries on such and such. Second paragraph. The insurance company appointed a surveyor. The surveyor filed a final report assessing the loss and damage of rupees 1.49 crores approximately. Next page. The police investigation report clearly states that the fire was a case of arson. Lordship, kindly underline this statement. However, the police could not identify the person responsible for such arson, and accordingly we are told that the police has closed the case. The insurance company subsequently wanted to appoint J. Bashir and company to investigate into the matter and find out as to who caused the arson. The appellant company was aggrieved by this and approached the learned signal judge by filing a writ petition. The learned signal judge disposed of the said writ petition. Operative part said order reads as follows. I am not reading that. Last paragraph. We have heard Mr. Mitra, learned senior counsel for the appellant at length. Today, it is submitted to the appellant. Appellant means Jupiter, the plaintiff, has no objection if the insurance company conducts an investigation through any other agency except J. Bashir and company. So, they also want an investigation into the unknown hand behind the arson. However, there should not be reassessment of damages in the garb of such investigation. We agreed to that. Next, my next page, 375. Mr. Bhattacharya, learned senior advocate, appeared for the insurance company in his usual fairness, submits that the object of investigation shall be to find out, if possible, who were behind the arson. Under no circumstances, there will be reassessment of damages. Then, second paragraph, this is very important. Accordingly, we make it clear that the insurance company shall be entitled to hold such investigation for the purpose of fixing responsibility for the arson in question and the reasons therefore. Such investigation shall be concluded within a period of 3 months from the date of the IRDA recommending the name of an investigator. I stop here. This paragraph, my lord, is very important because it sets out the scope for the investigator to be appointed by IRDA, which is fixing responsibility for the arson. Now, IRDA appoints the investigator, Mr. Falguni Purkastha.
Mr.
Falguni Purkastha, he submits his report at page 376, just the next page. His report starts from here. Exhibit II.
Yes.
Lordship says 8th of February 2018.
Yes.
The heading, investigation of alleged cause of fire for fixing liability of arson as alleged. And
yes,
he goes on, and
this is exhibited.
Yes, yes, exhibit II, capital II.
Yes.
I'm not, this is a very voluminous report.
What is the finding?
Yes, I'm coming to the finding. Lordship has hit the nail right on the head. Page 398. Conclusion. It is opined that the FSL report indicating the incidence of fire as caused by arson involving human act has not been authenticated, as the report is silent over source of ignition, as also presence of specific flammable liquid as accelerant as per requirement of indicators of arson. And Lordship comes to page 400. He goes on with his conclusion. I shall revert back there later. For the time being, kindly come to page 400. H. Last paragraph. We are therefore of the opinion that the incidence of fire is purely accidental. The police has not been able to identify motive or person behind the fire, as the fire occurred accidentally unnoticed. The cause of fire as arson is ruled out, and so the man behind. Some documents are filed for reference.
The police has not able to identify motive of persons behind the as he occurred unnoticed. The cause of fire arson is ruled out, and so the man behind. Some documents are filed for reference. Yes.
দুটো জায়গায় ছিল 378 আর 382. Yes. So the job that was assigned to him by the Honorable Division Bench was find out the cause of arson, and he files a report. No, there was no arson. It was accidental.
That's why there was no arson. How we can find?
Division Bench set out a particular homework for him. He goes on a total tangent, saying that there was no arson. And he finds a different cause of fire, that this is accidental. At the best, his report could have been, I could not find out the persons behind the arson. He overreaches the order of the division bench and says, you're wrong, there is no arson, this is accidental. And Lordship, kindly remember one thing, this order of division bench, which has recorded that there is an act of arson, was not carried in appeal, and this finding challenged before the Honorable Supreme Court. So even the plaintiff had accepted that there was arson.
No, that's correct. But there is arson.
Only because the person could not be identified.
Cause is to
Yes.
now subsequently.
But that does not rule out arson. Suppose there is a murder. Lordship knows in many cases the police cannot find out the culprit, and the case is closed and relegated to the unsolved mysteries. But that does not rule out that there was no murder and he died of a heart attack or suicide. So there is arson. There is a recording to that effect in the Honorable Division Bench order. That was not carried in appeal. That observation has attained finality. That Lordship will find at page 373, the Honorable Division Bench order, 374, first line at the top. The police investigation report clearly states that the fire was the cause of arson. Even there, they did not make out the case. No, there was no arson. There may be possibility of accidental fire, because by that time, the report of J.B. Boda was with them. That case was not made out before the Honorable Division Court, Division Bench. That kindly do not make this observation, because J.B. Boda's report says accidental.
Even though arson, so what benefit you will get?
I'm not getting any benefit out of arson. What I'm saying is, this
I appreciate
finding of arson.
I appreciate once the division bench has confirmed the arson. So
yes, what the division bench has confirmed is arson. The arson flows from the report of the FSL, and this arson is not the main finding. The main finding is the presence of highly combustible foreign material, and this is suggestive of arson. Because in the normal circumstances, burning of plastics, as in laptops, the keyboards, the USB board, monitors, they will not produce that high degree of temperature. To ignite that high degree of temperature, there has to be presence of foreign highly combustible substance. And the report of FSL, which they are challenging all throughout that they have never received, they do not know anything about FSL. This investigator has quoted from that FSL. Lordship kindly comes to page 378. The first instance where this FSL has been quoted. Lordship sees towards the middle, I think it is paragraph 6, the numbering is there. The concluding paragraph of FSL report was noted carefully. Then he starts with unquote. It should be quote because his, in italics he has quoted. On examination, it was found that the red oxide of iron, ferric oxide, contained brick converted to black oxide of iron, ferroferric oxide, the magnetic property of which was confirmed. Such conversion takes place at temperature above 1000 degrees centigrade. Burning of stored article in bracket computer peripherals cannot produce such high temperature that indicate presence of foreign highly combustible substance. This is the main finding. The corollary to the main finding is all the above evidence suggests that the incident of fire was an act of arson. Arson was not the main finding. Arson was suggested, be indicative, yes. Because in the normal course, if it got burned down, such high degree of temperature would not have been reached.
So this ferric oxide and these other materials. So how this?
This is a quotation from the FSL report.
No, that's why FSL report. How the FSL report they have come to, whether it has been sent to the forensic or forensic lab. The ashes has been sent to the forensic lab, or
yes, they collected.
Yes, my lord. As per the report of Premier Vigilance, they collected the materials.
It was sent to the forensic lab.
It is recorded in the report of JB Boda also that the forensic people had visited.
No, visited. Okay.
And page volume 2. No? এখানেও থাকবে. And the police report is annexed to the JB Boda's report, that is at page 239. Yes, sir. Page 239.
Yes.
Here it is stated, my lord, that FSL persons had gone to, this is a very, handwriting is difficult to read. I have got a typed copy for the lordships. This is the original Kolkata police report. This is marked as an exhibit. So the FSL is referred to here, that gets incorporated here. Lordship sees towards the middle, the local police started inquiry. Lordship has found it, my lord. Viday SPPS GD 483 dated 6/1/2006, and it could be ascertained that the above noted companies took the go down from LMG Logistics on lease under an agreement and certain rent to keep the above noted articles. The FSL Belgachia team with the expert visited the PO and collected the samples from the PO, and after laboratory analysis, they opined that the incidence of fire is an act of arson. So the FSL people had gone there, my lord, and had collected samples. And these are the samples, my lord, which is now quoted at page 370, that the red bricks had turned black.
And that's I wanted.
And then again, quotation has been made at page 382, volume 3, Falguni Purkasta's report.
Yes.
Third last paragraph. Last 3 lines. Under this context, third last paragraph. 382. This is the second quotation from FSL that.
Under this context,
Yes,
observation in the FSL.
Observation in the FSL report as quotation starts. All the 4 floors above the store collapsed due to failure of iron joist caused by excessive heat and temperature above 600 degrees centigrade. Then quotations closed is scientifically not correct. That is his observation, Falguni Purkasta's observation. So FSL report was all along available to all the surveys and investigators.
No, but that's correct.
Even though the case has been run by them,
But
that
unless
Jupiter
and
did not have a
unless and
copy of
until the
FSL.
FSL report is brought on record and not true, how far the court can rely on that?
Yes. Now the question is,
if you have not brought the
I have not brought it.
and
He has not brought it.
if it is
but
not proved,
it is part of every exhibit that they have made.
part of they have taken the gist.
Extract, not extract, they have quoted.
Yes,
The
quoted,
reason I pointed out these two paragraphs, because these are the vital paragraphs which are under challenge, that 1000-degree temperature and 600-degree temperature, that is our case. And these two vital paragraphs have been quoted here, and this entire report has been
Why
exhibited.
you are not contested? Why you are not adduced the evidence?
My lord, the persons who were there at that point of time, they were not in the that particular branch dealing with them, and lordship knows a public sector company. Lordship knows from lordship's experience at the bar, nobody wants to take responsibility. And it's a very old case also. Started in 2006. So all the officers, they were there who were actually dealing with them. They had retired or left or transferred. And the persons who briefed us, none of them knew anything, only they had the records. None of them wanted to come here. Anyway, that is neither here nor there. Thing is, it has not been exhibited. But my argument is, it does not take away anything from the validity of the FSL. It has been made a part of JB Boda's report. It has been quoted in Falguni Purkasta's report, and the finding that there has been arson has been recorded in the division bench judgment. So it really does not make any significant difference.
Okay. No, my lord.
Had it been otherwise, yes, I would have faced difficulty, because that is the main plank of my defense. I really would have faced an uphill task. But in this particular case, everybody and anybody who has dealt with it has quoted from it and has relied on it, to the extent it got incorporated in the Honorable Division Bench order and not challenged. And this arson is a corollary. The main portion which suggested arson was the reaching of this high temperature. And lastly, we have not rejected the claim partially, or let me phrase it differently. We have allowed it on non-standard basis, that is at 75%, not on the ground of arson, but because of presence of highly combustible substances. The lordship may ask, what difference does it make? There's a fire. Difference is, if you store something which is very hazardous in nature, which is easily inflammable, which may contribute to the fire, then what the insurance company does is, taking into the higher risk, it charges a higher premium.
Higher premium.
That is the difference. Since this was not disclosed, and if you take the whole circumstantial evidence, that warehouse, sale tea warehouse where their goods were stored, it did not have any electricity connection. It was run entirely on generator, diesel generator. The generator was found outside this warehouse, and their director has given the evidence that every day diesel was purchased and it was consumed entirely. So no diesel was stored inside, but the warehouse got fire. Now, it is very improbable. If you take the Bhushana, if you take a real life situation, there's monsoon, there's winter, nobody keeps a jerrycan of diesel outside under the open sky, even if it's in a safe jerrycan. Okay. Not
yes.
I have not finished.
I thought you have finished.
No. I'll tell you when I have finished.
Because
How much time will it take for that?
A little bit more, half an hour maybe. If
Next day, because other matter. And what's matter, eh? Record on. Learned counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 8 September at 3:45. Huh?
2 dates.
So 8-9 September.
8 and 9. Day after tomorrow.
Oh, just send things it to be day after tomorrow.
It is started the same.
He's not so lucky.
9 September.
September, my lord. I know your lordship
My
has a
reply will
really
not
heavy
take more
list.
than 10 minutes.
Huh?
My reply will not take more than 10 minutes.
Let Mr. Datta complete, then we'll see. Yes, call me.
8th and 9th at
3:40,
3:45, lordship. Grateful, my lord.
Item number 2 has two parts. One is GA3, that was my application for intervention. I have already served the affidavit in reply to my learned friend.
I'm appearing for the plaintiff, my lord.
Mr. Medora was appearing against me, but now he is moving over to the clamorous side. So today he is not appeared. So my lord will.
My lord, today they have served us with a copy of the affidavit in reply just now, my lord.
Who is for the petition plaintiff?
I am for the plaintiff, my lord.
Yes.
It is their intervening application. Today they have served us with a copy
And
of
who
the
is the-
reply.
Judge, I appear for the defendant because there has been a change in counsel. I kindly extends the interim order and fix a later date so that we can engage
You can engage
senior Millard.
senior.
That
And
is
what-
not defendant. I am for the intervenant, my lord. Your lordship knows the GA3. My application, I am the company that my property has been included in the partition suit. Your lordship was hearing that. I have filed the affidavit in reply. Your lordship may kindly extend
Yes.
whatever
And
information.
fix the date, my lord.
Record a note. What you filed affidavit in reply? Petitioner has filed affidavit in reply to
GA3.
GA3.
Intervener has filed affidavit in reply to the affidavit in opposition filed by the plaintiff in connection with GA3 of 2026. Let the same be kept with the record. Let counsel for the defendant, respondent, defendant, press for time. According case is adjourned. Let counsel for the petitioner press for extension of the interim order. Submit the interim order is till 10th of August 2026 and paid for extension of interim order. In view of the submission made by the counsel for the parties, interim order extended till 2nd September 2026 or until further order. Let the matter appear on 26th August 2026.
Grateful. 26th August.
Yes, next.
Lordship, please.
Three. Yes.
So before your lordship takes up item number 3, I am appearing when I intend to intervene in the matter. Your lordship would recollect this matter pertains to debit fees of a bank account of the petition. But I am the complainant on whose complaint the account was freezed. The letter reply to a legal notice from the bank's advocate that I had sent.
My lord, may I get a copy of the document?
In fact, it was sent by my learned senior friend appearing for the bank.
Yes.
So, yes. I am perhaps a necessary party to this petition.
My lord, my instruction, my lord, the
Shareholder of the company.
account has been, my lord, unfreezed, my lord, yesterday. Because, my lord, your lordship kindly see the letter I have replied to. I have also stated, my lord, your lordship's version also same. Your lordship's order also, yes.
Oh, what?
May I get a copy of the petition?
Let me see what the bank has done now.
Guys, I only have a copy of a lordship's last order. Lordship was satisfied with the explanation of the bank. Why the account has been closed.
Yes.
Not with the letter. And I am the complainant, I am a shareholder of the company. Another company is a shareholder. I am 80% shareholder of that particular company.
Whether you are the joint, you are operating the account.
No, he is not operating the account. My
Then-
lord, it is only the petitioner.
May I just
You are not the signatory of the account.
My lord, the writ
Yes, what
petition
is
may be
happened?
disposed of.
But I have already intimated, my lord, the
He
bank
has-
has already unfreezed the account, my lord.
Ah.
In view of the observation made by your lordships, my lord, the bank has unfreezed, my lord. And my lord, your lordships kindly see the, my lord, the opinion of the learned advocate also same. There was a misunderstanding. So, my lord, ultimately the account has been.
My lord, on this, the writ petition may be disposed of, my lord.
Yes.
just one humble prayer then. But my presence may be noted, it will help me in collateral proceedings. The allegations are serious.
My lord, the dispute is in between the, my lord, the
Which belongs to the proposed intervener, and they are brothers basically.
Okay, I am disposing of now already.
yes, my lord,
I am disposing, you
yes.
take up.
On indulge my presence may be recorded.
I record your presence.
Therefore, Mr. Jagdish Kumar Gulati.
Learned counsel for the bank. Bank, no?
Yes, my lord.
Learned counsel for
Respondents, my lord.
respondent bank, respondents submits that. Submit that the bank has already defreezed the account of the petitioner.
Yes.
The petitioner has submitted that. The bank has informed that the bank has already defreezed the account of the petitioner.
Yes.
And consent so and so appearing for learned advocate submits that he is the interested party, his client is the interested party, his client namely
Jagdish Kamal Gulati.
Jagdish Kamal Gulati is the interested party, and as such he may be allowed to intervene in the matter. Listen, this court find that the grievance of the petitioner in the present date application for a direction upon the respondents for defreezing the account of the petitioner. Now the bank has already defreezed the account of the petitioner. Accordingly, this court find that nothing remains in the present date application. The writ application is disposed of as infractious. Thus, the question of allowing the intervener in the present date application does not arise.
Grateful, my lord. I'm deeply obliged.
1 day late.
Yes.
Grateful, my lord.
I was going to give my rejoinder to the judgments here cited. She kindly first takes the judgment of the Supreme Court in 2023 South Indian Bank. No.
Yes.
Understand. Lordship kindly takes a look at the paragraph 8 of the judgment at page SCC page 318.
Page
318. Paragraph 8. Lordship, this paragraph 1, paragraph 1. Paragraph 1. Leave granted seeking, this is the bank's SLP, paragraph 1, seeking enforcement of a unilateral offer concerning private financial institutions while questioning the steps taken to recover the dues on the failure to comply with the one-time settlement. So there's a one-time settlement, failure to comply, they came up in a writ petition. The writ petition was allowed. Lordship kindly sees paragraph 8. Both by the one-time settlement also default was waived. Paragraph 8, page 318. Notwithstanding the orders passed above by this court.
Paragraph 8.
8, my lord. Paragraph 8. At placetum G at page 318.
You are referring from whom? Where?
South Indian Bank, well, South Indian Bank.
Referring from SCC.
SCC.
Not online. That is the problem.
No, SCC report.
This is SCC.
Kholo.
This is SCC online only, sir.
Page 8, paragraph 8 kholo. Oh, paragraph 8 match করছে না? আরো আগে. Lordship kindly comes to yes, paragraph 9, one paragraph apart. That is the order of the High Court and the division bench.
Yes, notwithstanding.
Notwithstanding the orders passed by this court.
Yes.
The High Court took upon itself to decide the issues raised on merit by allowing the respondents to make deferred payment in 20 installments. A relief which was more than the one prayed for. The installments were modified by the division bench in the piece number so and so to 12 months as originally prayed for by the respondents, while declining to interfere with the decision of the learned single judge on merit. Impugning the aforesaid orders, the learned bank, the lender bank has filed the present appeals. Now kindly see what was the Supreme Court's order. Last paragraph, man. Supreme Court did not interfere with the order. Did not interfere with the order. The last page. Paragraph at the very end. After laying down the law, the last paragraph, last two paragraphs, while doing so, we are conscious of the fact the powers conferred are rather wide, but are required to exercise only in extraordinary circumstances and matters pertaining to proceeding. Reiterating the concerns expressed in the present appeal are disposed of. Orders are not interfered with. The High Court's order remains, the division bench order remains, the bank's SLP is not allowed. So the High Court's interference with the in aid of inequitable interference.
No, with regard to the maintainability of the writ petition on the basis of these guidelines, and then this my judgment in just 2 days also I had delivered that it is maintained.
Again 2 days back, another judgment. That's the problem. I can never keep up to date.
Not with regard
Every
to
day we have to
These
sit here.
matters are too frequent, my lord.
We have to sit every day and watch.
So Lordship has held that
No, not this. With regard to the bank and the tender matter, so they have taken the plea, but in tender matter in accordance with the guidelines issued by the RBI. So this court has held that once the violation of the guidelines, and that is a statutory violation. If it is statutory violation, writ petition is maintained.
yes. Now here, my lord, now kindly see that the pronates judgment cited by them. Kindly see pronates. This is the statutory violation is glaring. Wow. Now, should kindly comes to paragraph 13. Lordship sees paragraph 10. Paragraph 10. What was being considered there? Paragraph 10, page 297.
Notification.
As stated earlier, the whole controversy in the instant appeal sent to the notification of 29th May 2015.
That's what I'm telling. So if you are telling that violation of the statutory guidelines,
Yes.
then
But the mine is not 15. This is not a guideline applicable.
that's a 15. You're 16.
Now I'm 16. That is in paragraph
In
13.
the 16th, the other
Lordship see paragraph 13, page 299. In the master direction of 2017, both have been reconciled. Lordship kindly sees the placetum. Lordship kindly sees page 299, placetum C.
classification of providing the advances issued the bank, they are being
Lordship just below placetum C.
The revival and rehabilitation.
Yes, of MSMEs having loan limits up to 25 crores
which
would be undertaken under the framework. Banks were required to put in place their own board approved policy to operationalize the framework. Now, revised framework supersedes our earlier.
Not later than 30th June.
Yes, so this is the 17th March, just before the 17th March 2016 framework. 2016 framework, my lord.
That is
An affidavit that is up to 25. That is done away with. So, but there, as and when I approach, whatever stage, Lordship, I have annexed that the 14 the 2000. Now, Lordship, that is part of the affidavit. The petition ache. Petition petition.
No, it is there.
Yes. So, my lord, Lordship, the 16.
That is page 110.
16. Yes.
2016.
Yes.
Page 110 is there.
Yes, but there, my lord, I am on paragraph
Yes,
3.4.
Page 110, then you come to
4.1.
4.1, yes.
So that is, they can't say I will not. Firstly, there is the obligation of the 4.1.
The court corrective action plan, then after they have given the corrective, what are the corrective action
No,
plans? Then you come to the action plan by the committee, then rectification.
Yes.
These are the stages which
Yes,
has been.
and 4.1 is either on my application at any stage, or number two is number two is for 4.1, or whenever the bank finds that the account has become SMA 2. SMA 2.
SMA 2.
So here, when the SMA 2 happened, there is a date given, the bank took no step whatsoever. SMA, Lordship kindly also sees paragraph 2.1, page 112. Just below the table, SMA 0, SMA 1, SMA 2, the last sentence of paragraph 2.1. Forwarding the account to the committee for CAP
Correct.
will be mandatory in case of accounts reported as SMA 2. So that they did not. And when I applied also, Lordship, 20, of course, after the, say, 13.4 notice was given, when I applied in 2024, twice, that you take the necessary MSME measures, they sat silent. And Lordship, Pronet's case, which was cited by them, was a case where Lordship sees the last paragraph, the bank had already taken possession, 13.4 was already over. Lordship, that is recorded in the Pronet's judgment, paragraph 23. That was already last page of that judgment. Lordship kindly sees that the distinction Pronet's. Firstly, the 2015 notification, and paragraph 23 is
already been concluded.
And the possession of the respective parties has already been taken over. We not. So that was an irreversible position. So but here we are at the stage where it is still reversible. Like so, but whether Lordship, I leave it to my Lord, where the division bench in the doors, he had placed the judgment of Justice Roy, where Lordship put a condition. But division bench I had placed. Division bench said without taking into consideration Justice Aniruddha's judgment, the bank will consider in the section 37, in section 17. Now I can go. Lordship feels that this is not the right place. Either Lordship has, as a Lordship has done in the Bizitsa case, let them consider and dispose it off. They have not yet taken possession. 13.4 not concluded, or I can approach the DRT and to ask for similar relief, or whichever way. But also Lordship kindly keep visits the judgment, and Lordship just one judgment. Lordship, they're talking so much about 13.4. Lordship, the judgment of our division bench in SRC Steel. In SRC Steel, our division bench judgment in a suit, in a post 13.4 case. This is under the 12th framework, 2012 framework on similar lines. Lordship kindly sees the first page, last paragraph. Aggrieved by this concession, the first quote, second last paragraph, the learned judge, after referring to the provisions of the scheme, was of the opinion further opportunity must be given to the debtor plaintiff, providing right of appeal before all other opportunities for rehabilitation are closed. There was right of appeal under the 12th framework. Closed. Therefore, learned judge directed the plaintiff to file an appeal as indicated in the scheme. And the same was directed to be filed within a particular time, further directed the apparent bank to dispose of the same. Aggrieved by this concession, Lordship, next page, aggrieved by this concession, Lordship, next page, actually this is second page, by this concession extended to the creditor unit, the appellant bank has approached this court mainly contended that civil court ought not to have entertained a suit in light of section 34 of Sarfesi, where the jurisdiction of civil courts is expressly barred. 34 of the Sarfesi Act reads as under 34 is quoted, and thereafter Lordship kindly comes to the next page, 34 after setting out, next page, last paragraph of the judgment. In that view of the matter, we are of the opinion reading subclause B of clause 7 of the scheme, that is the MSME scheme 2012 and 34. 34 has no application to the list raised before the learned single judge. In that view of the matter, we are of the opinion learned judge has taken care
of the interest of both the parties wherein the appellant bank is at liberty to consider the appeal and dispose. That's what my lord has observed. It is needless to say that clause 7B of the scheme, as is a mandate on the authority concerned, which is introduced only to see no arbitrariness is exercised on the part of the officials of the bank in the absence of a proper exercise of compliance of the procedure contemplated in terms of guidelines for rehabilitation. The debtor unit may even be suffocated with the result of closing down the unit by arbitrary order. Therefore, unless the procedure contemplated under the guidelines for rehabilitation is complied with in accordance with the guidelines, subsequent actions or consequences of such non-compliance may lead to disaster. This is what MSAB guidelines are meant for. And here twice we approached them with the request that you consider me. That is 2024, twice. And again thereafter, Lordship, may not be in the perfect language that you, this paragraph of the scheme, etc. But the Lordship, this 2-1, তুমি খালি একটা বলবে না কোথায় গেল ওটা এটা না এটা আমার যেখানে বললাম যে 2024 গুলো দাও 24টা that is the one that yes 2024 that is once paragraph.
Which one?
Yes. Paragraph page 172, volume 2. Not the one. Post 13.4 data. Yes. Ours, that is the one which I that is page paragraph 18-19. Then again page 209 on 4th December 2024.
Achha, regarding your request.
My request.
That yes.
Of course. So those will also all have something. Let them consider and reject if as per the guideline. I am.
Yes.
Only one letter, I forgot to show your lordship, is at page 191. There, 191. There's letter. It starts with the proposal for settlement of the dues. That means they're admitting the date of NPA, they're admitting the dues.
I admit my dues, of course.
So, the question of giving them under the scheme of MSME does not arise here.
That's for settlement.
Because if he's accepting the dues, and if he's accepting the date of the NPA, at a belated stage, can he?
I'm saying SMA is.
Yes, their contention is that yes, NPA is there and dues are there. But what the benefit he will get under the scheme, the committee has to consider whether he will get the. First, you have to consider.
At what stage?
That is
for your lordship to decide.
That is
after everything goes now, he will just jump after DRT, NCL, everything.
Stage is the main problem here.
That is the main.
Not only the difference in
question of consideration is not the problem. Question is from which stage,
lordship,
and whether the request made by the petitioner can be considered as a request or what.
That your lordship judgment is also clear and the Supreme Court judgment is also clear.
Let's see. Let us see.
Very good.
Okay, thank you.
Yes.
Hearing concluded, CAV. Yes.
Number 5.
Pay for minus short password late by the Mr. Vishnu voice charge.
Not password?
No.
Okay, 435. Next.
I'm for the respondent number 1.
Who is for the petitioner?
Mr. Chayan Gupta was appearing on the last occasion. Mr. Chayan Gupta was appearing on the last occasion.
Chayan Gupta.
Lordship, I'm appearing on behalf of the petitioner. My senior is just on his way. Could kindly.
Senior?
My senior is just on his way. If you could kindly just pay for a part.
Yes, this, the communication is final order or the notice?
My lord, it is a recommendation, my lord, but I'll take up, my lord, a preliminary objection as to the, my lord, jurisdiction in this case, because no part of the cause of action, my lord, has arisen within the jurisdiction of this honorable High Court. Only thing that has been said is that they have received the purchase order, and that is also from the respondent number 3, who is a subcontractor. And as far as the respondent number 1 is concerned, my lord, we are no way, my lord, covered by that communication. And in that case,
Lordship, kindly take it up on Monday, my lord.
Lordship, I'll try to, my lord, if Lordship grants me, I'll file a short report. Any other day?
And learned counsel for the.
Lord, respondent number 1.
Number?
1.
Respondent number 1. Yes.
Respondent number 2, RVL.
Respondent number 2, press for time to file short reply. Short report.
My lord, report.
Let the report be filed by
My lord, then I need some time, Lordship, fortnight.
within 2 weeks. You will file. Respondents are directed to file their report within 2 weeks after serving the copy to learned counsel for the petitioner. The petitioner is liberty to take exception to the report within a week thereafter. List the matter. It a date here in September.
And the point of maintainability may be kept open.
The respondent number 1 has raised the point of minority, the same is kept open.
Grateful.
345 corridor.
Lord, I appear for the petitioner.
I am for the respondent, my lord. In terms of your lordship's earlier direction, my lord, I may be allowed to file my report in the form of affidavit. Copy, sir, পেয়েছো?
No.
Copy দাওনি? এটা দিয়ে দাও না কেন? Not, I have a point of maintainability.
Whether what amount is pending?
Yes, my lord. If your lordship kindly takes up the application once.
Open. Yes.
Kindly.
Read. It's not one thing, but kindly see the report. And Lord will kindly see para 8.
And before that, my kindly take seize the cost type.
Yes.
But respondent number 1 is Axis Bank Limited, which is a private bank. Authorized officer of Axis Bank Limited, again private. Branch manager of Axis Bank Limited. There is no state in the REIT. How this REIT is maintainable?
My Supreme Court has now said in Muthoot Finance that writ petition is maintainable against private bank.
I am ready with that judge.
How?
Kindly come.
What you have prayed for?
But I'll tell you, Lordship, what has happened. My lord, we avail credit facilities to the extent of 36.40 lakh. My lord, my contention is that initially it was there with Citibank, thereafter it got transferred to the respondent number 1. My lord, the relevant document is where, my lord, on the basis whereof, my lordship will kindly see is, my lord, page 19. Well, it was a loan, credit facilities given, immovable property was mortgage, original documents and lying with them. But my small submission is that I have paid the dues. Now, if the bank says that something is due and payable, the bank can indicate what is the quantum which is due and payable. Because they cannot hold on to the original title deeds for an indefinite period. They are holding on to the title deeds only because there is some money is due and payable. If I pay off the dues, they will not hold on to the title deeds. If the bank can indicate how much is due and payable, I can take instruction, I'll pay that amount, then the matter will be over. But so far as the report that has now been filed, Lordship sees, they have given two figures, page 3, paragraph 8. Because Lordship's order was that they should file a report indicating how much is due and payable. Paragraph 8, they say that 5.31 lakhs is overdue. In addition thereto, future installments aggregating to 6.65 is due. This is why I take it that approximately 12 to 13 lakhs is due. Now, kindly see what they have done. I can show from the records of the writ petition that all the installments, particulars of which are mentioned in the sanction letter, all of them have been paid. Kindly see page 16 is the sanction letter.
Yes.
Page 16, this is the sanction letter of 1st of February 2011. Kindly turns the page, Page 17, EMI payment period is 175 months and the quantum of each installments is 44,719. So I have to pay this amount of 44,719 in 175 times, 175 installments. Kindly comes to page 28. This is the bank statement of the respondent number 1. This is the bank statement, and kindly see the first page, page 28, loan details. Kindly see amount financed on the right hand side column at page 28.
Yes.
Kindly see the right hand column, amount financed 36.40 lakhs. Kindly see amount disbursed, same amount. Now kindly comes towards the bottom. Kindly see the last two entries on the right hand column of the box on the right hand side. Principal paid is 26.40 lakhs. Interest paid is 53.38 lakhs. Now, this total of these two will be over 80 lakhs. But my instructions are from pages 28 to 48, I have disclosed the bank statement. The total quantum that I have paid is 80.22 lakhs. 8 principal plus interest. Kindly see page, kindly see these are the bank statements. Kindly see from page 29 onwards. But each and every installment has been paid. Even if we calculate 44,000 and odd with 175, the required summation comes to 78.25 lakhs. I have paid over and above that. The calculation that I have disclosed on the basis of the bank statements, these two figures, 26.40 and 53.38, the summation will come to 80 lakhs on odd.
No, but the principal is 2640.
Principal is 12
and the due paid and the principal sanction is a 3640.
Yes, but
if you come to the page 28,
yes,
the finance, the total is 36 lakhs 40.
Yes, this is the reason is kindly comes to page 29.
Yes.
Kindly see, towards the middle of the page, there is a date which is mentioned 1st of February 2024. 1, 2, 3, 4, 5, 6.
Yes.
The 7th or 8th entry.
Correct.
Kindly see 1st February 2024. Kindly see the middle column. Due for installment 44,719.
Due for installment.
Due for installment 719. There are now kindly see there kindly comes to few rows towards the bottom of the same chart. Due for installment number 2, due for installment number 4, then 5, then 6. Now on the right hand column, they have given that this 44,719 has not been paid so far as installment number 2, 3, 4 and 5. Now kindly see, this was not credited or deducted from my bank account. What I have done is I went to the bank and I have paid the deposited then amount. Kindly see page 33.
So you have considered this document after considering how the 5 lakhs and 6 lakhs is coming?
But 13 lakhs they are saying.
How it is coming? In the report, if you come to the report, it is mentioned.
This was granted by Citibank. Thereafter, Citibank merged with, so far certain transaction is concerned, that merged with Axis Bank.
Correct.
Now, my lord, when the Axis Bank took over the loan, at that point of time, there were 46 EMIs to be paid.
When you have taken the charge from the
2024 month.
which date?
First of January 2024.
1st of January
And
2020.
minor will find the statement from 1st of January, left hand side minor of my statement, page 5. But in the middle portion, left hand side, rate of interest. But this credit facility was with a floating rate of interest.
No, so this is when it has come to you, then you have made a new account.
Yes,
correct. So
my
you come to the total overdue 5,31,205. That was which date?
Yes. But whatever they are claiming, I will find whatever they have paid. Now kindly see installment paid 79,79,000. It has been disclosed.
Yes, 7 lakh, 79 lakh, 71
Out
lakh.
of which, my lord, principal paid 26,40,000.
Correct.
Then, my lord, interest was paid 53,38,000.
Correct.
Now, my lord, when Axis Bank took over the loan, kindly comes to the left hand side, my lord, of the same page. I will find rate of ROI, rate of interest, middle portion, my lord. Left hand side, middle portion.
Rate of interest.
Rate of interest.
Where from you are getting?
My lord, middle portion.
ROI. Yes. 13.35%.
Then, my lord, disbursal date was of February 2011. That was with Citibank. Then, my lord, interest rate type floating. Then, my lord, at that point of time, there was a due of 46 installments. Then, my lord, kindly comes to the transaction date.
No, that's see. Total. What is the total installment? What is the total? 175. So on that day, 46 installment was
well due.
Correct. And on that day, the 79 lakhs, 79,000 paid.
They have paid.
Correct. Correct. So 26 lakhs the principal amount.
Yes.
So 26 lakhs the principal amount. Then now the 10 lakh was the only due.
Yes. And not as on date, there are certain interest.
No, just you calculate. So as on 1st April to 1st January 2024, so if he has paid the 26 lakhs 40,400 and the amount was the 36 lakhs 40,000, 36 lakhs 40,000 and 26 lakhs 4,000, 26 lakhs 40,000 he has paid. So 10 lakh remains. Correct. So 10 lakhs. So when he has paid the installment of the 10 lakhs.
Yes. Now kindly come. Transaction date was.
Correct.
Now kindly see the first transaction date of 1st of January 2024.
Okay, come tomorrow.
And my lord, kindly keep in mind that I have a point of view.
Yes, that I keeping. Non-counsel for the respective parties are argued the matter at length. Non-counsel for the bank has filed a report after serving the copy to non-counsel for the petition.
And I have copy.
Both the parties have argued the matter. Mr. Counsel for the respondent bank raised the point of mental kept open. Let the matter remain.
Yeah, take it.
Wait for a moment.
Original.
Yesterday for getting it fixed.
Who told you 445? Who told you? Who told you 435? Come tomorrow to fix.
Just a humble.
Kunal, I put the
The map check. Maintain its list of some a little bit.
sorry.
A very small issue, you're not able to fix it, so we are going to watch it. Okay. Your Lordship, the petitioner has also come up.
the petitioner understands, your lordship, it's a very small issue.
That's why I called 435. 2 minutes time, you go and have a tea and all. Come tomorrow, come tomorrow. See the gathering here. Yes, 133 is appearing.
My lord, I am for the petitioner, my lord. My lord, in this matter, my lord, 133 is the, my lord, online application, and my lord, there is a requirement of, my lord, time bound manner.
Where is the appeal? Where is the appeal?
My lord, page number 133. My lord, the petitioner.
130? How many petitioners?
Only one, my lord.
Yes.
My lord, petitioner selected in the post of assistant commercial.
Where is the paper? Selection page.
Page 45, my lord.
Page 45.
Yes, your lordship. And relevant page is page 46, my lord. His serial number 27.
None counsel for the petition submitted. The petition has been selected in Group C post. But due to the deletion of the name in the state of West Bengal.
Yes, my lord.
Post in?
My lord, in the assistant commercial tax officer in West Bengal, revenue department, finance department.
Revenue department, but due to the deletion of his name from the voter list, the petition is not in a position to join his duty. His or her?
His, my lord.
His duty. She submitted after the deletion of the name of the petition from the voter list, the petition has preferred an appeal before the appellate tribunal and the same is pending before the appellate tribunal. She prays for a direction upon the appellate tribunal for disposal of the appeal as early as possible so as to enable the petitioner to join his duty. Heard the land counsel for the petitioner peruse the record. This court find that the petitioner has filed an appeal before the tribunal on 7th of April 2026 and the same is still pending. Accordingly, appellate tribunal is requested to consider the appeal preferred by the petitioner dated 7th April 2026 as early as possible, preferably within a period of 2 weeks from the date of receipt.
May I submit the affidavit of
Yes, next.
Yes, madam. Yes, madam, 70, my lord.
This was yes, 35.
35.
Then
in item number 136, Your Lordship, some urgency involved in this matter, Your Lordship.
Urgency.
The urgency involved is that, Your Lordship, the petitioners is the medical students who has applied for the Your Lordship passport to go abroad the future of study, Your Lordship. His passport is likely to be that was the indication that was given the passport as a in fact that the his Your Lordship.
Where is name?
That is the Your Lordship. Yesterday, one notice was issued, Your Lordship, on earlier occasions, indicating the fact that
Where you want to go to have admission?
For further study, Your Lordship.
Where?
Your Lordship, since Your Lordship, the UK, he have preferably, Your Lordship.
Got the order, appointment order?
No, Your Lordship, I not.
Recommendation order?
Since Your Lordship, I have applied for the passports. The passport authority indicating the fact, Your Lordship, that
it is submitted the petitioner intend to get an admission in the MBBS course at abroad, but due to the deletion of the name of the petitioner from the voter list, the passport authorities are not allowing the what you filed the application for a passport authority?
yes, Your Lordship, to obtain the passport, Your Lordship.
It's not
fresh.
Not granting the passport. Accordingly, submit that he has preferred an appeal before the appellate tribunal and wait for a direction upon the appellate tribunal for disposal of the appeal as early as possible. Cancel the submission made by the counsel for the request the appellate tribunal to dispose of the appeal preferred by the petitioner as early as possible, preferably within 2 weeks from the date of receipt. Next. Next. 37.
137 or page 41.
Disposed of.
138. No, 130. I am for the petitioner, madam. Petitioner has the passport also, madam. He cannot go outside the India because of this SI, madam.
Disposed of. Next.
Your Lordship, my appeal is in page number 52.
Disposed of.
140.
Your Lordship, page number 103.
Disposed of. 141.
Your Lordship, page number 105.
Disposed of.
142.
Page number 96.
Disposed of. 143.
Page number 63, appeal is there.
Disposed of. 144.
Page number 57.
Disposed of.
Page number 38.
Disposed of.
146.
Disposed of.
47.
Disposed of.
148.
Infractures disposed of.
Disposed of. Infractures, huh? Now 149.
149. 149. 150. 60.
Disposed of.
51. 60.
Disposed of.
152.
Your Lordship, page 52.
Disposed of.
153.
Disposed of.
154.
Disposed of.
Praying for correct the cost item.
What cost item? What is the correction?
Leave may be granted to correct the cost title, so you accordingly order.
54, no? Then 154, then consider for the petitioner submitted. Name, cost title means name of the petitioner. Oh, consider for the petitioner, place first. Submits that the name of the petition is wrongly typed in the cost title of the writ petition and press for due to correct the name of the petition in the cost title. Leave is granted to the petitioner to correct the name of the petitioner in the cost title in the course of the day. Baki ye sab ho gaya. Disposed of next. Next.
Again, 1, 5,
Disposed of. Disposed of.
7,
6, my lord.
This one.
Others.
366.
Fortune.
How many petitioners? 366. How is it?
22.
So for the first, if my lord,
Only one petitioner,
first petitioner, if my lord,
I will not allow anybody. You go and file one. Dismissed. It is found that the petitioner has filed the petition along with how many petitioners?
22 petitioners.
Along with 22 petitioners. Accordingly, petition is dismissed. However, the dismissal of the petition will not prevent the petitioners to take appropriate step for filing separate applications. Yes.
158.
Disposed of.
159.
Disposed of.
160.
Your Lordship, I am for the petitioner, 29, Your Lordship.
Disposed of.
161. 162.
Disposed of.
Candidate madam and counseling date 13 madam. Petitioner is.
What counseling?
Madam, late counseling madam.
Record an order. The counsel for the petitioner submitted the petitioners the counseling of what? Where is the document? Need counseling is the need counseling of the petitioner is fixed on
13th of August.
on 13th of August 2026. But due to the deletion of the name of the petition from the voter list, the authority is not accepting the request of the petition and declared for explicit disposal of the pending before the appellate authority. Made by the council for the petition, the appellate tribunal is directly requested to expedite the appeal and to dispose of the same as early as possible, preferably within a period of 1 week from the date of this. Next.
Page 37. Page 37, your lordship.
So the
For the petitioner, two petitioners.
Number 165.
First petitioner, appeal, page number 44, second, page number.
disposed of.
My lord, 165, renewal of the passport is kept on hold, 11th August file will be closed, my lord.
Yes.
Renewal of the passport is kept on hold. If it could be.
11th August, what will happen?
My lord, kindly passes for non-work. Pass any adverse order. But appeal at page 120. Yes. Till the disposal of the appeal.
The petitioner submits that the petitioner has applied for the passport and the authorities have given a notice for appointment for issuance of the passport on 11th August 2026. The petitioner submit that due to the deletion of the name of the petitioner from the voter list, it is not possible for the petitioner to produce the document before the passport authority. And if the petitioner will not produce the document to the passport authority, the passport authority will close the application on 11th August 2020. He submitted the petition already prepared an appeal before the appellate tribunal and the same is pending. He pressed for a direction upon the appellate authority for disposal of the appeal as early as possible, and till the disposal of the appeal by the appellate authority, the passport authority may be directed not to dispose of the application filed by the petitioner for grant of passport. Consider the submission made by the counsel for the petitioner. The appellate authority is directed to consider the appeal filed by the petitioner as early as possible, preferably within a period of 3 weeks from the date of receipt of this order. The passport authority is directed not to close the application filed by the petitioner for grant of passport till the decision is taken by the appellate authority. Next.
Lord, 166, two petitioners, my lord, may I withdraw with liberty to file afresh?
As per the liberty granted by the petitioner, WPA number 18004 of 2026 is dismissed as withdrawn with the liberty to file afresh.
I'm grateful.
There are 11 petitioners, my lord. I was seeking liberty to withdraw with liberty.
Petitioner, as per the liberty granted by the petitioner, WPA number 18765 2026 dismissed as withdrawn, liberty to file afresh.
Appeal is on page 22, your lordship.
Dispose of.
Appeal is on page 22, your lordship.
Dispose of.
Your lordship, appeal is on page number 30.
Dispose of.
Lordship, page number 28.
Dispose of.
Page number 31.
Dispose of.
173, my lord. My lord, this is a single petitioner, my lord, at page 24.
Disposed of.
My lord, 174, my lord, father and son come before your
You
lord.
are having all urgency.
My lord,
Disposed
the
of.
son is the, my lord, need aspirant. My lord, kindly peruse page number 44. My lord, the petitioner is the OBC candidate. Non-familiar certificate is not given due to, my lord, deletion of the SIR, my lord.
174. Counsel for the petitioner submitted. The petitioner is the NEET aspirant candidate, but due to the deletion of the name of the petitioner from the voter list, the authority is not considering the request of the petitioner for appointment for admission in the medical college. She submitted the petition already prepared an appeal before the appellate authority and prayed for a direction upon the appellate tribunal for disposal of the appeal as early as possible. Consider the submission made by the counsel for the petitioner. The appellate tribunal is requested to consider the application appeal filed by the petitioner as early as possible, preferably within a period of 3 weeks from the date of 2 weeks. 2 weeks.
13 August.
2 weeks. 1 week or क्या? Yes.
I am for the petition, your lordship. The appeal is at page number 19.
Disposed of.
Page number 22, your lordship.
Disposed of.
177, the petitioner is a NEET qualified student. There are 3 petitioners, parents and their son. The parent's name is not in the SIL list, so document verification will be starting on 14th.
What?
Document verification will be for the NEET.
Verification of what?
For the NEET counseling. Counseling process will be started on.
Counsel for the petition number.
Petitioner number one is the student, 2 and 3 are there is
Whose document is going to verify?
Petition number 1.
Our entire family has to be done because until unless they are tagged with their parents.
Counsel for the petition submit that the petitioner number.
One is the
aspirant for getting admission in the medical college, but due to the deletion of the name of the total family of the petitioner from the voter list, the authorities are not considering the name of the petitioner. Counsel for the petition submitted the petition for preferred an appeal before the appellate tribunal and the same is pending before the appellate tribunal. She prays for a direction upon the appellate tribunal for disposal of the appeal as early as possible. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to consider and dispose of the appeal filed by the within a period of 1 week for the date.
Tomorrow also 4:30.
Yes.
Tomorrow 4:30. It will be much more calmer. People will be less there.
Okay.
Your lordship kindly get up on time.
Why my officers have to type?
Your lordship have adverse effect on your health. Get up on time. It is difficult. Your lordship is doing public service, but still. So do it.
Appearing for the first time,
Noted.
Lordship allows.
Deeply
Deeply affected.
Let us see the consequences.